Well, good morning, everybody, and welcome to the second hearing of this committee's inquiry into fertility support and assisted reproductive treatment. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the land on which we're meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people who are joining us here today. My name is Sarah Mitchell and I'm the chair of the committee. Can I ask everybody in the room to please turn their mobile phones to silent? Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing, so I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants, and I encourage committee members and witnesses to be mindful of these procedures. Welcome to our first panel of witnesses today, and thank you for making the time to give evidence, and also just to acknowledge your support crews who are in the audience and your children. It's lovely to have you all here, and thank you for being here. Can I ask each witness, and I'll start on my left with you, Ms McCloy, to state your name, your position title, if there is an applicable one, and also swear either an oath or affirmation. So, Ms McCloy.
Sure. My name's Jennifer McCloy. I'm a surrogate and a fertility advocate, and my affirmation: I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mrs Coops?
Hi, I'm Lucy Coops and I am an intended parent, and my affirmation is I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr Gilchrist?
G'day, I'm Camden Gilchrist. I'm a dad through surrogacy. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you very much. And Mr Hadlenby?
Hi, I'm Darcian. I am a dad through surrogacy. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Would any or all of you like to make an opening statement? We might go down the same order again. So, Ms McCloy?
Sure. Well, firstly, thank you to you, Sarah, and the committee for having me today and for the time you and your colleagues have spent on this important topic. I was lucky enough to be a surrogate for two close friends living in Orange, New South Wales, in 2022. Our experience, so my husband and our two friends, Edwina and Charlie, was a beautiful one, which resulted in the birth of a beautiful baby boy, Angus, and the creation of a loving, happy family. However, this was primarily driven by our own advocacy to assemble the right team around us, and during the process I noted many ways that it could have been better supported by considered, thoughtful regulation. We had a truly beautiful experience as we've been friends for over 30 years, and I've just heard that that's a similar experience for Lucy next to me. And medically everything went smoothly, but really our situation is just not reflective of the thousands of couples that face fertility challenges every year. Over the last 3.5 years, I've spoken to hundreds of women, men and families who have been through fertility challenges and loved ones who have been there to support them. There is an overwhelming sentiment across the board that the path to parenthood could and should be far more supported by the New South Wales government. I sound like a politician with a catchphrase, I say this so often, but parenthood should be an option for every Australian, no matter what that looks like. Dr. Con yesterday said it far more eloquently. She quoted the World Health Organization, who said, all individuals and couples have the fundamental human right to decide freely and responsibly the number, timing and spacing of their children. My submission and my lived experience is specific to surrogacy, so that is what I'm here to speak on today. Throughout the submissions and the evidence given yesterday, there are two particular items that have emerged as the focus with relation to surrogacy. Firstly, the rights of the child, surrogate and intended parents in surrogacy arrangements, and secondly, the alleged exploitation of women. If we can address these two topics as paramount to the equation, I truly believe what will emerge is a clear path forward. As you will have seen in my submission, I've put forward 6 recommendations based on both my lived experience and hundreds of conversations. In the interest of time, in this statement, I'll just quickly highlight 2 of them that were echoed by a number of the witnesses yesterday, but I of course look forward to discussion on any of them. Firstly, the pre-birth parentage order. When I presented this concept to the Attorney General of New South Wales, Michael Daly, I was told this was low-hanging fruit and something that wouldn't be too onerous to change. I said, "Thank you, Michael, I agree." Secondly, compensated surrogacy. This is not about surrogates getting paid. It's about increasing access for Australians wanting to grow their families and providing protections to everyone involved in the process, including the child. There are multiple examples of this around the world, which is a real positive, and we can learn from years of these frameworks in practice. And rather than importing the risks seen elsewhere, Australia can explicitly legislate what can and cannot be included in surrogacy contracts, something many overseas jurisdictions have never done. The experience in jurisdictions like the US shows what happens in the absence of consistent national regulation. Put simply, an unregulated market creates and fosters exploitation. This is also where a certification or accreditation framework across the fertility pathway would play a role, ensuring that providers adhere not just to legal minimums, but to best practice ethical standards. I'll wrap up by saying, the government has a responsibility to do something. This is a topic that needs to be treated with care and consideration, but it also needs not to be the victim of inertia. I truly believe that with all the intelligence in this room, not including myself in that, we have an unprecedented opportunity here in New South Wales to lead the rest of Australia, to help Australians wanting to create and grow their families.
Thank you. Mrs. Coops?
Hi, and thank you for having me today. Over the past few years, my husband and I have been through years of infertility, multiple miscarriages, repeated surgeries, life-threatening complications, which resulted in my inability to carry a child. Many of these outcomes could have been avoided with better care, better information, and better systems. We, unlike most, were lucky to have a friend willing to be our surrogate, and earlier this year, we welcomed our baby into the world. Without our friend, it would have been the end of the road for us becoming parents, something that I had dreamt of my whole life. There is a long way to go for fair treatment, but there are a few key areas that need urgent change. First, D&Cs, as a result of a miscarriage, must come with proper informed consent and should only be performed by qualified gynecologists. Up to 40% of D&Cs performed as a result of a miscarriage results in Asherman syndrome, which is what happened to me. During such an emotional and stressful time, I was not warned about the risks, and ultimately it affected my fertility. Second, surrogacy needs to be more accessible. Right now, it depends on who you know or who you're willing to find and trust. A registered database of potential surrogates would give families a fair chance and reduce informal arrangements that are currently taking place. Third, legal protections and counselling requirements during surrogacy needs to be fixed. Families are spending thousands on these services that are more tick box, agreements that are not enforceable, and parentage orders that can take months, leaving both the surrogate and intended parents exposed. Admissible legal contracts should be required, and authentic counselling sessions should be conducted for the protection of both parties. Fourth, people going through surrogacy don't get equal access to Medicare. The same IVF treatment is covered if you can carry a child or require a donor egg, but not if you need a surrogate. This unfairly excludes people who physically cannot carry a pregnancy, and surrogacy should be recognised for rebates. On the topic of Medicare, there is also a serious gap where babies cannot be properly covered by Medicare or clearly treated in the system while waiting for the legal parentage order. Whether a child can access care becomes inconsistent and unclear. Intended parents should be able to access Medicare for their baby to receive medical treatment. Finally, hospitals are not equipped to support surrogacy. Intended parents are often treated as visitors, not parents, with no clear policies or training in place. We experience this firsthand with a lack of understanding and care in the ward. These are not isolated issues. They're gaps in the system. With right reforms, we can create a system that is safer, fairer, and actually supports families.
Thank you. Mr. Gilchrist?
G'day. Chair, committee members, thank you for this opportunity. I'm here today with my husband Phil and our sons Augustus and Ignatius at the back of the room, or as we like to call them, Dino and Nacho. To them we are Da and Baba, their dads that wrestle them into outfits in the morning, fetch snacks and command and read them stories at night. They were born almost 2 years ago in Argentina. Legally I appear on Nacho's birth certificate and Phil appears on Dino's. The second name on each certificate is an incredible woman on the other side of the world who loves our boys, but has no desire to hold legal parentage. So the question is, how did we get here? We didn't end up overseas on a whim. When Phil and I met 15 years ago, we knew we wanted a family. We explored options and settled on surrogacy, but we quickly realised how hard it was to find a surrogate in Australia. We almost ended up in Canada, but cancelled when 2 friends generously offered to be our egg donor and surrogate. Together, we jumped through the hoops. Counselling, legals, medical screening and endless forms. We were living in Victoria at the time, but we moved back to New South Wales for a new job and had to do the whole process all over again. Then COVID happened, and so we pushed through, made embryos between lockdowns, but unfortunately our transfers failed. Then our fertility clinic admitted they had wrongly destroyed our remaining embryos. So after 4 years, tens of thousands of dollars, and immense emotional strain, Phil and I fell into a period of deep depression. When we eventually picked ourselves up again, we began researching options for our family. This led us to Argentina. The city of Buenos Aires at the time had a long-standing legal framework that provided a clear pathway to full legal parentage for both of us. That is, that we would both receive birth certificates with us listed as parents from the outset. So over the course of the next 3 years, we travelled to Buenos Aires 3 times. We built lifelong friendships with our surrogates and their families. And in mid-2024, in what would be one of the best days in our lives, our boys were born, just a week apart. But then, Buenos Aires surrogacy protocols changed overnight. After a period of 2 months, we were issued with a birth certificate, but it wasn't the one that we'd all agreed to. However, this allowed us to complete our Australian citizenship paperwork, return home 4 months after our boys were born. From an everyday perspective, our birth certificates that we have work. But in an emergency situation, not being able to make a medical decision on behalf of my son terrifies me. One of our boys had a seizure last year in the emergency department. I had to pause at the administration desk to mentally check that I was right, the right father and able to provide the medical direction that doctors required. We've been advised that the pathway for a parentage order to fix this may be almost impossible to navigate as it stands. Parents who have even attempted to apply also risk being prosecuted. This needs to change. I think regardless of your views on surrogacy, our children are here. They deserve to have the same legal protections as any other child in New South Wales. And more broadly, there's clearly a lot of room to move, or a lot of room to fix the system that we have in New South Wales. We wanted to build our family here, but the system was complex, overly commercial, and ultimately failed. Clearly others are making the same conclusion and going overseas. But despite the small setbacks, I want to finish on a positive note. Our story is actually a happy one. We have 2 beautiful sons at the back of this room and a family on the other side of the world. And despite what you may have heard through the hearings, not all stories are bad. There are thousands of us living out our lives and our dream to be parents and raising good kids in our community. I thank God every day for the incredible gifts these 2 women were able to provide us with, and I'm so proud of the family we're building together.
Thank you.
Thank you for inviting me today. I'm joined in the room by my husband, our beautiful 11-month-old son, who was born through altruistic surrogacy here in New South Wales. In 2020, we attended a Rainbow Families seminar to understand possible pathways through fostering, adoption, domestic and international surrogacy. Given how difficult it is to find a surrogate here in Australia, we made the decision to pursue altruistic surrogacy through Canada, where the process felt clear and regulated. After a few setbacks, we eventually matched with a semi-known egg donor, creating 20 embryos between us. Around the same time, a friend came to stay with us. For what was meant to be a short stay, turned out to last several weeks, or several months and years through COVID. And in March 2023, we're about to create our profile with the intention for a surrogate to one day choose us when our friend sat us down and said 4 simple words: "I want to help." We were taken by surprise. We cried. It was one of the most generous and selfless offers we could ever imagine. Here are some words from our friend who was also in the room. "I knew I wanted to help my friends, and after seeing how difficult every other step of their journey had been, I felt that this was one way I could make things a little easier. I wanted to give them the opportunity to experience the pregnancy of their child from start to finish, something that many intended parents don't get the chance to do. From my own experience, deciding to become a surrogate wasn't something I took lightly. I thought long and hard before even offering to do this. For 9 months, I did my own research to understand what was involved, what the process looked like, and whether I would be a good fit for surrogacy. I also spoke with my parents and family to get their thoughts and make sure I had their support. Surrogacy is built on trust, compassion, and generosity. With the right support in place, it allows more people to come together to create families, something I am forever grateful I had the opportunity to do." Now for the transfer, our friend travelled to Canada for 7 weeks. Returning home, she moved in with us so we could experience the pregnancy together. The day our son was born was overwhelming. It was the most beautiful way, but we still were not his legal parents. The birth certificate listed our friend as mother and sole parent. While our experience has been positive, the process itself is complex. Navigating pre-transfer counselling, post-birth parentage orders and birth registration requires significant time and persistence. Despite having a parentage order from December last year, as of today we are still waiting to receive a correct, reissued New South Wales birth certificate listing us both as parents. We're fortunate, our surrogate is in our lives, and not a lot of people have that support network. But many intended parents and surrogates are also not in that position, and these barriers can make surrogacy difficult to access or even out of reach, especially financially. We've already embarked on our sibling journey, working with 2 different Canadian organisations with the hope of one day expanding our family. At its heart, we believe surrogacy is about people coming together to help create a family. Our son is here because of that generosity, and we are deeply grateful. Thank you.
Thank you. Thank you all for sharing those personal experiences. It's really helpful to the committee to understand the different journeys that you've all been on in this space. So the committee's resolved that we're going to equally divide the time between sort of opposition, crossbench and government members. So we'll do a couple of rounds of questions from different members. And just flagging, we do have a couple of committee members who are appearing online, so they'll come up on the screen in front of you if they're asking questions. So I might kick off for us, if that's okay. And I'm going to ask, it's probably a hard question, but obviously there's a lot of different pathways that people take, and I think even the 4 of you have had slightly different journeys to parenthood or to being a surrogate in your case, Jen. But I just wondered if the committee could make one recommendation that you thought would be, you know, the top thing that we could do coming out of this, what would you suggest that be for us? And I'm happy whoever wants to jump in. I know that there's a lot of things you've all put forward, but what would be your number one that would have made it easier, better for you in your different circumstances?
The pre-birth parentage order would be my, probably I would say that because it feels like the lowest hanging fruit. It feels like something very simple, and with respect to the committee, it feels like something that's not too tough to change. And I would also say there was a lot of talk yesterday about education and awareness for clinicians and healthcare providers and everyone who's involved in the process. And I think that's echoed by what you guys have already said. But did you guys want to?
I would say the parentage order as well. I think that has an on-flow effect to access other things like Medicare. If the parentage order was in place from the beginning, then it would make it a lot easier and seamless to get things like Medicare on board for our children.
I echo the same comments. The parentage order process needs to change. It doesn't work clearly for domestic and international arrangements, even given the challenges around international surrogacy.
Yeah.
Parentage order, as an example, the flow-on effect, like everything from Medicare to both the surrogate and my husband trying to get parental leave. You know, they went to Services Australia and the education, the people had no idea. They asked if we wanted to put our child up for adoption. yeah, it's challenging.
I'd just echo, as a surrogate as well, that is quite a level of responsibility to carry. So I was Angus's, on the birth certificate, I was Angus's mother for the first 12 months of his life, and I can imagine for intended parents that's harrowing. But also as a surrogate, that's just, it's not okay.
See, I thought it was a tough question, but you all gave me the same answer. So maybe there's more alignment than I thought. And then I suppose this is probably more relevant to those, probably to Miss McCloy, Miss Coops. But in terms of the New South Wales health protocols, processes, when you're going through the experience of either being a surrogate or being an intended parent or intended parents. We had health here yesterday, and I was sort of keen to understand whether there was a set of guidelines or advice that goes to hospital staff and to clinicians about how to work with families who are choosing surrogacy. There didn't seem to be sort of a set framework that they provide advice, and I was wondering whether you had any views on your experiences in the hospital setting here in New South Wales and things that you would change in that space as well. And I'm happy for...
Sure. We had a fantastic social worker at the hospital, and she put in place quite a rigorous process so that everybody that was involved in the process knew exactly what to do, including things like what we wanted to be called. So if, there's some parents that like to be called intended parents. I think you mentioned yesterday commissioning parents. I was happy just with surrogate, but other surrogates like to be called different things, birth mother. Now that sounds really simple, but it's something that can easily be written into a guideline. So she put in place a process where everyone sat down together and agreed all these different things, and exactly even the coordination, the choreography of the birthing suite. I think that's a best practice example, but there certainly isn't something that is provided on a broader level, and I think that it's definitely something that could help. Another very simple, and I'm not sure if this was your experience, but in the hospital, Edwina and Charlie were boarders, not patients. Their suite had my name on it. They had to order food under my name. It said baby of Jennifer McCloy on the crib, and they're all just really minor things that, again, I don't think would be too onerous to change, and it would make a really big impact.
Yeah, I believe we had a very different experience to that. And yeah, our baby was born in February this year. We went through private but delivered in a public hospital. With that, we thought, we had been told that hospital was great at supporting surrogacy. They're one of the best in Sydney. Once we got there, within the birthing suite, the experience was great. They were very respectful of knowing everybody and who we all were and what the process would be once the baby was born. We comically actually missed the birth because she came out so fast. But they were amazing in terms of ensuring that my husband still was able to cut the cord, and we didn't know the gender, and so we did a bit of a gender reveal once we got there about 2 minutes after she was born, and then came straight onto my chest. I'd induced lactation. So that was all perfect. It then changed really quickly when we were moved up to the ward. We were given one room with 2 beds, which we had to fight for, one for our surrogate and one for myself. We were then, I was registered as a boarder. My husband was told he wasn't allowed to stay, but we fought that he would and really pushed, and so they ended up saying he could stay, but we had to provide our own mattress for him to sleep on, so luckily we had one in the car already. I was then not recognised as a patient, as I was a boarder. So the nurses came in, they did the obs check on our surrogate, they did the obs check on baby, but at no point were we taught how to put on a nappy, how to wrap. No one checked if she was latching properly. None of that was happened, and we were discharged within 24 hours to go home. We had we were told as soon as we left the hospital we weren't to come back for any checkups because we were being discharged and I wasn't the parent. We left without having the hearing test done, without even having the paediatrician final check over the baby. We were sort of just sent on our way as first-time parents, absolutely petrified.
That's universal, don't worry.
No idea what I was going to do with a baby who was 24 hours old walking out of a hospital, but I sought private care with a private midwife who actually pulled some strings and managed to get us care through a separate hospital closer to us. Their follow-up care seemed to be a lot more in-depth, but still it was quite a disappointing experience of what we thought should be a very exciting time and feel supported. We very much felt as though we were just there as an inconvenience.
I'm sorry to hear that. That sounds really horrific on top of everything else that you've been through as well. And what should be really joyful time, obviously, I'm sure was for you, but to have that extra stress wouldn't have been much fun. So we're now up to, I think if Dr. Con comes on the screen, it's her allocation of time. There she is. So I'll hand over to Dr. Con.
Thanks, Chair. Thanks so much to all of you for taking the time to share your experiences with us today. This is absolutely critical to the work that the committee's doing. Just, I suppose, following on from the Chair's question about some of the challenges that you encountered on your journey, I'm interested in understanding the financial cost. Some of you put some ballpark figures in your written submissions, but I'm interested for all four of you if you could break down the kinds of expenses that you encountered on your surrogacy journey and a ballpark figure of how much that was.
You guys start.
Look, for us, we kind of started down the Canadian surrogacy route, but we've kind of estimated we want 2 children, so it's probably about $130,000 per child, and that's in an altruistic model. That's IVF, fully overseas. Someone once gave us advice. We started with the spreadsheets, just stop. So we kind of did, but that's the kind of mental figure that we're working on.
I think for us, I mean, again, to that point, at some point, you do stop counting the dollars because, as we found, particularly even in Australia, like the idea that somehow overseas is commercial in Australia is perfectly smooth running is pretty delusional. We found clinics and the process here as commercial, if not more commercial than what we encountered overseas in terms of costs. So yeah. We do, I mean, we've got an estimated sort of total figure for our 2 journeys, which includes our domestic and international journey, which would be in excess of $250,000.
Our journey, I guess, spanned, since about 2021, and since that time, we have spent, we sort of, again, stopped counting, but it's more than, $250,000 in total. That included 7 rounds of IVF on myself, 1 round for our surrogate. Thankfully, she fell pregnant first go. But then there's things like post-surrogacy counselling, which the surrogate and her husband had to attend, and my husband and I had to attend separate. That was $1,000, and the sessions went for, in total for both sessions, about 45 minutes. And that is a requirement that can't, you need to do that to then be able to have the parentage order. So there's a lot of legal fees, counselling fees, all within, before we even had done a transfer, we had spent more than $25,000 just on the pre-surrogacy process here in Australia.
Obviously, I'm coming from a different angle as a surrogate, but I don't want to speak necessarily on behalf of my friends Edwina and Charlie because I haven't seen their spreadsheet, but I know that it was very expensive, and I would echo everything that they've said.
Thank you. Look, it's quite extraordinary, and I know you could never put a price on having happy kids and a happy family, but it really strikes me that this is clearly not a journey that's accessible for every family in New South Wales if they needed to. I'm also interested in understanding where you go to for information about these processes. It's obviously extraordinarily complex, both legally and medically and practically, without some kind of centralised, regulated government source of information. How did you find out how to navigate any of these things? What are your sources of information?
I mean, if I can speak for our experience, I think domestically and internationally, there's very well-known communities online where people seek information, and there are also service providers that provide information about how to proceed, and of course, lawyers, clinics. So you kind of cobble together your advice based off a number of different information sources and try to work out what's the best path forward. I agree with your idea that it would be helpful if there was some sort of central authoritative government guidance as to how to proceed in a surrogacy journey, because I don't think that there really is. And that flows into the question around how do you get more surrogates, is that I think, again, there might be people out there who want to be surrogates but also don't understand how to actually put themselves forward. So I think there's elements of that.
Yeah, so the first question that I would get whenever I shared what I was doing was, isn't that illegal? Everyone thought that it was illegal to be a surrogate in Australia. So that goes back to us talking about an education and awareness campaign. For me as a surrogate, we did a lot of research, my husband and I, before offering, and that was cobbled together. And the main source for me was using every network I could possibly find to find surrogates and speak to them, because I felt that they were the best source of information. But if you have a look at any other health process in Australia, there is a government regulated, trusted source of information, and this just doesn't have that.
For us, we were sort of advised that we would be having to look to go down the surrogacy path well before we had come to the decision to go down that path. And we were directed a lot by our fertility clinic. And with our surrogate, I don't think she really had done much research into it, but being like a sister to me, I've known her since I was 2 years old. She said during sort of some dark times, like, I am here for you to be your surrogate if needed, probably not expecting that we were going to get to that point. But then once we did get to that point, we sort of just were pushed and flowed in the direction that we needed to, with advice from our lawyers and our fertility clinic here.
For us, we used a concierge service called Babies Come True in Canada. And then when our journey turned into a domestic surrogacy journey, our Canadian lawyer referred us to Sarah Jefford, who I know you heard from yesterday, who helped us navigate the legal framework here in New South Wales.
Thanks. Apologies to the chair that I can't hear the bell go. So
you've got 30 seconds, so you can have one more.
Okay. Yeah, great. Thank you. I suppose the last question for the two of you that engaged with overseas processes, we had a discussion with the lawyers yesterday about the impact of overseas political decisions and the uncertainty that creates. And I was wondering if you had a perspective on that.
I have very strong views on that, given our journey was upturned 2 weeks before our children were born. As we said, the jurisdiction where we're having our children decided to change the process that we had entered into. So the contracts, the agreements with our surrogates were effectively cast aside, and the authorities decided to take a different path, which I guess that's the risk you take when going overseas, but no one expects it ever's going to happen to them. So we had a period of saying close to 2 months where we didn't have any documentation to prove our children existed, let alone that we were parents in a foreign country. And it was a period of great uncertainty and quite difficult, whilst you're also trying to raise two children for the first time. And I think it comes back to my reflections and all of this. There's obviously, you can't, the people of New South Wales or this government can't solve for international insecurity, but if we created a system here in Australia where people weren't making the decisions that we ultimately did, where we had more surrogates and better regulation, then we probably wouldn't have been overseas. We wouldn't have had to make that decision we did. And that's the risk that people are taking. And I wouldn't want people to experience that. And whilst ultimately we have great relationships with our surrogates, and we're a great story, a happy story, as I said, it was a pretty tough time. And I don't think we need to continue to allow that by the current arrangements we've got in place.
I'd also like to add that the stress around the parentage order here in New South Wales. So early on, we were told to, I guess, alleviate the stress of, you go, what if the surrogate is going to take our child? Flip that around the other way. How does the surrogate feel? What if we don't take the child from them? And that same applies for the parentage order. You go through what everyone agrees is years and years to get your child, but you still don't know at the end whether the parentage order will be approved. We still do not have a birth certificate that is correct, listing us as parents from New South Wales. And our parentage order was approved in December last year.
I would just add to that, sorry, Dr. Con, I would just add to that on behalf of Edwina and Charlie, part of the process that they had to go through, and I'm sure it's the same for you guys, was it was essentially they were adopting Angus from me. So they had to write like a long affidavit about why they would be good parents to their own child. And that's just an emotionally harrowing, unnecessary process.
Thank you. I think I'm out of time.
Yeah, we'll move to government questions.
Thank
Mr.
you,
Donnelly?
yes, and thank you through you, Chair. Thank you all for coming along. Just got limited time, so forgive me, I'll sort of have to press on. My questions. This is a hypothetical question, but one nevertheless I'd appreciate your thoughts. It's in the context of this discussion about the pre-birth parenting orders. And I perhaps from left to right sort of answer this question. That might be the easiest way to deal with it, just from each of you. What happens if a woman has declared she wants to become a surrogate, enters into an arrangement, believing that's what she wants to do, be a surrogate, goes through the practice of the surrogacy procedure, the negotiations that are associated with the identification of what needs to be the arrangements, gives birth, but then says, I've changed my mind. I have formed a particular bond through the pregnancy with this child. Yes, I thought that I wanted to be a surrogate, but I've changed my mind and I want to actually keep this baby. Now that's different from examples obviously where a woman enters into arrangement of a surrogacy, goes through the practice, whether it's altruistic or commercial, and the intention at the start is to be a surrogate and carries that intention through to the end, involving obviously the passing of the baby over to the commissioning parents. What do you say should be the rights, the fundamental rights of that woman to that child that she's carried for that duration, if she changes her mind? If she changes her mind and decides that she does not want to continue through with a surrogacy arrangement?
I would suggest we look at it like any other contract. So, and that's the difficulty with the pre-birth parentage order not being in place, and that's why every other jurisdiction has that in place. Your question is, what are the fundamental rights? I think what you agree to is what you agree to, and
I'm specifically
me-
about the mother and the child. The mother
Yeah,
and the
so
child
for-
that she's carrying.
Yeah, of course. So for me, as a surrogate, I entered into that experience knowing that I was going to carry the child for 9 months, but with the full intention that it was their child, not my child. I shouldn't say it like this, but I was like the Airbnb. They just moved in for a bit, moved out. So, I
Sorry,
feel...
who moved in and out? Sorry.
Well, the child. So I was just carrying the
right.
child. I was just the home for the child for 9 months. And the fundamental right is that child is theirs. It's the intended parent's child. And I was just there to help bring them into the world. So I think if we want to look at the legislation, I think it should show very clearly that a pre-birth parentage order should be in place so everybody is clear from the outset. And there is not taxing admin when you are trying to look after your first child. Everything is up in the air. Everybody knows how crazy that time is, and there's no reason for that taxing admin to happen. And it can take up to 12 months.
But with
So
respect,
that introduces a lot of
But with
confusion.
respect, I'm talking about a situation, irrespective of a parenting or pre-birth declaration of parentage. If a woman effectively changes her mind about the arrangement she's entered into, your evidence is that she's bound by the contract she's entered into.
Well, currently, no.
Hang on.
Currently,
And
no.
essentially, that's it. And that contract should be enforceable in all its terms, and that's the position.
It should be,
It
and
should
it
be,
is
okay.
not currently. So that confusion and that concern is what is currently happening. For surrogates, for the child, if we talk about the child being paramount, that child, in a wonderful example that you gave, that child could end up in child services because the surrogate didn't enter into that wanting the child. The intended parents, if they decide they don't want to take the child, where does the child go? The legislation should protect against
Yeah, I'm
that.
specifically looking at it through the eyes of the surrogate mother. Perhaps moving on to...
From my experience, our surrogate went into the agreement knowing that it wasn't her child. Biologically, the baby is mine and my husband's. So it really isn't her child because biologically her DNA is mine. I think that it's a terrifying time to go through thinking, what if they change their mind and decide that they would like to keep the child? And I think that that's why there should be more legal contracts in place to prevent that from happening. And I think that the pre-surrogacy counselling needs to be more meaningful in how the surrogate goes through that, because currently it's very top level tick box. And I think that you shouldn't essentially be allowed to be a surrogate unless you are able to compartmentalize. This isn't my child, but I am carrying it because it is for somebody that I love dearly, or it is for somebody that I would like to help in the world to help them to be parents.
Okay, no, that's clear. Just perhaps same question.
I think, Mr. Donnelly, it's a hard one for me to answer because I'm not a surrogate, but I do. So I think in on this particular question, you've got to take guidance from people who've actually carried children and been in those shoes and experienced that, because I think that's the greatest guidance you can get. And I think we've had a great explanation of the thoughts and thinking around that. I know in our experience, where we completed a lot of our pre-counselling process and ethics approvals here in New South Wales, we had long and deep conversations with our surrogate. And the primary concern at the time from our surrogate was, and which a number of surrogates is what happens if you don't want the child. That's what they're more concerned about.
Well, some.
Well,
The ones
in
you
this
dealt
in
with.
this situation, that could be one that a lot of people contemplate. So it's not just the side that you might always perceive in this situation.
I'm not perceiving anything. I'm just interested in your answer to the question.
Yeah.
So, just what's your thoughts on that?
Look, I'm going to echo around the framework. We completed pre-surrogacy, and ethics counselling in both Canada and New South Wales in the lead up, and it was really helpful. I do feel like we were quite educated in the whole process, but sitting down in a group session, talking through all the different scenarios, the good and the bad, with our surrogate was really insightful. And I guess that all happens pre-transfer. So you are entering into a process that, everyone's been guided and making an informed decision that you do hope that you don't get to that point. In our case, our surrogate had no genetic tie to our child. So, I can't speak on what it's like to give birth or that connection with the child, but I would also think that gives some separation to that process.
Thank you. Ms. Cutter?
Thank you all very much for being here and sharing with us. I'm keen to keep exploring the same issue, the idea of the pre-conception contract, I suppose. In terms of an altruistic surrogate where there's a pre-existing relationship and both parties are on an equal footing, I can understand conceptually how that would work. My challenge is how that would work when there's any inequality between the parties. And I think once we're moving into compensated or commercial surrogacy, yesterday there were examples where there was a fear that there would be an inequality where, because of too few surrogates, the inequality is between the intending parents and the surrogate. Commonly we see examples where the inequality is between the paid surrogate and the intending parents. How does binding somebody before conception work, before the experience of being pregnant, carrying that child? And should we lawfully compel a woman to hand over a child if we can't be sure that she has had equal bargaining power and has fully understood the process that she's entering into?
I would suggest that entering into any agreement, all parties benefit from clarity. So having clarity at the beginning of the process would just benefit everyone involved. So you touched on compensated surrogacy, of course, and that provides, that is not necessarily about just paying the surrogate. We heard yesterday from Sarah. I completely understand that that's important and I'm not here saying I want it to be paid. It's more about increasing access, which is what you touched on, increasing access to commissioning families wanting to have a child.
I just wonder if we can focus on this pre-birth contract though, because sure. I can't think of another example of a contract where legally you can compel execution-specific performance of a contract for the provision of personal services. Because what you're talking about really is a remedy of specific performance, and that's really because the court has taken the view that provision of personal services under a contract should not be compelled, yet here we would be compelling the most personal of services. And if a woman has developed a bond with the child that she's carrying and hasn't fully understood, and especially if we're thinking about women in really strained economic situations who feel that this might be something and so they go into it under economic duress, are we setting up a situation where we would be legally compelling women to hand over children? And we've seen examples of that well-intentioned in the past where it's ended up in significant generational pain, and I wonder whether we'd be repeating those same mistakes.
So just to clarify your question, when you say inequality, are you talking about coercion? Or
I'm talking about inequality of bargaining power. Contract theory rests on the theory that there's equality of bargaining power. It never exists, which is why we have consumer law. And I can see in the situations that Ms McCloy and Mrs Coops that you've raised, you've got an existing relationship with the person who reaches out and says, I love you, I want to be part of this. I can see how a pre-birth agreement would work well in those situations, a preconception agreement. My worry is that once we make that standard, we're then applying it to other situations where parties don't come with a pre-existing relationship. And if we're talking about a register where we're accessing somebody off a list, there is no pre-existing relationship. How can we be sure at that stage? How can we bind the woman to what happens in 9 months is what I'm asking. So Mrs. Coops, I think you wanted to say something.
Oh, yeah.
Sorry.
Yeah. I mean, without having a sort of system set up and in place, currently right now, there are a lot of arrangements happening. We are the minority of surrogacies in Australia, and majority of them there's Facebook groups where people are pleading for a surrogate to reach out to them. They are having informal agreements, and in that case, neither party is being protected in that,
Or the child.
the child, and that's where it does become really difficult, because for these people, what if the intended parents turn around and say, actually, we don't want the child, but that surrogate has gone into it and they also don't want the child? And I think that having a sort of a system put into place similar to a donor egg, where what if the person that's donated their egg then decides, actually, I do feel a connection to this child? I think that it can be argued both ways, but legally that donor egg has been donated and the person whose eggs it are don't have any rights.
And I would suggest, I'm sure you're going to echo it, but I would suggest in the situations where there isn't a pre-existing relationship, clarity and a pre-birth parentage order is much more useful. So that would be my position.
It's the agency of the carrying mother that worries me, though.
Dr. Con.
Yeah.
Yeah, there's a 5-minute allocation for you, Dr. Con.
Thank you. I think I'll only have time for one question in 5 minutes, and I wanted to put to all four of you that we've received submissions and evidence from people arguing ostensibly in the best interests of children and of surrogates, and their proposed solution is that people seeking children through surrogacy arrangements should be criminalised and thrown in jail as the pathway forward. And I wanted to give you the opportunity to respond to that, and I suppose what impact it would have on you and your families and the beautiful bubs that I can see in the background of the shot at the moment, were that to be the recommendation that this committee makes.
What can any parent say to that? I mean, the idea is horrific. And as a parent, to be disconnected from your child is unthinkable. It makes my skin crawl, the idea that I would not be able to read to my children the story of night, or take them to daycare in the morning. The idea that someone would make an arbitrary decision or judgment about the validity of my family without knowing our story and how we created our family, just to service what we think is, and what clearly is a law that is not working, is just ridiculous. And I think we need to think long and hard about this and the implication of that law and what it does to families and the decisions that it creates and the heartbreak and the risk that people take. And if we can't rethink or change that law, why say things like that as well? Anyway, yeah, I find it hard. Anyway, someone else should answer that.
So much love has gone into all of us creating our families. I don't think, it's not like we woke up one day and went, we're going to have a child, and it's taken years, and our child has such a large community supporting him. He's one of the luckiest children, and I know I'm biased, but so much love.
I think from my experience, as well as through medical misconduct, essentially I lost my ability to carry a child. I nearly lost my life 3 times. I essentially ended up having to have a full hysterectomy to save my life. Why is it fair that I'm not allowed to then continue my journey to try and become a mother, something that I've always wanted to be my whole entire life, and just through bad luck haven't been able to do it myself. So I think, how is that fair? Or equally, women that are born without uteruses, or same-sex couples where, it's just not possible. I just don't see how that's fair.
I would just echo everything they've said, but if we want to talk about, criminalising something that's a gift to another human being, that just seems ridiculous. But also, if we want to talk about the agency of the surrogate parent and the intended parents, if we wish to enter into an agreement together and we all sign and we're happy and we have clarity and everybody ends up with a good outcome, then why wouldn't legislation support that?
You do have 1.5 minutes left, Amanda, if you've got any more questions.
Thanks. I might follow up just directly to Ms. McCloy, that some people have argued in the interests of women's rights that surrogacy should be banned in all circumstances. From your point of view, in terms of your reproductive autonomy, you've made a choice to be a surrogate. What's your view of a ban on surrogacy from that perspective of autonomy?
I think it's a flawed argument. If they're talking about autonomy and women's rights, then it's our right to make the decision what we wish to do with our own uterus. So that makes absolutely no sense. I just think it's deeply flawed. And I think that, we can make these decisions to do things for other humans, and that's fine, but I do think that we need to have protections around it, because that deters so many other people from doing it, because it is a huge risk at the moment with the way that the legislation sits, and it's a risk for everyone involved, as we've really clearly, I'm not going to go over that again, but it's a risk for everyone involved, which means that access is low, which means we are sending beautiful Australian families and parents into unregulated, risky situations, and I just don't see why the government can't support that.
Thank you. Thanks, Chair.
No worries. Mr. Donnelly? Yep.
My colleague Emily.
Oh, Emily, Mr. Val,
you-
online?
I'll just ask.
Thanks, and apologies to those in attendance that I can't turn on my screen. I'm driving at the moment. Thank you all for your evidence so far, and for sharing some really deeply personal experiences that you've all had. My question is quite specific, and it relates to the evidence regarding D&Cs that I think, apologies,
Mrs. Coops.
I can't recall. Yep. Thank you, Mrs. Coops. Thanks, Chair. Look, I'm just wondering if you could explain more about that specific recommendation for me, and where that sort of come up from.
Yeah, sure. So from a bit on my story, I was able to conceive. The first time we tried, I fell pregnant. It resulted in a miscarriage. I then tried my hardest to wait out the time of passing the baby myself. I was 10 weeks pregnant at that point. We had seen a heartbeat. I had formed a connection, and the baby we went to the 10-week scan and there was no heartbeat. I waited 2 weeks. It took a huge mental toll, and so I then went to the hospital and was informed that the best path forward, because I was so far along, was to have a D&C. At no point was I told that I was at risk of Ashman syndrome, which is an intrauterine scarring which causes infertility. At no point was I told that there was a risk that it was going to cause damage to my cervix, which down the line caused me to have a late miscarriage at 18 weeks, where I had to birth my baby girl. And all of this had snowballed, all of my hemorrhaging had snowballed from that one D&C, having no medical intervention prior to that one. It was evident that the D&C had caused all of my medical complications. It was performed by a registrar, and there's a lot of research that goes into if it is not performed correctly, and if it is a result of a miscarriage, you are at a very high chance of getting Ashman syndrome or of your uterus being perforated, so a hole placed into your uterus causing extreme complications. None of this was ever explained to me. I was told this was the best way forward. No, you don't want to take the tablet because then you're going to see a baby born into the toilet and go through labour pain at 10 weeks. So I think that if they are performed correctly, and there's a lot of sort of research, Professor Terry Van Kai is sort of he's a specialist in this area. People travel from all around the world to see him for Ashman's treatment. If it is performed correctly, your risks are significantly reduced. And I believe that a D&C being performed by a registrar, so they're not a fully qualified gynecologist, they're probably just on their round of their studies where they're placed into that section of the hospital, it can cause serious lifelong issues for women.
Look, thank you for sharing that. It's obviously a really deeply personal thing, and I'm really sorry for all that you have gone through.
Thank you.
That's awful. Given your experience, are you aware of any? Because I presume, Ms. Coops, that you went through sort of a process after that with the treating hospital, and if you can tell us, but please tell us. Please obviously decline to answer if that's more appropriate. But was there measures put in place, to your knowledge, to ensure that this sort of thing doesn't happen again?
No, there is a group, an Ashman Syndrome group Australia-wide, that are fighting for hospitals to change their policies, because currently anyone that has gone back to hospitals to argue that it had happened under the care, we are told straight back that we signed a consent waiver and that the liability is all on us.
So it sounds to me like the crux of the issue, and please correct me if I'm wrong, but part of the crux of the issue here is around the consent and the sort of lack of informed consent. Is that the case?
Yes, I believe that is definitely step one of the case, and then step two is who actually performs the procedure.
Emily, sorry, that's your bell rang. I apologise.
No, sorry.
That's the end of the time allocation. Thank you.
Thanks, Chair.
No problem. Thank you all for being here, and as I said, for sharing all of your personal stories, and particularly just on that note at the end, Mrs. Coop, sorry for your losses, and thank you for sharing about Millie and your journey and your written submission as well. And it's lovely to see your beautiful daughter here and all the happy families in the room. It's a very nice way to start the day. So I don't think anybody took anything on notice, but some of the committee members might have supplementary questions after today that we want to put to you. So the Secretariat will be in touch if that's the case. But thank you for making the time, and we really genuinely appreciate you being so open with us on what is obviously a very sensitive and challenging topic, but also a really lovely outcome for all of you. So thank you for being here. We'll now have a short morning tea break and resume at 10:30. Thanks. Excellent. Okay, hand sign's great. Thank you. So we'll just move now to our next panel of witnesses. Thank you all for being here. I would like to ask each witness, starting with you, Ms. Parsons, just to state your name, your position title, and then swear either the oath or the affirmation, please.
Okay. Christy Sheridan Parsons, family advocate from Families Donor Australia. And, Donor Conceives Families Australia. Sorry,
That's okay.
I've got a bit of a chest thing happening. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given to me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr. Scott?
My name's Ashley Scott and I'm the Executive Officer of Rainbow Families Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And Mr. Everingham?
My name's Sam Everingham, the Director of Growing Families. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. There's an opportunity for each of you to make a brief opening statement if you'd like. So, Ms. Parsons, we might begin with you.
Okay. I'll just apologise because I've got a bit of damage in my lungs. So
Okay, that's all right.
I need
Take
to
your
take
time.
breaths.
That's
Yes,
fine.
sorry.
That's okay.
Okay, so good morning, Chair and Honourable Committee members. My name is Christy Parsons and I'm a family advocate from Donor Conceived Families Australia. I appreciate the opportunity to speak today about pathways to parenthood that are safe, equitable and transparent. Australian family law has not kept pace with how families are formed today. Across New South Wales, people are creating families through donor conception, IVF and surrogacy, but the system governing this is increasingly restricting access, increasing costs and creating legal uncertainty. At the centre of this, there is a critical shortage of sperm and egg donors. This shortage is not accidental, it is driven by policy. In New South Wales, a donor is limited to 5 families worldwide. In practice, this often becomes 4 because one place is typically reserved for the donor's own families. That means each donor is only available to around 4 families. This is out of step with the guidance of the Reproductive Technology Accreditation Committee, which recommends 10 families per donor within Australia. A nationally consistent 10 family limit would immediately improve access while maintaining safeguards. Right now, intended parents are being forced into impossible choices. Use a donor who doesn't align with their personal, cultural or medical needs, travel interstate or overseas at great expense, turn to unregulated online arrangements or remain childless, not by choice. This is not about preference, it's about meaningful reproductive choice. Following the 225 clarification by New South Wales Health that the donor limit applies globally, access to overseas donors has largely disappeared. As a result, some patients are now paying well over $30,000 for donor sperm alone. Access to parenthood is increasingly determined by financial means. This is not equitable. But access is only part of the problem. There is also serious legal uncertainty, especially for single parents. Section 60H of the Family Law Act 1975 was written for a 2-parent model and does not clearly exclude donors when a single person conceives. That gap has real consequences. In Groth First Banks, a sperm donor was recognised as a legal parent despite prior agreement. This leaves solo parents at risk of custody disputes and unwanted co-parenting and creates uncertainty for their children. It also changes behaviour, with some parents avoiding donor contact out of legal fear. At the same time, Australia's ban on compensating donors and surrogates beyond expenses is limiting supply. If we want a sustainable system, participation needs to be viable within a regulated and ethical framework. Finally, this is a human rights issue. The Universal Declaration of Human Rights recognises the right to found a family. A system that forces people into unsafe options, unaffordable pathways, or prevents them from trying altogether is not consistent with that principle. So the solutions are clear. Adopt a nationally consistent 10 family limit per donor in line with Reproductive Technology Accreditation Committee guidance. Move to a per family model and exclude the donor's own family from the cap. Allow regulated compensation for donors and surrogates. And New South Wales recommend to amend Section 60H of the Family Law Act 1975 to provide certainty for single parents by excluding donors from legal parentage, because this is about fairness. It is about ensuring people are not locked out of parenthood by outdated policy, and that when families are created, they are protected.
Thank you. Mr. Scott?
Thank you. Thank you for the opportunity to appear today. My name is Ashley Scott. I am one of the founders and the executive officer of Rainbow Families. Rainbow Families is the peak body for LGBTQ+ families. Our mission is to connect, support and empower LGBTQ+ families across Australia. We were founded in New South Wales in 2015 and we became a national charity in 2024. I'm also a gay dad through surrogacy and a donor for another family that has a little one as well. Our community of LGBTQ+ parents is always growing, particularly since marriage equality. We see increasing numbers each year at our Making Rainbow Families seminar, antenatal classes, and our new parents group, which is run here in Sydney. Our community is beautifully diverse, and for our community, there are many different ways of starting a family. A majority of our families use some form of ART on their journey to parenthood, and for most, donor sperm and/or eggs are essential. With this in mind, the decisions that this committee makes will shape the lives of our families directly and profoundly. There are 3 areas I'd like to bring to the committee's attention. Firstly, donor sperm access. Last year, the New South Wales government clarified the regulation around family limits for donor sperm, reducing it to 5 families. 5 families worldwide, including the donor's family. This was changed without consultation and has had devastating impacts on far too many of our families who were just starting the process of IVF. This is how one member of our community has described their experience. It's such a terrible feeling and a lonely one. I wish they could tell us when more donors will be allowed through the system. It seems they've put a freeze on everything, and I see other states with many options. We are considering changing our address and flying to Queensland for treatments. Not sure how that would work legally. We are desperate. We started our journey in July when there were donors available. Now there are 0 donors, and it's been like that for months. Due to situations like this, increasingly people are turning to unregulated social media platforms to find donors, sometimes with devastating consequences. These online platforms are unregulated and come with additional risks for prospective parents as well as donors. Aside from the health and legal risks, we hear about people being pressured into natural insemination or pressured to have sex. These power dynamics involved can make it very unsafe for vulnerable people who may be desperate to conceive. Due to the lack of regulation and lack of donor limits, this can lead to a single donor being used by many families in the same area, particularly in regional areas. The answer to this problem for families needing donor sperm in New South Wales is simple. Like Christy just mentioned, bring the limit back up to 10 families and apply it nationwide. The second issue I'd like to raise is the cost and access to ART for LGBTQ+ people. This issue was raised by many people in our consultation. Families talked about having to sell houses or use money set aside for a house deposit to fund ART. Others talked about dipping into their super multiple times and now worrying about the long-term impacts this will have on them and their family. A significant and unjust barrier for our community is that low-cost public IVF clinics in New South Wales do not facilitate access to donor sperm banks. This means that unless you have a known donor, affordable treatment is simply not available. We would like to see low-cost public IVF clinics provide access to donor sperm banks so that treatment is accessible to all families, regardless of their budget. The last issue I'd like to raise in my opening statement is around surrogacy. The committee will have received submissions from people who are ideologically opposed to surrogacy, and I'd respectfully ask the committee give greater weight to the evidence from people with direct lived experience, like the families you met just before, rather than those who oppose it without any direct experience of surrogacy. In New South Wales, there are 3 main issues with surrogacy, in my opinion. First, the post-birth parentage order system for domestic surrogacy needs to be reformed. Parents should be able to be recognised from birth and immediately after with appropriate safeguards. As we heard earlier this morning, the surrogate remains the legal parent of a child they never intended to raise for up to 6 months after the birth, while the parents have no legal standing. The second surrogacy issue is to increase domestic surrogacy and reduce the need for families to go overseas. New South Wales must consider a regulated, capped, compensated model for surrogates. It's in the best interest of children, surrogates and families that these journeys happen here, where they can be properly regulated. The third issue is the criminalisation of international commercial surrogacy, which must be removed. It was introduced without community consultation, has never resulted in a single prosecution, and has succeeded in only leaving children without the legal recognition of their parents, who are fearful of applying for parentage orders. Rainbow families are already here. Our families need access to donors and low-cost ART options, and our children deserve the same legal certainty as every other child in New South Wales. Thank you.
Mr. Everingham.
Thanks for the opportunity to address the committee. I'm the Global Director of Growing Families, an Australian-based surrogacy support and education organisation, and over the past 15 years I've worked with more than 2,800 individuals and couples pursuing surrogacy. My team's delivered over 100 conferences and educational programs. I'm also a dad via international surrogacy of two girls. I speak today as a result through not only professional experience but also someone who's lived this journey. Surrogacy is no longer a fringe issue. It's a necessary and growing pathway to family for many Australians. A generation ago, people facing infertility often turned to adoption. Today, those pathways are largely closed, and surrogacy has become one of the only viable options. Yet here in New South Wales, the system is not working. Intended parents, as Ashley's alluded to, are forced into complex, uncertain and often overseas arrangements. They take on significant financial and emotional burdens while navigating a system that offers limited support and in some cases creates much additional risk. At the same time, we deny surrogates and donors even modest compensation for their time, commitment, physical and emotional investment. This has led to critical shortages and pushed more Australians offshore, despite the clear preference, as we heard yesterday, of most to build their families here within a regulated Australian framework. The barriers are clear. No compensation, no structured system for screening and support, no enforceable agreements, and a parentage process that creates uncertainty at the very moment a child is born. These are not minor administrative issues. They go to the heart of whether the system is ethical, functional and safe. Reform is both necessary and achievable. We can introduce a clear pre-birth parentage process that provides certainty for all parties. We can allow regulated agencies to operate, ensuring proper screening, education and ongoing support. And we can permit modest structured compensation, removing a key barrier while maintaining strong ethical safeguards. Right now, despite legal prohibitions, most New South Wales residents, as people have alluded to, do go overseas. No prosecutions have occurred, the law is not preventing the practice, it's just exporting it along with these risks. Most importantly, as we've heard already, current laws leave some children without clear legal recognition at birth, including our own. It's a real and avoidable harm, and there's no sound policy reason for maintaining a system that drives families offshore, limits safeguards and creates uncertainty for children. New South Wales does have the opportunity to create a framework that's ethical, practical and centred on best interests of the children. So I urge the committee to take that opportunity.
Thank you. I think a couple of you have been in the audience, but the committee's resolved to split the sort of question time equally between opposition and crossbenching government members. So we'll do a couple of rounds of questions, and just noting that we do have a couple of committee members online. So if they appear, they'll be on the screen in front of you. If they, I think Dr. Con, and I'm sure she'll have questions. So I will kick off for the opposition. I wanted to start with you, if I can, Mr. Scott. I think in the earlier session, I think it was Mr. Hadlin-Beer talked about going to a Rainbow Families sort of seminar, and I know you said, Mr. Everingham, that you also run a lot of conferences. I guess I'm just trying to understand sort of the level of demand, how important this is for the families and the individuals that you work with. Are people becoming more aware of the processes? Is it as confusing as it's always been? What's your experience in that in the organisations that you both run? And I'm happy for you, Ms. Parsons, to also comment on that, but I'll start with Mr. Scott.
So Rainbow Families, we've been running our Making Rainbow Families seminar since 2016, so 10 years this year. And it started because there was a group of us back then who had gone through the journey of parenthood and felt unsupported, didn't know where to look, didn't know what information was trustworthy. And so we brought together the experts in various fields to educate our community in a one-stop shop kind of way. So we start the day with psychologists, we have fostering and adoption agencies, we have international surrogacy from SAM, we have domestic surrogacy from Surrogacy Australia, IVF, we have a midwife talk about home insemination, we have a lawyer talk about the legal perspectives. We also have parent panels and children panels as well. And it really is a lovely day for people who are at the beginning of that parenting journey going, I think I want to be a parent, but I just don't know where to start. And they come and they get trusted information from the beginning. So we have around 80 people attend that conference every year, and that is, most people are in person here in Sydney. We do offer it as a hybrid event now so that people from around the country can join, but it is mostly people from Sydney that are joining. There's a lot of confusing information out there for anyone on that IVF journey, I think. But for queer people, I think there's it's even more confusing because there's no one clear pathway. You know, you can look at adoption, you can look at home insemination, you can look at IVF. If you're looking for surrogacy, is it domestic, is it international? It's very confusing because of all those options. And so people need to get that information from a trusted source and then pursue whichever option is going to be best for them.
In a way, the LGBTQI community is easier to access for this information because they tend to come to it a bit earlier. The heterosexual community, on the other hand, finds it very hard to get information. They're quite a hard population to access. As you've heard earlier today, they're often going through multiple rounds of failed IVF in Australia. Healthcare professionals here in Australia don't feel qualified to give them advice about surrogacy. They're not allowed to when it comes to international arrangements as well. So a lot of them rely on social media forums online, as you've already heard, which unfortunately have a lot of very out-of-date information on it, information that may not be applicable to their circumstances. It's a really complex area in terms of laws, ethics, logistics, and how different clinics approach the subject. And we do see a lot of intending parents get into trouble with these processes because they've assumed it's easy or they've gone down the wrong route and then have to retrace their steps after spending $50,000 or so. So look, it's a hard area because we do what we can with webinars and a few conferences each year, but there's a lot of people who don't access those things and access information that, or no information or not enough information to make it happen.
Ms. Parsons, did you have anything to add on that?
I can totally relate to what these gentlemen are saying. It's I think of, so I'm a single mother by choice. I have a young daughter, and she was, I used a sperm donor to have her 10 years ago. So I've been in this sphere for quite some time. I run different support groups. I've got a large single mothers by choice one, as well as ones that are, there's one that's just global and it's for everybody, heterosexual couples and queer couples and you know, the like, and single people. And there is such a dearth of information, as I said, or correct information, especially in Australia, because we have, you know, different laws in all the different states. So it's very confusing, and it can be quite dangerous because women are mainly women in the groups. They can get themselves into these situations where, as Ashley mentioned about the online donor community that happens, some people, that is their first choice. They would like to use a donor that they don't know, they strike a relationship with, and then that's the donor they use either at home or in the clinic. So that's that side of it. Then there's other people who go through clinics and they choose a donor there. The problem with using the donors outside the clinics is there is very little legal protection. So the donor can be considered the parent through the Family Law Act. If they go through a clinic, you're a bit more protected, but you're not 100%. They can still, you might write a contract or some sort of agreement between yourself and the person donating. But if they decide that they want to have more access, then that can be a big fight. And I know one woman in particular who's spent thousands and thousands of dollars trying to prevent her donor from taking custody. So it's pretty scary. And they had an agreement beforehand that was written by a solicitor. They knew that it was, because it comes before a judge, they look at that and they look at the intent, but they're always looking at what's best for the child. And often, unfortunately, there is a default that it's best to still have a nuclear family, a mum and dad. There is no evidence to support that. There's a lot of evidence to support that single mother families are actually thriving, in some instances, better than a couple that's, divorced, or they've had, some sort of trauma behind that, because it's a different choice when you're thinking, yes, I'll be a parent, you get all your ducks in a row, you're ready for it, and then if that is taken under your feet, imagine that's really hard. So we're having really great outcomes with our children, but there is a possibility that if a donor wants some sort of access, they can have it.
So one of the things that we heard yesterday from some of the witnesses, we were talking about the rights of the child, and there was some evidence around, the bonds that form in the womb with birth mothers, and people are obviously entitled to their views in relation to those issues. But I was interested, you called it out in your submission, Ms Parsons, but also from the other two witnesses to get your views. Research about children who are conceived, sort of what you're saying, either through donations or through surrogacy, I guess from all of the families and the people that you work with, and I think we saw a bit of that this morning. What do you see in terms of the family relationships, the outcomes of the children, and I guess the positives of that particular pathway to parenthood?
Yes, definitely. The single mothers, my choice, that I know and I'm in touch with, and all the polling and talking that we do between each other. So it is anecdotal, but then there's a lot of studies that I also read, global and national. The kids just seem so happy and secure. There doesn't seem to be any that I've come across where they're sort of grieving for another parent. That's just their life. A child is born into whatever situation they is. They might be a wealthy family, a middle class family, and that's what the circumstances are. And it's the same with these children who don't have a father. Some people decide to bring the donor into their life in a sort of uncle or family friend capacity, and they have to worry about that legal aspect, so that does worry me, and that is preventing some people from forming that bond, even if they want to, because they are concerned that they might get themselves into some legal hot water, because it's showing that there's a bond, then there's now a bond there. But there's nothing, there's been no proof that that's a negative thing to have a relationship with their donor when it's not a legal issue.
Yeah.
It's also shown that there's no negative aspect of not having that bond with a child. So there's just no research to prove either way.
Yeah.
It's a neutral topic. It's kind of down to personal choice.
Yeah. Mr Everingham, did you want to?
I've interviewed about 40 teenagers born via egg donation or surrogacy on conference panels. And the key issue seems to be early disclosure to those children about how they were conceived and how they were created. And we push that as a message to all intending parents, that as long as the kids are told early that there was a donor and or a surrogate used, they end up being perfectly fine as kids and are no different to the rest of the community in terms of how they turn out in their relationships. Some of them do have relationships with their surrogates and donors, some don't. There's no evidence either way that there's any differences in their outcomes for those kids.
Yeah.
But in the kids I've talked to over a number of years, that they've all had sort of happy experiences because there was early disclosure.
Yeah. Did you want to add something, Mr Scott?
Just echoing what everyone else has said, our kids have really wanted and really loved. We spend so long in the planning and the process to have these children, that they're created with such intention and such love. The longitudinal research does show that our families do just as well, if not better. Our kids are doing as well, if not better, than traditional families. So the evidence is there showing that. And I think that is particularly in a rainbow family situation with queer parents. That's partly because of that early transparency. When you look at donor conceived people that have had a negative experience, those people are often a lot older and there was not transparency around their conception. But for queer families, we don't have the choice, not that we'd want to, but it's pretty obvious you've got two dads or you've got two mums or whatever that situation is, and then there was a donor or a surrogate involved in that. And so that early transparency is so important to the kids' happiness, and that's what happens within rainbow families.
Thank you. We'll move to Dr. Con, who's online. Ready?
Thanks, Chair. Good morning, everyone. Thanks so much for taking the time today to share your experiences and your expertise with us. I might start with Mr. Scott. Of course, not every family that accesses assisted reproductive technology is a rainbow family, but you're obviously speaking on behalf of rainbow families today. And in your written submission, you touched on inadequate support services specifically for LGBTQ plus people. And I was wondering if you could talk through, whether in the health system or the legal system or both, what you see as the opportunities to improve supports for LGBTQ plus people specifically.
The health system and the IVF system is such a heteronormative space. It is really set up for for straight couples. I think single parents would find the same thing, and there's some IVF clinics that might have a front that looks very rainbow, but then once you get behind that, you see that you're really just going into the traditional heteronormative space. I think there's an opportunity for IVF clinics to improve on their family diversity inclusion and improve the way they support our families. Our community is so incredibly diverse, which is something I love. It's not everyone is a same-sex lesbian couple. We've got trans and gender diverse people. You've got dads through surrogacy. You've got people with known donors. It's really diverse, and I think IVF clinics can get better at supporting our families, upskilling their staff and their clinicians around family diversity inclusion. That also then follows through into the health system, into antenatal care, antenatal education, new parents groups. It's all very heteronormative, in my opinion. Does that answer your question?
Yeah, it does, and maybe I'll extend the question to all three of you now in terms of that support, in terms of information provision, in terms of education, in terms of, I suppose, hand-holding in what can be an incredibly complex process. What recommendations you think we could make to better support people? So rainbow families, but all families going through ART.
Do you want to speak first? Or?
Look, I think there has to be more funding of education for infertile couples and involuntary infertile people, like gay singles and couples, because there is an absence of reliable information out there. We try and keep information up to date on our website, but we can only do so much. So I think government investment in education is important to do that, because there's just not much out there. I think the federal government has a surrogacy website now which is fairly static and doesn't have a lot on it. This obviously people can go to specialist surrogacy lawyers, but that's the main avenue they tend to go to for information, and they're just looking at the legal side of it, not the emotional and medical and logistical side of it, and that's where there's a lot of lack of information around about what the implications are of their decision making, and that's a big area I think for reform in terms of talking them through these issues before they take a decision that might not be prepared for.
This morning, if I can quickly jump in, this morning we heard about, there was discussion around a surrogacy-based information and education campaign, which I think would be a really great place to start. And what I would encourage this committee to do would be to ensure that it is LGBTQ plus inclusive as well, and make sure that it's information in there for all members of the community that are accessing that information.
With the single mothers and not having enough support through the clinics and just in general, we identify very much with the rainbow community, as in we are going outside that traditional family unit, and also we have a lot of rainbow families in our family as well who are just single. Anyway, but there is such a, it's the same as Ashley's, where the clinic might show that they're very solely mother by choice friendly, but they don't have very good information. They have things like you have to attend a counselling session, whereas that's very off-putting, and a lot of the people get really scared and say, oh, they're going to let me know if I'm worthy of having a child, where really it's an information session. It could be called an information session. In those sessions, they're told that the donor has no legal rights whatsoever, which isn't true. They are often not given correct stats, so they might just be given stats of pregnancies rather than live births, which is very, they're very different, because there can be, I can't remember their stats, but there are a lot of early term miscarriages where we know a lot earlier when we're going to have a child. Like it's at 2 weeks we'll know we're pregnant. Most people wouldn't know that the first 6 weeks that they have miscarriage. So a lot of them aren't being told that this is actually a live birth, rather than this is a stat for the pregnancy, not a live birth. So they get confused that they think they'll, it'll work one goes and that just is not the case. It usually takes between 2 to 3 cycles to actually have a live birth. They also don't, they just don't seem to be across a lot of the single things. Like they'll say, oh, you can sign this registry and that can help with meeting up with donor siblings, but they don't go through that what the benefit might be, and that would be an anecdotal benefit, because there is a little bit of data about that it can be a good thing, but there's nothing to say it's detrimental. I feel by giving that option, saying, hey, you could register, it's not showing that it's a neutral topic, that it can be a personal one. They think that they have to do that, and when they might not choose to, there just seems to be this, it's all still very pointed towards heterosexual couples. Yeah, I hope that gives some sort of background.
Yeah, thank you, that's helpful. And if I can just come back to Mr. Scott to pick something up from your written submission, which was about the implementation of the Equality Act, which the Parliament passed in this term and was intended to provide a pathway for existing families with children born through surrogacy arrangements to be able to access a parentage order when that's in the best interests of the child. It's obviously quite distressing to read that that's not actually the case for all of the families that change was intended to support. Can you talk us through that issue?
Absolutely. It's a passion project of mine, so thank you for the question. So I will talk about my family. My children were born through international surrogacy, and I'm listed on their birth certificate as their father, and on one of their birth certificates is their surrogate, and on the other one it's just me as the parent. Because we engaged in international surrogacy, commercial surrogacy, we broke the law. And so we're worried about the criminalisation of engaging in international commercial surrogacy. And so we haven't sought a parentage order. What that means is that my child isn't recognised, my children are not recognised as my children or my husband's. And for me, I have the certainty of a birth certificate, which has got my name on it. But if I walked out of here today and got hit by a bus, there's actually no record of my husband being a parent to our children. He's not on their birth certificate. On the passport applications, I pretend I'm a single parent because that's just easier, and that was the advice that we were given at the time. And so there's no record of my husband as a parent. So how does he then enroll them in school with a birth certificate where his name isn't on there and there's no parentage order? I worked and have been advocating on this for many, many years, and worked quite closely with Alex Greenwich on the Equality Bill, and my family was mentioned quite a lot in Parliament around the parentage order component of the Equality Bill, and we celebrated that win because we thought that was a win. It's turned out that families like mine actually can't access those parentage orders because we don't meet the strict criteria. And you heard from Camden and Phil this morning as well, who are in a similar situation. So the Equality Bill was the laws around the parentage order were drafted quite quickly, and the intention was that families like mine through international surrogacy would be able to access the parentage order, but that isn't the reality. So we'd really love to see a recommendation out of this committee that families through international surrogacy, if it's in the best interest of the children obviously, those parents are able to access parentage orders to give those families and those children that legal certainty of who their parents are.
Amanda, it's time for government questions now. So
Thank you. Thanks, Jan. Thank you all
members.
for coming along, and thank you for your submissions, which have been very helpful. I've got the same few questions that I wish to sort of pose to the three of you, if that's okay. And so perhaps these sort of start on the left and move across. Is that the convenient way to do it? Yeah. The questions are and we're a bit challenged, I think, the committee of actually finding examples of surrogacy agreements, the actual documents, be they altruistic in nature, altruistic agreements which are the case for Australia, generally speaking, across the jurisdictions, and the commercial arrangements, the commercial surrogacy agreements, which typically are found in various jurisdictions overseas where parents or individuals travel overseas and arrange a surrogacy arrangement which is available obviously in a number of jurisdictions. Starting on the issue of the altruistic agreements, does Donor Conceived Families Australia have examples of altruistic surrogacy agreements? Can I just say up front, very clear, we're not looking for any identifying markings or names or anything that could identify the individuals involved, be they the commissioning parents or the whole set of people involved. But just for our own understanding of what agreements look like, do you have any examples of altruistic agreements that you
I
might be
have seen them. I don't have.
No, sorry,
on me,
I'm not assuming
but,
that you got them today,
yeah,
but
no.
you might have some.
I'm quite happy to send, with permission from
on
other
notice?
people, I'm happy to send them across.
Yeah, so on notice, this is on notice, so
Okay,
obviously,
yes. Yeah.
and they're altruistic agreements, in other words, other than for reasonable expenses, obviously there's no additional payment. With respect to commercial surrogacy agreements, would you equally have access to any of those?
Yes, certainly. So I could get you an Australian altruistic, Australian commercial, and a completely if you're interested in what they do in Canada. I have a friend there who went through a surrogate and used a donor.
Just because
in a heterosexual relationship.
Big one?
In a heterosexual relationship. So you could look at
whatever the relationship is. It's just interesting to see what the actual terms of an agreement is, because we're hearing different bits of information about the content and the limits of the content or the non-limits of the content in terms of what could be in it. In other words, multiple sort of clauses and across many, many pages. So thank you for that. How about your organisation? Would you have examples of agreements that you might be able to sort of de-identify and provide as evidence to inquiry?
Rainbow Families doesn't have those kind of agreements. That's, I guess, not what we're as an organisation set up to support families on that journey. I would wonder if the surrogacy lawyers who you met yesterday might have more access to those domestic altruistic agreements and to those international commercial ones. But Sam may have more to say on that, given that's his area.
So just remember, you wouldn't have any template agreements that you sort of would use to sort of advise people about?
No, we don't provide that kind of advice.
Okay, that's helpful to know. That's helpful to know. Yeah.
And we do discourage people from using a template. These are such individualised arrangements that you need to talk about them and write them from a customised perspective. We can certainly provide some de-identified agreements samples from countries like Georgia, Colombia, Mexico, or USA, because we see those agreements all the time.
Now, just to help understand the terms, and so what about the altruistic agreements in Australia? Do they typically, noting the legislation in Australia in each jurisdiction, do they typically have documents which are called contracts or agreements between the parties?
It's not a contract.
Sorry, I use that, apologise, I use that in a very generic sense. Is there a document that...
There's usually a written document, an agreement defining what the parties have agreed to up front, and what their expectations are around how the pregnancy will run, what they'd like to do for each other during the pregnancy and after, what contact they expect to have during the pregnancy and after. Depending on how much detail their lawyer goes into, they can put whatever they'd like in there. They're not binding agreements, as you heard yesterday,
Sure.
but they're certainly supposed to be a guideline to show evidence that the team, we call them a surrogacy team, have thought this through in detail.
So if you've got any examples of the altruistic ones, just for our understanding. In terms of the matter of the terms within a commercial surrogacy agreement, and once again, I pose this, I guess, to the three of you. Obviously, across the three submissions, there is reference to, and I think, correct me if I'm wrong, if I've misunderstood this particular element of the evidence in the submissions, but support for the idea of what might be described as a creation of an arrangement which would move to a reasonable compensation or reasonable payment arrangement for surrogacy in Australia, which is different from the altruistic, which we currently have, which is reasonable expenses. I've sort of used that phrase. With respect to the reasonable compensation, would it be likely, if one did transition to that through legislative change, to incorporate a lot more detail inside those agreements that I've seen in, just by doing a bit of and I know this sort of sounds very lame, but some basic search on the internet where some of these agreements go over many, many pages. So what I guess I'm saying is that with respect to moving towards that more commercial model as proposed, it would likely see, as part of a natural progression, a more comprehensive document with a range of conditions and details and requirements and obligations on parties, which otherwise you probably wouldn't find in an altruistic agreement?
Look, I don't agree. I don't think that's a requirement that we're arguing for in a revised Australian New South Wales model. We're arguing really for more generous expenses to allow for things like pain, discomfort, labour involved in the process, time away from their own families. We're not arguing for a contract-based model where the surrogate has no ability to change her mind. So there's certainly no argument here that we would put in place a contractual model like other countries have. The arguments we're going for is really much more around giving the surrogate much more recognition and financial recognition for the pain and suffering, and having that paid on a monthly basis rather than a lump sum at the end, which many countries do.
If I read the evidence correctly, so that's a payment which would be up to 3 months after the birth. Is that?
No, I'm talking about a monthly payment of $2,000 perhaps.
Right.
Each month of the pregnancy for the labour involved in the pregnancy.
For the duration of the 9 months.
Yeah.
Thanks, Ms. Donnelly. Mrs. Carter.
Okay. Thank you all for being here. If I could just follow up, Mr. Everingham, on Mr. Donnelly's question. So you would not support a model where there was a contract with the commissioning parents and the birth mother pre-conception?
No, we would support that, to have a pre-birth order in place.
Sorry, because I just understood you to say that you thought it should be open for the woman to change her mind.
We think there should be a safeguard in place if the surrogate... We don't think that the surrogate should be forced to give up the child if she does change her mind post-birth. In the cases where she has not, where everything's going fine, then there should be automatic transfer of parentage at the birth or pre-birth to the intending parents. So
what would the time period be that you would think was reasonable for the woman to contemplate whether she wanted to retain the child to which she'd
around
given
3
birth?
months post-birth.
So you'd still have a 3-month uncertainty period, wouldn't you?
Yes, in case things went badly wrong. And there are cases when a surrogate has not had adequate counselling up front, she hasn't thought this through.
And also pregnancy changes people's perspectives on things, doesn't it?
That's right.
Yeah, the experience of carrying a child and bonding with that child changes a woman's perspective.
I agree. And having talked to surrogates and policymakers over the last 15 years, I'm strongly of the view that there needs to be an out clause there, so that if the surrogate does change her mind, she should be allowed to do that in our cultural environment here.
If you're talking about a situation where there's a compensated surrogacy and the woman exercised her right to keep her child, what happens to the compensation payments that have been made?
Look, that would be part of what's in the sort of the legal document.
What would you recommend though? What would be the sort of the starting position for that?
Look, I mean, there may be some refund of monies paid.
So the woman would have to pay back money if she wanted to keep a child?
I think so, yes.
How much of the money would she pay back?
Oh, look, I'm not sure. I haven't given that particular thought,
Right.
but perhaps a small proportion.
Okay. And what if... Yeah, okay, all right. If I could go back to you, Ms Parsons, and I think you too, Mr Scott, both mentioned the issue of the donor cap. What's the policy reason for having a donor cap at all?
There is thought that some people might not like to have so many donor siblings.
Is it people don't want to have so many donor siblings, or that there is a risk of too many brothers and sisters potentially meeting each other and lots of Ozark first cousins down the track?
Yeah, there is. There has been that argument in the past from some factions. I just think
is that not a good policy argument in theory?
Not really, because it's just so unlikely that it could happen. It's just have you
got any evidence for the basis that it is unlikely that that genetic siblings will find each other attractive?
The only evidence I have is there is no the genetic attraction, it's called the genetic sexual attraction. It's a quack, like it's pseudoscience. So there's no...
Have you got any papers that would support that? Because I've seen papers that support the opposite, so I'd be interested in any documentation. And have those papers been presented to policymakers about the cap?
I don't know.
So you haven't lobbied in relation to that?
Yeah, I haven't taken notice, but I can definitely get you...
Yeah. And why is 10 a better number than 5 in terms of the policy reasons for having a cap in the first place?
Yeah.
Mr Scott, have you got views on this?
Sure. 10 seems to be the international standard.
No, but what's the policy reasoning for developing 10 as a number?
In New South Wales?
Well, if you say it's an international standard, what are the policy reasons that support 10 rather than 5?
I don't know what those policy reasons are, but what I will say about that is, since reducing the number to 5, international sperm banks pretty much are not dealing with New South Wales clinics because all of their donors have agreed to 10 families. And so by reducing it to 5, there's now no donor sperm from international clinics in New South Wales. And so we're requesting...
What are the reasons why we don't have enough local donations?
Reasons are because we mandate ID release donors, so the donor must agree to be in touch with the child at a certain age if the child desires it, and that puts off a lot of donors from coming forward.
And if there's an international donation, is it subject to the same requirements?
If the donor eggs or sperm are coming into Australia, yes, it is. In theory, I doubt very much whether those children would be actually able to contact that donor 15 years down the line, but that's what they promise.
Why would they not be able to contact them?
Well, because the donor bank might not have kept the records up to date. The donor may have moved, may have changed their email address, changed their phone number.
Okay.
Yeah. If I might just...
so can I just ask a follow-up? Sorry. Isn't it in the best interest of the child, especially as that child becomes a young person and a young adult, that they're able to be in contact with the donors?
I believe so, yes.
Yeah. And Mr Scott?
Absolutely. They should have the option to do that.
Yeah. So that supports the policy, I suppose, in a sense. But, all right, sorry, I've run out of time. Sorry.
Sorry, yes. Dr. Con.
Thanks, Chair. A fairly minor question to all three of you, but I'm interested in your perspectives on terminology. We've had through the diversity of submissions that the committee's received, the term surrogate has been pretty common, but there's lots of other terms used, similarly intended parent and all of the other terms that are used. Do you have a strong preference on how the committee or how the government should be referring to different individuals involved in these arrangements?
I tend to prefer intended parent. A lot of the literature talks about commissioning parents in the academic literature, but intended parent seems to be more palatable to most of the community. And surrogate is certainly a term we prefer here in Australia rather than what the US uses, which is gestational carrier. We certainly don't like the term surrogate mother because surrogates don't see themselves as being the mother to the child.
Correct, I would agree with that.
Yeah. Yes, commissioning parent is it sounds quite abhorrent to me. It's hard because there's a big range in my community, in the single mothers community. I call myself a single parent by choice because they're just, I don't know, if you say single mother, people think you must have had a breakdown or something, and I like people to know that my daughter doesn't have another parent for safety reasons. A man's not going to come and try and pick her up from school, that stuff, and social reasons. But others call themselves single mothers by choice, so mothers by choice, it's not that big a deal. I don't like the recipient parent, or we don't like the recipient parent terminology because they're a parent, they're not. You know, if you've conceived by a donor or if you've conceived naturally, they're a parent. We don't need to say they're a recipient parent. Can I take on notice too, because we had some terminology in our submission.
Yeah, please.
Yeah.
Feel free to provide an answer on notice as well. And just with the last of my time, there was a particular comment in the written submission around specific issues faced by parents who are trans and gender diverse in accessing ART or surrogacy. And I was hoping you could explain that.
Sure. So transgender diverse parents or intending parents have, specific challenges depending on where they're at in their transition. And I've talked about the diversity of our community a little bit already. There's a huge diversity even within the trans and gender diverse parents space, whether people are on hormones, whether they're not, whether they need donor eggs, donor sperm, whether they need surrogacy. It's incredibly diverse. So I think the needs of trans and gender diverse people in the ART space are very specific. With our Making Rainbow Families seminar, for example, we used to run a trans and gender diverse session, but we stopped that a couple of years ago because we realised that the information that families needed was so specific that we were better off to connect those families directly with providers that could give them information specific to that family, rather than a broad, general trans and gender diverse information. I do think this comes back to that education for ART providers around the needs of trans and gender diverse people, and I think there's an opportunity to upskill providers around those needs and offer specific training for what those families may need.
Thank you. Thanks, Chair.
Mr.
Yeah,
Donovan?
thank you, Chair. Probably all aware that the principal agency in Australia responsible for setting rates and payments and allowances and entitlements is the Australian Fair Work Commission. And the Australian Fair Work Commission provides that they're what are called the National Employment Standards, or the NESs. And the National Employment Standards provide for what is a minimum for that applies with respect to rates of pay, allowances and entitlements, and no person is able to be paid in terms of those wages, rates of pay and entitlements less than those minimums. Now those minimums, they're called allowable matters, and typically the awards have, depends from award to award, but probably around 12 or so allowable matters. Now, to achieve the standards, which I think are being argued for here, is really we do need minimum standards, so we don't have sort of my language, sort of a off the plan surrogacy industry operating, where people are being paid less or exploited or whatever the case may be. Would you support the proposition of the Australian Fair Work Commission setting minimum standards for surrogacy in Australia?
It depends if you're going to define gestational labour as work.
Well, I think some of the submissions do. This is the point.
Yeah, okay.
Using the word labour exactly, labour. So I mean, this is the issue, that the commercialisation and the language used in a number of submissions talks about the labour and a range of other things associated with carrying. Well, first of all, the carrying the placing of the ova into the uterus, and then the 9 months and what might be the immediate period after it. So it's clearly characterising surrogacy as a commercial arrangement for what is a service being delivered. So if that's the case, which it clearly is, because the argument for the contracts, and putting aside Mr. Everingham's position that a surrogate at the end, if they change their mind, that's okay in circumstances. Virtually all the other witnesses that have come to the inquiry thus far arguing for reform have said that these commercial arrangements are effectively contracts that should be legally binding for the actual service of the labour applied for being what is a surrogate. So if there is going to be this movement towards a commercialisation of the practice of surrogacy, surely it can't be left to anyone other than the experts like the Australian Fair Work Commission to set minimum standards, because who else has the expertise?
Most surrogates would continue their other work while they're pregnant with someone else's child. So I don't see that they'd see this as being, or want to see this as being a form of paid labour. We are not arguing for a commercial model. We're arguing for more compensation for surrogates' time and effort. In the USA, for example, surrogate compensation is market-based, and it gets to ridiculous levels. But that is actually untaxed income in the USA. I don't quite know how they define it as that, but they say it's compensation rather than earnings, and so it's tax-free. I suspect that's the model we want to go down here, is make sure we see this as being compensation for labour and not earned income, if you like.
But that's contrary to, it's a moot point, and my time's expired, but a number, well, I don't want to exaggerate it, but a series of witnesses have come before the inquiry and expressly advocated for the model of a commercial arrangement, and that it be legally binding like any other contract. And it just struck me that it's just ripe for exploitation, this whole area of surrogacy, if we move towards this more commercial model and there isn't the setting by an independent body with expertise on labour and work and entitlements, like the Fair Work Commission, to determine what these minimum standards should be.
Yeah, no, I think you're right. There does need to be an expert body that determines minimum compensation. Totally, I think that's really important to have that there, so it's not a market-driven expense. It is a capped expense, as you heard yesterday from Sarah Jefford.
Do you think the Fair Work Commission would be a suitable body to do that?
It doesn't sit comfortably with me, but in the absence of anything else, possibly.
Well, if it doesn't sit comfortably with you, what other organisation or agency could possibly make that determination?
I can't think of one.
Okay, sure. Mr. Everingham, Mr. Scott, do you have a view about this?
It's an interesting concept that I've not heard brought up anywhere else, that the Fair Work Commission would set rates for surrogates. I know the federal ALRC.
And other provisions. So the allowable matters, there's about a dozen of them, which cover a whole range of minimum entitlements. Yeah.
The ALRC at the moment, I'm sure you're aware, are doing a piece of work around surrogacy, and I'd be interested in what their findings are and whether New South Wales could lean on their recommendations. Also, in our space, I don't hear of people asking for commercial surrogacy. I hear of people asking for compensated surrogacy. So not wanting to commercialise the industry, but really wanting to compensate the people who are surrogates. They're the one person in the whole surrogacy journey who's really not paid, and yet they're the one who's doing the amazing amount of work. The egg donors are compensated, the lawyers are paid, the IVF clinics, but the surrogate themselves are not paid. And so we would like to see greater compensation for them.
But you are calling it a payment, yeah. Ms. Parsons, did you have any comments?
Yes. So we also believe that surrogates should be compensated, as well as sperm and egg donors, we believe. I know it's an interesting concept to see if it would if it would be the right thing to go on Fair Work, because as Sam said, there needs to be a cap. None of us here want it to be a commercial entity, but we do want to see, and I think there are things that we don't even think about, like when a woman's pregnant, we have to buy bigger clothes, and then we might have to do things to lose the weight afterwards. And you can even, I've heard of women getting incredibly sick, which might have been due to pregnancy, and then they're not actually allowed to be compensated. They can for some things, but not for others. So it doesn't seem fair that the surrogate can actually be financially burdened as well if they can't they can't legally put some of the items that they can be compensated for now through. I hope that, I'm not sure if I've explained myself very
That's
well.
Okay. And just one point, just quickly, it's not actually a question.
Yeah.
You would be aware that in the labour market, over-reward payments, over-agreement payments are actually manifest. In other words, they're everywhere. Wherever work is done, there are over-award payments or over-agreement payments. I suspect that under the model that's being proposed, even if it's considered fair compensation, not basically remuneration, the fact of the matter is, and if I may be bold enough to say, it is quite delusional to be suggesting otherwise, there are and would have to be and will be over minimum payments made, which is a pretty standard practice in what is a market-style system. So I think we need to be frank about that. Yeah. Okay, thanks.
Thanks, Mr. Connolly. Thank you, all three of you, for appearing today. I know, Ms. Parsons, you took some questions on notice, and there might be some supplementary questions to all three of you that the committee may have. So in that case, the Secretariat will be in touch just to organise that process. But thank you for your evidence and for being here today.
Thank you so much.
All.
started with the next panel of witnesses. Thank you all for being here today and making the time to give evidence to the inquiry. Obviously, we've got 3 in the room and 1 online. We've also got a couple of the committee members online as well, just for your information. So, but we'll start with each witness stating their name, their position, title, and swearing either an oath or an affirmation. Starting with witness on my left, Ms. Beashall.
My name is Karen Beashall. I'm the Principal Solicitor at the Inner City Legal Centre. I solemnly and sincerely and truly declare and affirm the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Ms. Brown?
My name is Ms. Anna Brown. I'm the CEO of Equality Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
My name is Sarah Bevan. I am a specialist surrogacy lawyer and family lawyer. I am also president of Surrogacy Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And then we'll just move to Ms. Corkul online.
Good morning, everyone. I'm afraid I don't have the words in front of me, but I also solemnly declare and affirm that the evidence...
I think I can read... Hang on, let's get a bit of advice from my support crew here. I've got them and I can say them and you can...
Thank you.
You can repeat, so we're all above board. That's all right. Just give me a second. I apologise. I should have been more organised. 6. Tab 6. Here we go. The oath or the affirmation, what would you prefer?
Affirmation.
Sure. So I solemnly, sincerely and truly declare and affirm.
I solemnly, sincerely and truly affirm and declare.
That the evidence now about to be given by me.
That the evidence now about to be given by me.
Shall be the truth, the whole truth and nothing but the truth.
Shall be the truth, the whole truth and nothing but the truth.
Thank you. 15 years in Parliament, that's the first time I've ever said that, so there we go. We do a different swearing in. Anyway, I apologise. There's an opportunity for witnesses to make short opening statements, so if you'd like to do that, and again, happy for perhaps to start once again with you, please. Or
we might have had the opportunity to discuss beforehand.
Yep, no problem.
I'll start off and then throw to our Legal Director, Heather Corker. We will keep it brief, though. Thank you, Madam Chair, for the opportunity to appear here today and to the broader committee. Equality Australia is a national organisation dedicated to equality for LGBTIQ+ people, and part of our work focuses on ensuring that our communities have a fair opportunity to form families and raise children free from discrimination in safety and dignity. In recent years, Australia's seen a steady growth in LGBTIQ+ parented families, otherwise known as rainbow families, and LGBTIQ+ people are a significant and growing proportion of users of ART and surrogacy. Just to quickly paint a picture of the diversity of families in New South Wales today, 1 in 3 lesbian couples have children, with about 4% of ART cycles undertaken by these couples. Around 14% by solo parents, many of whom are LGBT+, and around 1 in 3 surrogacy arrangements were for gay couples, and of these, around 80% were family or friends. And when you specifically look at donor conception, LGBTIQ+ people and solo parents are in fact major users, making up to 90% of cycles involving donor gametes, 36% are lesbian couples. So the point I make here is really that we are major stakeholders in this policy area. So we made a detailed submission to this inquiry. We welcome this inquiry, and that covers barriers to access, how ART and surrogacy laws can be improved, but also we made a supplementary submission that deals with a specific point that our Legal Director, Heather Corker, will go into. But all of the issues we've raised in our submissions really come to the same underlying point, which is that the law in New South Wales hasn't kept pace with the diversity of how families are actually formed. And the reforms we're proposing in our submissions are practical and evidence-based, that improve access, reduce uncertainty, and ensure that children are legally connected to the people who are raising them from the very start. And that's what's most important. I'll hand over to Heather now to continue our opening statement and go into a bit more detail on a couple of those points.
Thank you very much, Anna. So firstly, as you've already heard about today, and I think also yesterday, the current 5 women per donor issue. So there was a reinterpretation last year by the government to apply this limit worldwide, not just within the state of New South Wales. And this has had an immediate and severe impact. It's virtually ending clinic facilitated donations within the state. The costs I'm hearing about are pretty terrifying, tens of thousands of dollars for a donor sperm allocation. The lowest we've heard about is about $14,000 per family, highest is around $55,000. It's a terrible outcome not only for families who are facing uncertainty, delays, and in some cases a loss of ability to proceed with any treatment, but it's also not a good outcome for donor-conceived children either. We know that when access to care is restricted, it pushes people outside of clinical settings where there's fewer medical and legal safeguards, likely reduced access to information about genetic origins, vital health information about the donor, and there's no limits at all on sibling numbers. So it's important to recognise that not all known donors are the same. Many are trusted family or family members or friends, and all these arrangements can be safe, intentional, and very well supported. But at the same time, there is a growing network of unsafe, unregulated donation occurring outside clinical settings, often facilitated through social media platforms, essentially between strangers. The law was already a problem as drafted. It's built around the idea of counting women, recipients of sperm or egg donations, but many families don't fit that mould. So not including single men or gay male couples, for example. That's already created some confusion about how the law is supposed to apply in New South Wales. It can lead to arbitrary and harmful outcomes, for example, families being unable to have siblings using the same donor if one parent enters a new relationship, or perhaps a gay couple uses 2 different surrogates. That's going to take up 2 of those allocations. So the solution has been raised by others. It is to replace the current rule with a family-based limit applied consistently regardless of family structure, ideally applying at a national level. We note that Queensland laws have recently done this. It's a 10-family limit Australia-wide, but Victoria, South Australia and ACT also have 10 family limits. And one of the reasons for this is balancing ensuring that there aren't excessive numbers of donor siblings created within geographic areas. So looking at the probability of people meeting and forming relationships inadvertently is one consideration. The other is that once you need to get the balance right between in relation to supply, and 10 families within Australia seems to have actually been meeting the requirements. It's only once you go down to 5 within worldwide that's when we seem to have real problems with donor shortages. The second issue is in relation to presumptions of parentage, where there's quite significant legal uncertainty in New South Wales about who is recognised as a parent in families formed through assisted reproduction. The current provisions rely on outdated and highly gendered language and only clearly recognise a pretty narrow set of family types, and that does create some ambiguity for many families, including trans parents, solo parents, as we heard from before, and co-parenting arrangements as well. And really at its core, the law just needs to be updated to ensure it reflects intention at the time of conception. So we need clarity that when a person is acting as a donor, they shouldn't be presumed to be a parent. And when people intend to raise a child, they should be recognised as parents from the outset. Finally, surrogacy laws are out of date in New South Wales, as you have heard of through the session so far. Recent changes to the Equality Act have unfortunately not been working in practice. So the post-birth order system is the first major concern. So currently intended parents must wait between 30 days and 6 months for after the birth to apply for a parenting order. And at that time, the surrogate and sometimes also the partner remains the legal parent despite never intending to raise the child. This leaves children in a legal limbo at a critical time and creates unnecessary administrative burdens, including for medical care and obtaining passports, and places a burden and responsibility on surrogates that they didn't seek to hold. The evidence doesn't support the assumptions that's underlying this delay, that surrogates are likely to change their mind. In reality, the evidence overwhelmingly suggests that surrogates worldwide, when asked about this, don't see themselves as the child's parent. And the chance of this occurring doesn't justify suiting all of the laws around that rare chance that it will occur. Instead, we think the law should allow for recognition of intended parents from birth or immediately after, with appropriate safeguards to prevent coercion. To be clear, we're not saying that this should influence the rights to bodily autonomy of a surrogate. It should never be compromised with the change of law. And there are certainly safeguards that can be put in place to ensure that in that rare circumstance that a surrogate does change their mind, that there can be a matter heard before an appropriate court to sort out any disputes. The second issue is the prohibition on compensation beyond reasonable expenses. This does mean in practice that surrogates can be left out of pocket for undertaking a significant and demanding role, and meanwhile every other party in the process is paid. We do support a regulated model of compensated surrogacy, which is not the same as commercial surrogacy, one that does allow for capped payments, recognising the surrogate's time, the risk they take on, and their labour, whilst maintaining strong safeguards against exploitation. Finally, there's the reforms in the Equality Bill, which were designed to allow families who had children through international surrogacy to obtain legal recognition of their parentage. As we heard from in relation to Ashley Scott in the previous session, there are several technical drafting issues, which means that it's not working currently. Sarah Bevan from Surrogacy Australia will talk through this in more detail. Thank you very much.
Thank you. Maybe to you then,
It is
that probably works.
Thank you. I am a lawyer practicing here in Sydney. I practice throughout Australia and advise Australians who are engaging in both domestic and international surrogacy arrangements. I'm also a specialist family lawyer, accredited specialist family lawyer, so I deal with the other end when people have issues that arise, particularly to do with parentage issues. Surrogacy Australia is Australia's peak body, in fact, only body that deals directly with providing surrogacy services. Its mission is to enhance the understanding of and access to best practice surrogacy arrangements through three arms: education, support and advocacy. Surrogacy Australia is focused on surrogacy in Australia, as the name suggests. You've heard from many other witnesses that the preference, the overwhelming preference is for people to remain in Australia. I won't go over some of the issues that other witnesses have addressed in detail, but clearly, shortage of surrogates is one of the primary barriers for people engaging in surrogacy in Australia. Two primary ways to address that. One would be the compensated model. There's been a lot of discussion here about the terms commercial and compensated. I would suggest that our current system that is called altruistic is in fact commercial for everyone except for the person who is, as I like to say, actually doing the labour. Quite literally the labour in the vast majority of cases, she is giving birth to the child. Everyone else is commercial, not her. The argument is that her currency is time, friendship and love. And that is what Surrogacy Australia helps people with in helping fill the surrogate's cup. What the argument is in relation to compensated models of surrogacy is to reflect the time, effort and risk that she is putting in to create life. There is no way that any person could ever put a dollar figure on a child. That is not what is being talked about in terms of compensation. It is about the time, effort and risk that she is putting in and giving some, what would have to only be a very superficial payment for that, because there's no way you could ever really quantify what that is for her. Education and awareness is the other part of dealing with surrogacy accessibility in Australia. Once upon a time, IVF was something very unknown and very rare. Surrogacy is something that is just not out there in common parlance and is something that so many people, so many women, especially heterosexual women who go through round after round after round of IVF, suffering knowing that it is likely to fail yet again, and yet she has to go through so many rounds before she is finally deemed an eligible woman to engage in surrogacy, if in fact she even finds out about surrogacy. One of the other barriers that I don't think any of the other witnesses have talked about with regard to surrogacy in Australia is about the support that's available. One of the reasons that some people head overseas is because the agencies, the good agencies, provide a central point for engagement with the surrogate, central point to project manage all of the moving parts. We don't have that in Australia, and people are left out on their own to manage the counselling appointments, the legal paperwork, the arrangements they have with their surrogate directly, and then importantly, if difficult conversations come up during the pregnancy or during the arrangement itself, to be that middle person who helps ensure that the arrangement can proceed without undue awkwardness that often comes around the discussions to do with money. Surrogacy Australia, one of the things that Surrogacy Australia is provide a support service. It provides a number of services. Some are free. In fact, the majority are free in terms of all of the webinars and the resources that are out there available to people. But it also provides for a paid service, which is a support service for teams that are formed to access counselling without the surrogate having to go cap in hand to the intended parents for payment of another counselling session if she feels she needs it. The other big heading that I would like to address is parentage recognition. As you've heard from Heather there and from other witnesses, there are significant gaps in what came out of the Equality Act, unfortunately. Ashley Scott was mentioned during the debate and his family. His family was formed many years ago. His daughters are now in their early teens. There are numerous barriers to him and his husband being able to obtain parentage orders, just like there are with so many other parents through surrogacy. They're many and varied. The primary ones are the requirement of an independent report at Section 17. There is the out of time requirement under Section 16 that requires an exceptional circumstances test, and recent Supreme Court decisions have indicated that exceptional circumstances test is in fact a high bar, as we know it is a high bar in other jurisdictions. It wasn't really until some recent decisions last year to do with exceptional circumstances. There are other issues such as the consent of the surrogate. If the surrogate is long gone and you can't find her, then you've got an exception. But if you manage to find her and she refuses to do so, then you've got nowhere to go under our current provide the consent. You've got nowhere to go. There's also the issue of, in overseas jurisdictions, surrogates partners are not commonly part of the process, but our law requires them to be so. And that's been, even with the current parents who are going through, that's been one of the real touch points of difficulty. Heather has also discussed, and as other witnesses discussed, the need for an administrative process for the parentage transfer, or parentage recognition, sorry, not transfer, so that a baby is born with the intent of what this child's reality is, which is that its parents are its parents. And that should be from birth, with, of course, provisions for a surrogate to make an application if need be. So the default provision should absolutely be, through an administrative process that happens pre-birth, that the parents are recognised as the parents and the child's reality is recognised as its reality right from birth.
Thank you. Ms. Special.
Thank you. So I'm the Principal Solicitor at the Inner City Legal Centre. We are a not-for-profit community legal centre offering free legal services to those most in need in Sydney's inner city, eastern and northern suburbs. In addition to our catchment-based services, we also have a number of specialist legal services that are available statewide. One of those is New South Wales LGBTQIA+ legal service. So ICLC supports the submission that domestic compensated surrogacy, when supported by robust regulations, should be legalised in New South Wales. We would also support there being a model national framework for surrogacy arrangements. Surrogacy is an invaluable form of family planning for those who cannot otherwise have children, including people with infertility issues, same-sex male couples, trans and gender diverse people, people who do not wish to carry children or who cannot carry children, and single men. However, the restriction on compensated surrogacy arrangements significantly reduces its accessibility and increases the prevalence of people pursuing more unregulated methods of surrogacy, such as international commercial arrangements. The legalisation of a regulated form of compensated surrogacy will make surrogacy more accessible for intended parents, reduce rates of international surrogacy arrangements, and appropriately acknowledge the contribution of surrogates while still providing for the rights of intended parents, surrogates, and children. Improved access to surrogacy in general, including compensated surrogacy, is also one way to address differences or disadvantages suffered by the LGBTQIA+ community in building families, in addition to assisting people who otherwise have fertility issues. I've had the benefit of listening to the opening statements of my fellow witnesses, and they have covered off pretty much every other area that I would raise, and I certainly support everything that they have raised, including that really in the current surrogacy process, everyone except the person who is doing the labour really does seem to be commercially compensated. And I think that's something that really does need to be addressed. And I would definitely support a national model framework. Thank you.
Fantastic. Thank you. So the committee's resolved to equally split the time between opposition, crossbench and government members, noting for the crossbench Dr. Conn's online. We've got about 34 minutes, so we might just do one round each just so members are aware rather than two, which is as we've been doing. So we have about 10 minutes or so. So we're going to start with Mrs. Carter.
Thank you all for being here, and thank you for being online. A commonality, I think, with the submissions now and the ones earlier is I think the desire to have certainty in what are now legal altruistic, and if that changes, other surrogacy arrangements, and so there's no gap for the child. But how do we have a pre-birth agreement but also respect the agency of the woman who's carrying the child?
I would say the pre-birth arrangement is the default provision. There would then be the ability for the surrogate to make an application if for some reason she chose to do so.
To whom would she apply?
Currently, the jurisdiction is held by the Supreme Court in the Equity Division.
I'm just trying to tease out the reality of this.
Yep.
You've got a woman who, postpartum, very conflicted, very hormonal, and you're basically saying you have to go to the court to keep your baby. Is that really the sort of arrangement we want to set up?
That's working from the assumption that surrogates wish to keep their babies.
I accept that this may be a 2% situation, but we can't pass laws that ignore that 2%, I think. And especially when that 2% deals with respect for the woman who's doing the labour and her agency and the reality of pregnancy, that she may well change her thinking if she develops a relationship with the child she's carrying.
Yes, I would suggest it's well under 2% to start with, but regardless, there may be someone.
Yeah.
The reality is, under our current position, if she wanted to keep the baby, there would be court proceedings anyway. So,
sorry, I thought you said that none of the agreements were enforceable, or was that earlier evidence?
Agreements are not enforceable, with the exception of expenses.
So how would who would bring the court proceedings, and what would be the legal basis for that?
The intended parents.
But what would be their legal right to require the child to be taken from the birth mother and given to them?
If it's falling outside of the current state-based surrogacy system, which it would do in the situation where the surrogate wishes to keep the baby, they would be applying as a person concerned with the care, welfare and development of the child under the Family Law Act. So
they'd be suing the surrogate to suggest that she was not a fit mother for the child and they would be better parents?
No, the test under the Family Law Act is the best interest of the child.
But so they would be basically bringing an action saying the best interests of the child are not served by being raised by the birth mother.
Yes.
Am I able to add here
at this
point? there could be further safeguards that you could add. Just to be clear, just because you have a pre-birth order doesn't mean that the intended parents are parents. That could transfer in birth, but also we would also support there being a further process in which an administrative process post-birth, perhaps a reasonable time frame after, a couple of weeks after, to give enough time for the surrogate to allow, basically there's got to be a final stage in which the surrogate then transfers over parentage. That might then account for that, maybe less than 1% of matters where there is going to be a conflict or dispute, because of course not all surrogacy arrangements do go through clinics in highly regulated environments. We do also have traditional surrogacy where perhaps in some rare situations there isn't very clear intention between the parties, so we do need a court system to actually cater for those situations as well.
But I suppose what I'm struggling with, if we have this handover period afterwards, which I think is appropriate and respectful for the woman who's given birth, that doesn't address the problem of certainty at the moment of birth. So
it would to an extent, because actually what we're talking about now is people waiting for, say, 6 to 9 months. And to give you a bit of a picture,
so it would shorten the time frame you're suggesting.
Yeah, extremely shortened time frame from where we're at. So we've even got situations just around applying for Medicare, applying for passports, all these administrative issues. You could shorten that time down way below what it is at the moment.
And if we have compensated surrogacy and this sort of arrangement, if a woman decided to retain her child, would she be required to repay any compensation that had been provided?
The current provisions...
because currently we don't legally have compensated surrogacy. So if we introduce compensated surrogacy and the woman wants to keep her child, does she have to repay the commissioning parents?
We currently have payment of expenses allowed, and if she keeps the child, then there's provision for that to be recovered from her. So it would be similar situation.
So she sort of has to buy the child back from the parents in a sense?
Well, the payments aren't for buying the child. The payments are with regard for her time and effort.
But she would have to pay the commissioning parents if she wanted to retain the child herself.
Based on the way the law is currently provided for in terms of expenses, yes.
Okay, thank you.
And would
I
it all
think
be
that's
dealt
probably
with
more time.
as a matter of contract? So,
so many more questions. So little time. Yeah.
Thanks, Mrs. Carter. There's a lot I want to ask, but I've only got a couple of minutes. I wanted to just touch on the issue of donor limits, because that has come up from a few different witnesses today and also yesterday. And some of the evidence we got yesterday was that effectively there seemed to be a differing way in which New South Wales, the Ministry of Health, interpreted what's in the legislation. And I'm not a lawyer, but there's a few of you in the room. So what is the way to fix this? Is it a ministerial direction? Is it a regulatory change? Is it a legislative change? What could the committee recommend in order to fix this issue? And happy for any or all of you to answer.
I think Heather's well versed on this one, aren't you, Heather?
Yeah.
Yeah, I think because of the fact that there is nothing in the legislation now that indicates that it should be operating extraterritorially, it doesn't actually make sense to make the interpretation that they have just from last year. So the government could just reinterpret it again how it's always been interpreted. It's actually quite simple, and that just needs to be then communicated back to clinics. We would prefer a legislative change though, because we think that a couple of changes need to be made to make it a family limit. Take the complication out of having the donor's family as one of the spots, and just make it a bit more streamlined. So a legislative change would be a longer term and beneficial thing to do, to align it with most other states and territories. However, even today, the New South Wales Health Department could reinterpret it again and say we got this wrong.
Does anyone know sorry, I didn't mean to interrupt, but what happened last year that made it sort of change? What was the catalyst for that, or was it just something that seemed to come from within the ministry?
I'm not aware of what made it change, but I can say that I have seen the impact that it has had on people. We've had a lot of distressed people calling because they might have been entering into donor agreements that now all of a sudden can't be followed through with because the donor may have reached that limit. And it certainly, has a very negative impact. Does anyone else know the basis for
it's fine if you don't. Yeah.
I think some organisation had asked a question of the ministry, and that then prompted consideration of it.
Okay.
Can't tell you who it was though, sorry.
No, that's fine. I don't necessarily expect you to know. I just was curious about it. The other issue I just want to go to is sort of information more broadly, and I think it's in both Equality Australia and the Surrogacy Australia submission, but the idea of having somewhere that is actually, whether it's through a government agency at a federal level, but sort of a one-stop shop for people who are going down the journey into parenthood in whatever their circumstances might be, whether it's going through IVF or surrogacy or all of the different pathways. Do you think that that's lacking, that doesn't exist now when people are getting information from different sources that may not be trusted? And who do you think would be best placed to be, I guess, the bearers of that information, or to run a service like that for the community?
That was part of the discussion paper released by the ALRC last year. They referred to them as surrogacy support organisations, SSOs. The idea is that organisations would put up their hands to fit the regulations. Surrogacy Australia believes that we're ideally placed to be one of those SSOs if that was to be the way forward. The reason being is that people have such a piecemeal bit of information, and as a lawyer, my job is to advise people when they come to me. I have seen situations where I don't think they should proceed, but I have no basis to stop them. I cannot do that. I can give them advice. I can't release that advice to anyone because, of course, it's confidential, but it has red flags everywhere for me. If there was an independent organisation who is providing some oversight, then these rare red flag type situations would presumably be picked up. And on the flip side, that this organisation would be ensuring that everyone is following through with all of the very important counselling and legal advice, so that everyone is placed in the fully informed, fully aware position before they proceed on this very unusual and unique type arrangement.
I think Equality Australia, I think you call for a federal body in your submission. That's your recommendation, to really cover all of the information that people would need.
Yes, there was previously VARTA, which was a Victorian government authority, which was doing a great job. Unfortunately, it lost funding. It's a model that New South Wales could also consider if looking at state-based options. They not only had the donor register, they also provided evidence-based information to families, to donors. It's really critical. Something that was said in the previous session from Christy from Donor Conceived Families Australia really resonated with me as well. So as someone with a donor conceived child and going in firstly to counselling, imagining I was going to be evaluated for how good a parent I was going to be, sort of dispelling all of that, and also I really wanted to read the literature on what's best for my child, how to disclose, when to disclose. That sort of material is extremely valuable. It's not sort of held in one central place. In fact, VARTA, like sort of archive websites, the place that sort of people go at the moment. So something state-based or even national would be great.
And I would just add, VARTA provides really important services, as Heather said, to donor conceived families wishing to form, or couples wishing to create families, but also donor conceived adults. Tracking down information about their donor as well, and the counselling services provided. I access those services through VARTA, and the donor conceived community nationally is very, I think, grieving the loss of VARTA. So if there's any way that New South Wales could, I guess, enliven the idea of replicating something like VARTA and those counselling services, it would be very welcome by the donor conceived community as well. Taking my Equality Australia hat off for a moment.
Yeah, thank you. We're moving to crossbench questions now, so we've got Dr. Con who's joining us online. So 10 minutes, Amanda.
Hey, thanks, Chair. Thank you all so much for sharing your expertise with us today. It's been really valuable, and for your written submissions as well. I just wanted to come back to the question of New South Wales legislation. So my question is for Equality Australia, but I welcome anyone to weigh in You've made a recommendation around terminology changes in a number of different pieces of legislation, so the Assisted Reproductive Technology Act, Status of Children Act, the Surrogacy Act and the Adoption Act. And I was hoping you could talk us through the need for those changes and who that is impacting at the moment, that outdated terminology.
Sure, there's a couple of issues. One is about people understanding how the law applies to them and seeing themselves in it. And then there's also the sort of practical implications about the interpretation of laws as well. So in relation to how people see themselves, I think we've definitely heard from many witnesses that the term birth mother does not resonate with surrogates. People don't see themselves as the mother of the child, more a carer of the child that they are looking after for the family until birth. So that would be one of the changes that we'd suggest. But other than that, there's a range of presumptions of who is a parent, which are greatly gendered. So they really only include certain types of, say, heterosexual married couples, but also certain same-sex couples. But there's a range of people that they don't include, including particularly trans and gender diverse parents. It's very hard to see where they fit in. And even in co-parenting arrangements, it's also very difficult. So I won't go into the real details, but we've also provided this to a New South Wales departmental review of those laws as well. So the Presumptions of Parentage in the Status of Children Act and a number of other places need sort of quite vast changes, particularly in light of changes to the Births, Deaths and Marriages Act, which have meant that obviously people are recognised as their gender, but the flow-on effects into other laws haven't necessarily all been looked at this stage.
Thanks, that's helpful. I'm just pausing in case any of the other witnesses wanted to jump in on that question. Okay. I also wanted to follow up with Ms. Bevan. You explained in your opening statement some of those technical issues with the Equality Act in terms of parentage orders and what specific recommendations you would make for us to rectify those issues, whether it's a clarification from the government, whether we need to amend legislation.
It would need to be legislative change, and there's a few things that I would suggest need doing. Number one, there's a difference. There's some parts of it, exceptions are subject to a best interest of the child test. Some are exceptional circumstances test. All of them, I suggest, should be best interest of the child. That is what we are focused on in this area. So to make it exceptional circumstances, which brings in a whole lot of other concerns, is problematic. And that applies to out-of-time applications, which all of the older children would obviously be. It applies to circumstances where people have gone overseas and not complied with one or more of the preconception non-mandatory preconditions. So best interest, in my suggestion, should be extended to, as the test should be extended to all of those considerations. Next is the Section 17 independent report. That's simply not possible to complete when the surrogate is disappeared. So that should be something that has, again, possibly waived on an international basis or able to be waived subject to a best interest test as well. Similarly, the consent of the surrogate should be able to be inferred, and that is domestic and international. On rare occasions, very rare occasions, you have a surrogate who simply throws up her hands and says, look, I'm done, I don't want to have to be doing anything more, and refuses to sign an affidavit. Rules, evidential requirements such as hearsay rules prevent us from being able to rely on her statements to a counsellor or anyone. So we can't infer her consent from that position. Similarly, if she's overseas and you can't find her, or she has said, no, I won't agree unless you pay me X amount of money, again, her consent should be able to be inferred. The involvement of the surrogate's partner when overseas, I think, should be something that we address on a wholesale basis, as in not making that a mandatory requirement. Or in fact, it's a non-mandatory precondition in most circumstances. but waiving that or removing that entirely is what I would suggest, given the differences in our cultures. There also, the trickiest part is where there's a second parent. So in most cases it's two men. One is the biological father and the other is the non-biological father. In the historical cases in India and Thailand, for example, the second dad was never mentioned in any of the agreements because that helped them get over the line and comply with their law. The way our legislation is drafted means that he simply cannot be recognised as a parent under our law as it is. So that requires fairly wholesale changes for that particular issue.
Okay, thank you. And the other thing you mentioned in your opening statement was the question of the surrogate's partner needing to be involved in the process. And I think you mentioned that other jurisdictions don't require that. Perhaps on notice, in the interest of time, can you tell us which jurisdictions do and don't have that kind of requirement?
I'm talking about overseas jurisdictions, and it's pretty much all of the jurisdictions that people go to, or that Australians go to. So USA, Canada, Mexico, Colombia, Georgia.
Okay, so to clarify the issue, it's our legislation requiring a new separate person to be involved in the process who hasn't been entirely, because the domestic legislation over there doesn't require.
That's right.
Thank you. Thanks for clarifying.
Yes.
Thanks, Chair.
Thank you. You do have 3 minutes left if you wanted to ask any more questions, but it's not a few. You're muted, so I'm going to say, I think you're saying no, I think you're shaking your head.
Sorry, my questions have been very comprehensively answered.
Okay, well then we might move to some government questions.
Thank you.
Mr. Dodd?
Thank you. And thank you for coming along today. And thanks for your submissions. They're very comprehensive and detailed. Just on the matter of the content of surrogacy agreements, both the altruistic ones that presently is the case here in Australia, and the ones that are commercial in nature, which we see from overseas, some of which are available, but I've got to say they're not readily available for any particular source or domain where one can go and see the content of them. With respect to the organisations, just one at a time, does the Inner City Legal Centre, do you have examples of altruistic agreements that have been used? They could be template agreements or de-identified agreements that you would be able to, on notice, provide to the committee?
For surrogacy? No.
You don't have any agreements?
We generally refer out to a more specialised service in relation to surrogacy agreements.
So
because
not even any templates that you're aware of that have been used by any clients to...
Not that I'm aware of.
Sorry?
Not that I'm aware of, no.
Not that you're aware of, yeah. Well,
I can take it on notice and have a look.
Yeah, just have a look, yeah. Because we're trying to grasp that if we're contemplating moving from the altruistic to what appears to be somewhere between altruistic and the commercial that we see overseas, what I'm trying to, in my mind, conceptualise is that what would be the content of those, because there seem to be a midpoint from the commercial ones, which I think other witnesses have cited is typically in the United States, which are very comprehensive and detailed. What about Equality Australia? Do you have any examples of?
No,
but I can talk generally what is and generally in an altruistic surrogacy arrangement. And it's not a contract. It is basically a statement of intent between the parties.
Yeah, other witnesses said that,
work through some things such as if there is perhaps a breakdown in partnership between the parents, there needs to be things like, what will the expenses be, when and how will the child be handed over, breast milk or formula feeding, those sort of aspects. We don't see things like a woman can't dye her hair or needs to have a certain number of calories, and we strongly oppose those kind of provisions in surrogacy arrangements. We think there's a simple way.
Sorry,
to
that includes the surrogacy arrangements that are being advanced as the sort of hybrid ones between the altruistic and commercial?
I think what's really critical is that the surrogate retains the right to bodily autonomy. It should be enshrined in New South Wales law, and it is not currently now. And we think that anything that's really about unreasonably controlling a woman's body during the course of the pregnancy should not be an enforceable term in an agreement. And so there would be a way to actually try to get past this issue, which is to create model surrogacy arrangement documents that are essentially something that can be registered. That's actually something I think that the Australian Law Reform Commission will actually be looking at in some detail, but that might actually bypass these very issues around unreasonable terms.
I can also add from my practice as a lawyer with regard to surrogacy arrangements is that there is no one template. There is...
Well, that's not true. I mean, one can find them pretty readily on the internet. And I'm not advancing that I recommend them, but there are various agreements that actually, there's a template Canadian agreement, and et cetera, et cetera. So,
but there's not one template. What tends to happen?
No, but there are template agreements around. That's why I'm posing the question.
Most of the time, it is a...
individual.
It is a lawyer's preference as to how they draft.
Yeah.
And the advice I give my intended parents is, if you are trusting someone to carry the most precious thing you're ever going to have, you're going to trust that she is able to follow medical advice. So the highest it goes in my surrogacy agreements, and most of the ones that I see, is that she will reasonably follow medical advice. That is what the templates, my standard precedent said. Mm-hmm. And there is no reason why it would be any different if we move to a compensated model.
So is the evidence, as sort of just one organisation at a time, that moving to the compensated arrangement is very much setting aside the commercial surrogacy concept, which hitherto has been the basic dichotomy. So this would be introducing, essentially in Australia, there'd be altruistic surrogacy and there would be compensated. So you'd have that would become the new dichotomy. Is that essentially what's being advanced?
I don't think these things are mutually exclusive at all.
Sorry, I'm just trying to be clear. What's being advanced is the introduction, and other witnesses have done it today, of the compensated model, which is not what we have at the moment. It doesn't exist per se. What we understand, the evidence is you've got the altruistic surrogacy and then what's called commercial surrogacy. It's sort of a generic term that's used. My question is that under the proposals that have come forth in your submissions, that you'd have, there's no intention of not having altruistic arrangements. I don't think anyone's saying that, are they? No. So, and they would only receive reasonable reimbursements. And then you'd have a second category, which was the ones that have been advanced, which are the compensated surrogacy agreements. So that would become the basic economy? Or would there be
a different...
Or would there be the option of a commercial surrogacy arrangement as well, where there could be negotiations over what the fees might be or the payments might be? Just so we can see what the proposed landscape is in fact being put forward.
I think the starting point is that most surrogates, even those who enter into arrangements overseas, including commercial arrangements, they are generally motivated by altruistic reasons. So that will be wanting to help a family, that maybe they enjoy the experience of pregnancy and want to experience that again. It's very rare that money is the primary motivation based on the research and asking surrogates about their motivations. So I think that it's actually...
Sorry to interrupt. Sorry to interrupt. I'm not going to questions of motivation. What's being put forward... No, let me finish. What's being put forward is a change in the fundamental framework that exists here in New South Wales. That's what's being put in your submission. And what I'm trying to understand is that do we move from, under your proposition, and this is for each organisation because essentially it's reflected across the three submissions, more or less, that presently there's the altruistic, and then we do know there are commercial surrogacy agreements being entered into overseas. Now, as I understand the submissions, what's being proposed is that there would be a new framework in New South Wales which will provide for the ongoing ability to enter into altruistic agreements, which would provide for payments not other than the reasonable expenses, and then the compensation arrangements. That's just the two. And what I'm asking is, would there be scope for a third category whereby an individual surrogate could seek to engage in payments which are above what is this minimum that I understand is being advanced, would be the base level in the compensated surrogacy agreements?
I think it's the opposite. I think what's being advanced is a cap, so a top level payment as opposed to a minimum level payment.
Okay, well, sorry, if we flip it around then, a cap, does that mean that would therefore prohibit the ability for a surrogate to enter into, through negotiation with commissioning parent or parents, a payment to be paid above that? Is that what that would be?
Yes. Yes.
So surrogates in New South Wales could not negotiate a payment above that. There'd be a figure that would be set, and that would become a minimum and a maximum effectively. Is that what the submission is?
It would become a maximum, so that sisters might agree to not make any additional payment.
Okay, so it'd be just a maximum.
Yes.
But it would be illegal to enter into payments beyond that. Is that correct?
If the law is drafted in a similar way, allowing for that cap as it is currently, then yes.
Sorry, just say that bit again.
Currently, entering into any form of compensated surrogacy in New South Wales is a criminal offence.
Well, except for the reasonable expenses.
Above the reasonable expenses. That's reasonable expenses forms part of the altruistic model.
I do understand that, yeah.
Yep. So if the law was to follow, the legislation was to follow how it is currently drafted, then yes, any payments above the cap would be a criminal offence. I would argue that making it a criminal offence where there are potential grey areas about payments leads to a whole host of concerns and unnecessary stress for everyone involved, the surrogate and the intended parents.
So why should there be a cap? I mean, if a woman wishes to offer herself as a surrogate and say, this is my rate, why should commissioning parent or parents be denied the opportunity to pay above that, what is in effect that maximum?
Well, I think then it's getting to the same policy issues that people have, that it becomes much more commercial in nature if people are negotiating some unknown ridiculous amount. The very few reported cases on surrogacy, one of them involves a case where a woman demanded what in effect amounted to about $250,000 before she would hand the baby over. It was a very out-of-the-box type of situation, and it was some years ago. If you don't have a cap, then there may be much more room for surrogates with less positive reasons to be engaging in the process, and that can lead to all sorts of issues. As Heather's just said, all surrogates in Australia and most surrogates overseas are motivated by altruistic reasons.
But the evidence is very clear from the literature that entering into it for a reason to receive a payment, to receive an actual payment, is a motivating factor.
It's a motivating factor, I would argue, to recognise the time, stress and effort they're going to and risk. In and of itself, I think it's a fairly rare thing.
Well, that's not what the literature shows. But to the point, though, who would set this figure?
Well,
I put in to early witnesses in the previous panel the suggestion that Australian Fair Work Commission set what is a rate which is consistent with the National Employment Standard. So in other words, that's a body which is the premier body in Australia that has an understanding of the matter of payment. So would we be looking at someone like the Australian Fair Work Commission to establish a rate that becomes a maximum rate, which you're saying there would be criminal offences if a person got paid above that, or would it be some other body?
The recommendation is for a national regulator about surrogacy generally. Fair Work Commission may well be experts in certain parts of remuneration, but they are certainly not experts in the unique experience, the unique human experience that is surrogacy. The effort and risk that the surrogate is going to is not simply a matter of turning up to work. It is the risk that she is incurring. So I assume that this national regulator would be the one to set the cap, and I assume that they would seek input from experts, and it may well be that they reach out to the Fair Work Commission for their invaluable input about levels of remuneration, but it's not Fair Work Australia who would be the appropriate.
But just to clarify this, because my time's run out, just to clarify with each organisation, just starting with Inner City Legal Service, do you accept the proposition that the cap with respect to the compensation payment is a maximum payment, and to exceed that payment would be a criminal offence?
I don't agree on criminalisation of any of it.
I agree it should be a maximum payment. Yeah. I don't necessarily agree that there should be criminalisation, but it really, it can be drafted. It depends on how the law is drafted, really.
No, but I'm saying, as a principal position for the organisation, I mean, what you're effectively doing is that you're saying that there should be no payment, and a woman should not be entitled to negotiate a payment above what is set as a minimum / maximum, we'll call it maximum, and to do so, in effect, takes them into illegality. Now, you're saying not criminal illegality. What other illegality would you be thinking they'd be entering into if they passed that threshold?
One option is civil penalties, which is
civil
something
penalties,
that the Law Reform Commission is considering, and I think that the preference would be to apply that perhaps to providers, so those that facilitated such an arrangement, rather than to the surrogate themselves. They may be in a position of vulnerability in that situation. I'm not sure about criminalising, and civil penalties are much more readily, of course, applied to regular, organisations that can be regulated, such as clinics, surrogacy services, lawyers, etc.
So just last two, so on behalf of Equality Australia, your position is there be a cap, there be a compensation payment cap, and that be a maximum, and there is no capacity to negotiate a rate above that. Is that the position?
That is correct.
Yeah, and that's the case for yourself also. Okay, no, thank you.
Thank you. Thanks, Mr. Donnelly. Thank you to all of you for appearing today. I think there might have been some questions on notice, but the committee members may also have supplementary questions that they want to put to you as well. So in that case, the Secretariat will be in touch. But thank you for your time today and for your submissions. And thank you also to the intern who helped with your Inner City Legal Centre. I did read that. So in opposition, we know what it's like to have no resources. So we love our interns, as I'm sure you do too. So thank you. We'll now break for our lunch break, and the hearing will resume at 1:30.
Right, thank you. Thank you.
Excellent. Well, good afternoon, everybody, and welcome back to the afternoon session for the inquiry. I'd like to welcome our next witness, the New South Wales Anti-Slavery Commissioner. Commissioner, thank you for being here. If I could ask you just to start by stating your name, position, title, and swear either an oath or an affirmation, please.
Yes, good afternoon. My name is Dr. James Cockayne. I'm the New South Wales Anti-Slavery Commissioner. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. And would you like to make a short opening statement?
Yes, please, just a brief one if I may. So I'd like to begin by acknowledging the Gadigal people of the Eora Nation and the fact that they have suffered practices that today would constitute modern slavery and continue to wrestle with its legacies. I'd also like to acknowledge that existing legal arrangements in New South Wales create barriers to parenting for those facing infertility. These barriers also particularly impact the LGBTIQA+ community in New South Wales, and I strongly support measures to address these barriers and to support the well-being of families and surrogates in ways that advance the full enjoyment of human rights by all. The regulation of commercial surrogacy is, of course, a complex and difficult matter, and my submission, Chair, focused, as you know, on commercial surrogacy. Excessive reliance on criminal law as a regulatory tool may have counterproductive effects, driving families to operate outside the law. Exploitation is more likely to occur in poorly regulated environments, producing worse outcomes for parents, surrogates, and indeed the children that are born through surrogacy. When poorly regulated, commercial surrogacy may in some circumstances result in violations of both national laws and international human rights law. And poorly regulated commercial surrogacy can expose both surrogates and children born through surrogacy to the risk of modern slavery. Australia has, in those circumstances, a duty under international law to protect the rights of children, including children born through surrogacy, whether that was lawful surrogacy or not, through appropriate legal and regulatory frameworks. At the same time, permitting unfettered participation in international commercial surrogacy arrangements while banning domestic commercial surrogacy is likely, in fact, to encourage participation in less well-regulated offshore surrogacy arrangements, increasing the risks of exploitation and negative outcomes for all involved. Where agreements are entered into overseas, the New South Wales Government's ability to regulate conditions of commercial surrogacy offshore is frankly very weak. It's also very difficult for Australians seeking surrogates to perform effective due diligence on international providers. At the same time, participation in international commercial surrogacy could in some circumstances expose New South Wales residents to criminal liability for violations of federal modern slavery laws, and in some circumstances even New South Wales laws relating to servitude and trading in tissue. So the regulation of domestic and international commercial surrogacy is complex and is properly a matter for the Parliament. And the policy decisions on that aspect of the regulation are beyond my mandate. My role really in making a submission and appearing before you today is simply to advise on the modern slavery aspects of this. I believe that any move to permit New South Wales residents to participate in commercial surrogacy should be accompanied by proportionate safeguards to ensure that those residents are neither contributing to increased modern slavery risk nor suffering potential liability for their own conduct if permissible under New South Wales law. I did in earlier submissions outline a framework that would establish these safeguards, including a submission to a departmental review. But those notions, that framework that I suggested there has, I would argue, in some ways been superseded by the proposal from the Australian Law Reform Commission in its discussion paper, notably its focus on what we might call a whitelist of permitted destinations. And I commend that discussion paper to the Select Committee. Finally, I would simply say that any reform of New South Wales government policies and procedures, and indeed legislation relating to commercial surrogacy, must consider and, where possible, of course, be consistent with regulation at the federal level and in other Australian states and territories. In this regard, it impacts, obviously, important matters of bilateral relations between Australia and a number of other countries, and I have consistently advocated for close engagement between New South Wales and the federal government as a result on these issues. Thank you.
Thank you. So the committee has resolved to equally split the time between opposition, crossbench and government members. So we'll have sort of one session each with you, and just noting that Dr. Con is online. So when it's her allocation, she'll come up on the screen in front of you there. So.
Thank you.
I might just ask a couple and then I'll hand over to my colleague. So thank you for your submission, and I appreciate what you said also in your opening statement, that obviously any decisions around sort of the legislative framework related to surrogacy is a matter for the parliaments. But I thought it was interesting the point that you made, which also was highlighted by evidence that we've received in the course of the last day or so, that if people find that the altruistic option in New South Wales or in Australia isn't available to them and they do go overseas, notwithstanding, you know, the laws around that, that it potentially increases to the risk for the intended parents, but also for the surrogate as well when it's in a poorly regulated country or not having a proper framework. And so I guess what I wanted to ask a little bit more about was, if we were to move to a compensated form here in Australia and New South Wales, in your submission you do call out, I think, having sort of a panel or having a proper process that you could do it, that you could potentially, or governments could look at in a policy sense. Could you talk a little bit more about that aspect of your submission, noting you said it's been a little bit superseded by the Law Reform Commission work, but you know, if we were to do it here, or if the committee was to recommend some changes to a compensated surrogacy model in New South Wales, what do you think would be the frameworks that should be in place to make sure that there weren't any issues around slavery?
Yes, I'm happy to speak to that. I note that in a sense the question, Chair, you've asked is one that's squarely raised also by that Law Reform discussion paper, Law Reform Commission discussion paper. Under question S, for example, they ask a question: what factors should the registration entity consider when determining which destinations should be permitted destinations? For example, should these be destinations with laws that require the surrogate's informed consent, or transparent gamete donation? Certainly, from an anti-slavery perspective, informed consent and voluntarity would be critical questions that any expert decision maker, whether a panel, a minister, anyone else, should be well informed and advised on. That's essentially a research task. So that speaks fairly quickly to the question of resourcing of any such panel. Expertise on the panel, but also resourcing of the research component of any such panel or decision-making entity. Because there are many jurisdictions in which commercial surrogacy is, as a matter of fact, available. Their capacities and the practice of commercial actors changes over time. So this is not something that would be a one-off analysis. It would require either ongoing or at a minimum recurring analysis of risk and of the strength of regulatory arrangements. It would require not only desk review, I would argue, of the laws in place, but also something beyond desk review to understand how those laws operate in practice. It would certainly require an understanding of who in fact is being recruited to serve as surrogates in any given jurisdiction, and what safeguards are in place to provide protections. So there's a possibility one could envisage, and I am obviously speaking hypothetically here, but one could envisage that it might actually require, in some cases, country visits, for example, to visit with the fertility clinics and other commercial actors in that jurisdiction to get a first-hand expert feel for whether those providers are reliable and safe.
Yeah. And I guess that would apply whether there were, as you say, sort of the list of specified countries where, you know, it does sort of fit those criteria, or if there was some form of compensated model here in Australia. It's kind of the same concept, I guess, would be my question.
Yes, in a way, harder to execute though offshore,
Offshore,
for obvious
absolutely, yeah.
reasons.
Yeah.
But I think the underlying principles, the factors that you're looking for in order to green light
Yes.
a provider or a jurisdiction
Yes.
would be very similar. And from an anti-slavery perspective, that question of agency
Yes.
and informed consent is really critical.
Mhm.
Is the surrogate fully informed?
Mm.
Fully informed in a language appropriate to them, at the appropriate level of education and literacy? Are they really understanding of the contract that they are entering into? And frankly, there would also need to be careful thought given in design to what we might call the structural drivers of participation in surrogacy, and how those can affect and even in some cases taint informed consent. So there is some careful design work that would be required here, but I think for executing a set of basic principles that are fairly the principles themselves are relatively easy to identify. The implementation in practice is a little more complex.
Thank you. Mrs. Carter?
Yeah. I'd love to pursue consent, but I fear we don't have the time. I wanted to ask you, a fundamental question about rights and human rights, because we've been struggling with this and how you balance rights of commissioning parents, rights of surrogates. We've heard a lot about rights to a family, and you've spoken about this before, but how is the right to manage your own family, manage your own fertility, decide on your own family, which is a right you exercise over yourself, how is that different to a right to a family, which, if you're facing infertility, either social or medical, must then be a right that you can exercise over the body of another? Do we ever have a right that we can exercise over the body of another?
So I hesitate, Mrs. Carter, because I would not represent myself as an expert on this corner of international human rights law. I think
it's a more fundamental question, though, rather than... Because rights have to be exercisable over... They have to be enforceable against somebody. My right to liberty is enforceable against the government or anyone who would deny me liberty. If I have a right to a family, which is different to a right to manage my own family, then who is that enforceable against? Who can I enforce against to say, you must give me a child in adoption, you must give me gametes, you must give me the use of your womb? Do we ever have those rights?
As the Anti-Slavery Commissioner, I'd probably approach that question from the concept of the right of ownership that is embedded in the international law around slavery, and indeed is central to the Australian legal understanding of slavery per se as the result of a very important High Court decision from almost 2 decades ago. It is illegal under international law to exercise the powers that attach to the rights of ownership over another person. And in the Crown and Tang, there was quite an extensive exploration, including by Justice Kirby, of what those powers constitute. I know that in one of the submissions before you, I believe it was submission 18 from the Special Rapporteur on Violence Against Women and Girls, there is a discussion in paragraph 40 of that submission of the Roman law concept of usus and the use of another person's body. Human rights law works today in a way that multiple rights coexist and interact with each other at the same time. And there is a right for a person to enter into contracts, including for the provision of services. Much manual labour involves the use of one's own body to deliver certain kinds of services. We have a number of complex legal frameworks here in New South Wales and Australia that regulate how you can use your body to provide services in a range of ways, including, for example, on the sports field.
And contract theory assumes equality between bargaining parties, and because it very often doesn't exist, we have consumer law, we have labour law, we have all of those other...
Exactly.
Yes.
Exactly. So I think that the challenge here is for all of you, and not a task I envy you, to develop a regulatory framework that balances those rights and that ensures, I do come back very rapidly to that notion of informed consent in a situation which is structurally unbalanced. And that's where I think, coming back to the earlier discussion, the challenge that arises in offshore context is radically different from the challenge of regulating this service provision in a commercial context in Australia.
On notice, if you're able, because I'm conscious of my time, are you aware of any work that's been done of the way that consent can change during the course of a pregnancy? And is it realistic to assume that informed consent remains the same during a month of fertility treatment and then 9 months of pregnancy?
Happy to take that on notice.
Thank you very much.
Dr. Con, we'll now move to your allocation of time.
Hi, thanks so much for taking the time to give evidence today. In your written submission, you wrote that it's your view that commercial surrogacy is not inherently or unavoidably exploitative. We've had evidence from others that all commercial surrogacy is exploitative, or even that all surrogacy, including altruistic surrogacy, is exploitative. I'm interested if you could talk us through how you arrived at your view that it's not inherently or unavoidably exploitative.
Thank you, Dr. Con. I think this, in a way, comes from the conversation that I was just having with Mrs. Carter around the potential for contracting and the agency of an individual that respects. So there is, in theory, a freedom to contract with one's own services or for the provision of one's own services and the use of one's body in that way. The challenge, of course, is once one steps into the real world from theory. There's an old chestnut that says that in theory, there's no difference between theory and practice. But in practice, there's every difference between theory and practice. And so whatever one thinks of the inherent virtue or permissibility of commercial surrogacy, as soon as one steps into a context of the real world where there are imbalances of power, then that is where the real challenge lies. So I don't think it's inconsistent, or I should frame that in the positive. I believe it's consistent to say that in theory, it is not inherently exploitative to contract for the use of one's own body to provide this service to others. The challenge, however, is that as soon as we step away from the theory, lots of external factors enter into the picture to make it difficult to assure that all of the parties involved in the contracting are exercising agency effectively, without duress or coercion, in an informed way, and that informed consent, as just noted in the question from Mrs. Carter, remains intact, if I can put it that way. I hope that offers an answer, Dr. Con.
Yeah, thanks for clarifying. I also wanted to ask, you talked in your opening statement about the submission that you'd made to the surrogacy review, and you indicated that it's been somewhat superseded by the work that the Australian Law Reform Commission is doing, but I'm interested if you could talk us through some of the things that you had suggested in that submission in terms of a framework that could establish some necessary safeguards.
Yes, I can. It was very simple, to be frank, what we were proposing, and it was by no means intended as a complete answer to the many complex questions here. It was narrowly gauged to address the question of how does one seek to mitigate modern slavery risks to which New South Wales individuals might be exposed through contracting for commercial surrogacy in any context, but particularly offshore. It was a suggestion essentially to have a panel of experts that involved both people with relevant clinical expertise and relevant modern slavery expertise, and of course surrogacy expertise, which could potentially encompass lived expertise, that would conduct a periodic review of specific jurisdictions' regulatory and enforcement arrangements for commercial surrogacy in order to assess whether each jurisdiction met a defined regulatory standard that would achieve three things. First of all, protecting human rights. Secondly, conforming with Australia's international anti-slavery commitments. And thirdly, offering safeguards to New South Wales residents on a number of fronts. And there are a number of areas that could encompass, for example, around parentage. But of course, in my mandate, the focus is on anti-slavery. So I was particularly focused on offering safeguards for New South Wales residents to protect them against unwitting exposure to criminal liability for modern slavery offences. For example, it is in theory possible that you could, after New South Wales law reforms, you could engage in commercial surrogacy contracting that is permissible under those reforms and yet still potentially have liability under the Commonwealth Criminal Code. And obviously that's an outcome we would all wish to avoid.
Thank you. That's helpful. Thanks, Chair.
You do have a couple more minutes if you have any more questions, Dr. Conn, but
Thank you. My questions are minutes.
Sure.
Thank you, Doctor.
Government, Mr. Donnelly?
Thanks. Welcome, Commissioner. Thank you for your submission. With respect to the, I think I sort of the direction, if I could put it that way, of your submission, with the caveat at the end that this is essentially a matter for government and before that policy developed. There seems to be, as I read it, almost an explicit, if not explicit, an implicit thrust supporting, at least in principle, the proposition of a commercial surrogacy framework, however you might call it, in addition to the altruistic arrangements that currently exist here in New South Wales. We had witnesses this morning, and I was trying to sort of draw this out. There's a sort of criticism, blank criticism, that overseas there are these arrangements called commercial surrogacy agreements, and a number of them are sort of riddled with sort of examples of exploitation and abuse if one goes looking for it. And the thesis being developed is that, listen, if only we could get the regulation right, that effectively this would all fall away. These issues, and they are quite manifest across a range of domains about concerns about surrogacy. And you seem to be backing in this thesis that you don't talk in any detail about the altruistic surrogacy, so I presume effectively that remains in place in New South Wales. Is that the case? The provisions to enable altruistic surrogacy would be retained here in New South Wales?
I don't adopt a view on that. Mr. Donnelly, my role in this debate, I think, is to help the committee, the Parliament and the public understand where modern slavery risks arise. I don't see modern slavery risks arising systematically in the altruistic surrogacy context.
Well, I've got to say, that's not the evidence we've received today or from other witnesses that in fact altruistic surrogacy overseas is free of slavery-like arrangements or human trafficking arrangements, if that's your submission.
That's not my submission. I would treat that as commercial surrogacy, where I think we're having a category error conversation, if I can put it that way. I think we're approaching the categories in slightly different ways. If something is presented as altruistic surrogacy but is operating in fact in terms of incentives that rise to the level of exploitations, then in the way I've approached this analysis, I would be approaching that in the context of the discussion of commercial surrogacy, however it may be formally represented.
Is that time gone like that?
No, you can keep going. So you got the last of Amanda's time. You've got 5 more minutes.
But I have to say, going to the point that I was making as we slightly sort of digressed there, your focus is on the commercial surrogacy, but we do have obviously altruistic surrogacy here in New South Wales, right? And under the discussion that's going on that you would be aware of, the question is that commercial surrogacy presently is not legal in its state. So there is discussion then about, well, what might a non-altruistic arrangement look like? And you seem to be edging towards the proposition. And the sentence on page 5 in paragraph 11 was the one that sort of drew my attention. That commercial surrogacy is not inherently or unavoidably exploitative. And what I sort of wondered was that if one looks, for example, at the document of the Special Rapporteur, which was presented to the UN General Assembly, I think it was in October of last year. I think the document was released in July. That commercial surrogacy, as it exists around the world, is rampant with examples of exploitation.
Indeed.
Rampant. But the thesis you seem to be putting forward is that, and I take that not as an acknowledgement that that is the case, that notwithstanding that in a theoretical level, commercial surrogacy, as you say, is not inherently or unavoidably exploitative. And what I don't know is what is the underpinning evidence or reasoning or thesis behind that statement, because there is manifest evidence that in fact that's exactly what it is. Commercial surrogacy is just that, and there's very little evidence that's been brought before the hearing thus far, or the inquiry thus far, which actually provides examples that would otherwise suggest that it's, to use the words here, not inherently or unavoidably exploitative. In other words, there's examples where, in fact, it is, I'll sort of use the quotes, sort of good commercial surrogacy. There just seems to be no evidence of that that's been brought before the inquiry. So what I don't understand is where you're drawing from as an evidence base to validate that statement.
The statement is a statement based in theory, not empirical evidence, if I can make that distinction.
So it's a normative statement.
It's a legal analysis, I would offer. It is an analysis of the legal and basis of...
Sorry, what legal basis are we talking about?
So the statement you've drawn my attention to, Mr. Donnelly, is commercial surrogacy is not inherently or unavoidably exploitative.
Yeah, that's your statement. Yeah.
That's my statement. What I was trying to communicate, perhaps poorly there, is that as a matter of theory, I believe that there is a legal basis for contracting for the use of one's body to provide these services. It's not inherently, as a matter of theory, exploitative to do that. But as I've stated in my earlier evidence, the challenge is that as soon as theory meets reality, we're confronted by much evidence, as you pointed out, that in practice, it does become exploitative, because imbalances of power, coercion, fraud, deception enter the execution. And this is why I say that is a question of policy design and execution properly for the Parliament, because the Parliament is not, if I may proffer this opinion, the Parliament is not dealing with matters of theory alone, but has to make law for the real world. And so the evidence of how things operate in practice in the real world is absolutely critical, and why the committee is, in my view, quite rightly paying attention to that. This mere statement that commercial surrogacy is not inherently or unavoidably exploitative is a statement about how things would be if we were dealing and trading only in ideals, and we do not. And you know from my submission and from earlier conversations I've had with the Parliament in other forums, that I'm quite willing to acknowledge numerous examples of significant exploitation, indeed rising to the level of modern slavery and human trafficking, occurring in contexts of commercial surrogacy. So the challenge here is one of policy design and execution to ensure that something that is not, in theory, not inherently exploitative does not become so. And it is, I think, entirely open to the Parliament to determine, if it so chooses, that there is no reality in which you can, as you put it, get regulation right to reduce that risk to a level that Parliament is prepared to legislate for.
That concludes our time. Sorry, Mr. Donnelly. Thank you so much for your evidence and being here with us today. I think there was at least one question taken on notice, and the committee might have some follow-up supplementary questions for you, in which case the Secretariat will be in touch. But thank you for making time to appear before us this afternoon.
Chair. Thank you, members.
Thank you.
Okay. I will now move to our next witnesses. So thank you, both of you, for being here today. Can I ask each witness to state your name, position, title, and swear either the oath or the affirmation? And we'll begin with Dr. Tobin.
My name is Bernadette Tobin, and I work at the Plunkett Centre for Ethics at St Vincent's Hospital, which is a centre of Australian Catholic University, and I will take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. Professor Somerville?
Yes. My name is Margaret Somerville, usually called Margot, and and I am Professor of Bioethics at the University of Notre Dame, Australia. Samuel Gale, Emeritus Professor of Law, Professor in the Faculty of Medicine, and Founding Director of the McGill Centre for Medicine, Ethics and Law at McGill University in Montreal. And I too will take the oath.
Please.
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. There's an opportunity for both of you to make a short opening statement, if you would like. So I'll once again pass back to Dr. Tobin.
Thanks very much. Look, in my written submission, I concentrated on the terms F, I and J, but thinking it over since then, it strikes me that an inquiry which investigates, among other things, education and information available in New South Wales about fertility and ART, which is a term of reference number C, should involve an openness to what are called fertility awareness-based methods of conception. These methods can be effective. They can avoid the risks and the side effects of IVF. They're much less costly than other methods, and they do expand the range of choices available to people seeking assistance in having a baby. So that was just one point I'd like to make. And the other is this, that I do oppose the liberalisation of surrogacy laws, and in particular any proposal to legalise commercial surrogacy arrangements, whether domestic or international, for two reasons. In my view, surrogacy undermines the rights of the child, in particular the right of the child, the entitlement of the child to know and be cared for by his or her parents. And the second reason is that surrogacy exploits women. Frequently onerous contracts, forced caesareans, poor remuneration, slavery-like conditions. And all that's set out in very good detail by the submission 3 from Professor Patrick Parkinson. Now, 25 years ago, it was the radical feminists who shamed their liberal feminist colleagues on this matter. And today, it's institutions like the UN's Special Rapporteur on Violence Against Women who call for the practice to be abolished, for reasons that no doubt are familiar to you. So thank you for the opportunity to appear before you and to make those opening remarks.
Thank you. Professor Somerville?
Yes, I just would note first that on your terms of reference, I've written this in the submission, there's an assumption that surrogacy is ethical, and I would challenge that assumption, but I certainly think that your committee needs to look into that and see if you really can justify thinking it's ethical. We don't regulate what we think is unethical, we prohibit it. And moreover, a majority voting for something doesn't make something unethical ethical. So that would be my first point. And the main point of all of the things that I wrote here is that for a long time the child has been ignored in all of these absolutely incredible decisions that we have to make about the new reproductive technologies, and we can't afford to ignore the child. It's wrong, and it's not just. And so I would urge you to put the child at the centre of the decision making. And again, there's, back to your terms of reference, there's no requirement in them that the best interests of the child be given priority. Now, in comparison, the Australian Law Reform Commission, which is also looking into this, does put in their terms of reference that it must always be in the best interests of the child. And the other statement I would put on the record is, and this has caused me enormous grief over the years, I've been in this area for nearly 50 years. And right from when it first began, we could hardly believe that you could have a baby in a test tube, as we used to describe it. But what we have to be extraordinarily careful what we do to the child. And the most fundamental question of all is, does a child need and have a right to both a mother and a father, and to be brought up, if at all possible, by their biological parents within their biological family? Now, that can't always be achieved, but I would urge that our basic presumption is that the natural family is the best thing for most children, and as part of the base of our law and our ethics, which doesn't mean that there can't be exceptions to it. There can be, but they have to be very carefully justified. And when you work with basic presumptions, where there's doubt, the basic presumption governs and the exception is narrowly construed. So, I mean, I could go on forever, and I don't want to do that. But this is a very important inquiry, because what we've got on the horizon is the possibility, already the Chinese have developed artificial uteruses. So would that be acceptable? I mean, I think absolutely not. But these are the sorts of things you're going to face. And designing our children, and the transhumanists urging that we go to a post-human future, because we'll be so redesigned that we're not human at all. So I leave it at that. I mean, I could bore you to death.
No, never bore. I'm sure there'll be a lot of questions. So, thank you. Just for your information, the committee has resolved to equally split the time between opposition, crossbench and government members. Dr. Con is appearing online, so when she asks her question, she'll just appear on the screen in front of you, and we will do 2 rounds of questions. So we're going to start with opposition questions, and I might see if Mrs. Carter would like to kick off.
Okay. Thank you both for being here. Dr. Tobin, if I could start with you. I notice in your submission, and thank you, to be honest, I had not thought about looking at the NHMRC guidelines, and so it was an interesting discussion of those guidelines from a very authoritative source. You're talking about the requirement that children born through ART are entitled to the knowledge of their biological parents. And we heard discussion this morning, issues in relation to availability of donor eggs and donor sperm, because we require donors to provide biological details. Is this, if this is causing difficulty with donation, how important is this continuing need for children to be able to understand their biological heritage?
When the NHMRC, through its Australian Health Ethics Committee work, reminded people of that ethical truth, and for the first time put it in the guidelines. Of course, as you would know, draft guidelines went out and people were invited to comment, and mostly people from the industry said this will be the end of donation. It hasn't been the end of donation.
I suppose my question goes to we're dealing a lot with competing rights and competing interests. If we have to choose between the right of an adult to donate anonymously and the right of a child to know their heritage, which has primacy and why?
So when you talk about this right and that right, I don't know whether you're talking about legal rights or a prior ethical notion of an entitlement. And if we're talking ethically, it just seems very obvious that the child's entitlement to know his or her, to have knowledge of his or her parents, takes priority.
If we're talking about rights, there was a question that I raised with a previous...
I'm sorry, I'm having trouble hearing.
Oh, I'm sorry. I'll
Yeah.
bring the microphone a bit closer. I apologise. A question, and perhaps, to both of you, that I raised with a previous witness. We've heard a lot about rights to family. Again, we're dealing with competing rights of birth mothers, rights of commissioning parents if we're speaking surrogacy. What I'm trying to understand is, does the right that we recognise to manage our family, to have children when and where we wish, space our families, decide when our families are finished, does that right include an objective right to have a family? And I suppose what I'm trying to tease out is a right to manage one's fertility is a right you exercise over yourself, whereas if for whatever reason you are infertile, a right to a family must involve a right that you exercise over somebody else. And I'm just wondering whether we can actually ever say that we have objectively a right to a family that government, society is required to fulfil for us.
I would challenge that there's a right to a family. I would say that there's a privilege to have a family. I would also argue that there is a right not to be prevented from having a family. But then you get into what constitutes preventing having a family. And then I would argue, because, for example, if you wanted a legal basis for the UN Convention on the Rights of the Child, clearly sets out that the child has got a right to a family, and preferentially their own biological family, and at least to know where they came from. In the early days of artificial insemination and ovum donation, there wasn't as you know, it was anonymous. And I can remember, I was still living in Canada at that time, and I remember coming back to Australia, and indeed I think it was in this Parliament that I appeared before a committee considering the same issues. And I would argue, I couldn't believe what I heard from the young people who were a group of young women who'd founded an organisation called Tangled Webs, which was for people who didn't know who their father was. Mainly it was sperm donation in those days. And they were devastated by this. And it really, I know we've changed that. We learnt from that, and we've got open, I understand we have an open identification now. But these things can happen, and we don't realise what the problems are until they occur. And as I put in an example in my submission, I can remember being here with Joanna Rose, who was quite a famous early person who objected to the fact that she couldn't find out who her sperm donor father was. And one of the people on the committee said to her, I don't know what you're complaining about. You wouldn't be here beating up on us if that hadn't happened. And I heard that, and I thought, I have no idea how you could reply to that, because it was true. If the donation hadn't been made, she wouldn't be there going berserk. And she came up with the most brilliant answer. She said, if I was the product of rape, I would be glad to be alive. But that doesn't mean that I approve of rape or think it is ethical. So I think, and we can't have competing rights. We've got to either say the adults have got a right to have a family, or the child has got a right to have certain kind of parents. And we've got to make up our minds which of those we give priority to.
Yes, Dr. Tobin.
I think it's not helpful. In fact, I think it's a mistake with respect to conceive the problem as a matter of rights. On the one hand, you have a child with certain needs which ought to be met insofar as they're possible, and I'd say knowing one's biological parents ought to be understood, knowing them and being cared for them in terms of the child's needs. On the other hand, you have desires of adults, and I don't dismiss them at all. I know of the grief people suffer who really want to have children. But with respect, I think it's misconceiving the whole issue to talk in terms of rights that have to be balanced, or one's got to take priority over the other.
Okay, thank you very much.
We move to Dr. Con online.
Good afternoon. Thanks to both of you for making the time to appear today. My main question's for Professor Somerville, but I'd be happy for you both to weigh in. You've argued strongly that the child needs to be at the centre of decision making and made a very strong argument to support that. But in your argument to therefore restrict or prohibit surrogacy, I suppose, how do you reconcile that with the very significant body of peer-reviewed evidence now, including longitudinal research tracking children from birth, showing that children conceived through donors, regardless of means, actually do very well. The research has shown that long-term outcomes for those children are much more strongly linked to the quality of the relationship between children and their parents, their family, than their means of conception.
I'm sorry, I don't understand the question. You asked me how I reconciled what?
Yeah, so if we accept your argument that we must be putting the child at the centre of decision making, the scientific evidence base is very clear now from decades of long-term research looking at children's well-being, that children who are donor conceived do very well. They thrive when the family who raise those children is loving and supportive. So my question is, in the context of that evidence, how do you then make the argument that these kinds of arrangements should be prohibited for the purposes of the best interests of the child?
I don't know that evidence. I see it referred to every now and again. I'm not so confident about it, but the honest answer is I don't know it. But it's not inconsistent to say that a child needs to know and be cared for by his or her biological parents, if that's possible, and there'll be situations where it isn't, and to say that something else that matters is that children are brought up in the context of a loving and caring relationship of adults looking after them, even an adult. So I don't know that we ought to be confident that one thing is more important than the other. Both are important.
Okay, and thank you for your answer. And what I'd put to you, I suppose I'm giving you the opportunity to respond to this research that in my view is contradicting what you're saying. That longitudinal research, which has been provided to us by other contributors to this inquiry, showed that those children conceived by donors or assisted reproductive technology do very well whether or not they have contact with their donor. So that evidence-based research, I suppose it contradicts what you're saying, regardless of whether or not they have contact with what you're calling their biological parent. So on what basis are you making that argument, or can you point us to any research that supports your assertion that connection is important?
With respect, I don't think even if that research is reliable, I don't think it contradicts what I'm saying or what Dr. Somerville is saying. It's another factor as well.
Okay, and are you able to point us towards any research that supports that the well-being of children's improved through that direct contact with a donor or in your words, a biological parent?
So some things are matter of empirical research, and some things are matters of normative research. When I was talking about the child's entitlement to know and be cared for by his or her biological parents, I was talking normatively. I wasn't making a claim that could be falsified by empirical research.
But I think the other thing we need to add there is not just what is the impact on the child, important as that is, but what does it mean that we are facilitating creating families where the child doesn't have two parents of one of each sex? And what does that do to certain values on which we base our society? This has got other ramifications other than just on the child. And again, I would stress that I would promote a basic presumption that a child does have a right to both a mother and a father, but there can be exceptions to that. What those exceptions are would have to be worked out.
Okay, thank you.
That's it, Chair.
Thanks, Chair.
Yep. Mr. Donnelly.
Thank you, Chair, and thank you both for coming along this afternoon and for your submissions.
Greg, please talk up.
Oh, I apologise. Is that better?
Yeah, that's better.
The first questions go to matter of definition and how the question of the meaning of surrogacy has altered. And I then want to take you to some evidence we've received thus far that you may not be aware of and explain that, and then ask you a question about what you think. Now, looking back historically, there was the idea of surrogacy and in fact, in going back in time immemorial, the idea that there has been surrogacy and it has existed. But then in recent time, and I'm meaning in the last 50 years to take a period of time, we've had the creation of this idea of altruistic surrogacy and commercial surrogacy. And with respect to the altruistic, it's manifested itself in laws whereby there is no payment for acting as the surrogate, but there is a payment for reasonable expenses. And that's the notion of altruistic surrogacy that we have in this state here and in other states and territories in Australia. The idea of commercial surrogacy is the other alternative or option that hitherto has existed, where there is a payment to the term I often use, a gestational carrier, to be paid an amount of money to carry from the placement of the embryo into a uterus through to the 9 months in giving birth, and a payment for that. So we've had the altruistic and the commercial surrogacy. And with respect to where we are today, which I'm finding from the evidence that we've received just over the last day and a half, is that it's evolved further. This is the proposition here in Australia that some are advancing, is that we have still altruistic surrogacy where there is no payment except for reasonable expenses, but there's this new concept called compensated surrogacy, whereby there is no payment except for reasonable expenses, and also what is effectively a fee on top of that which would be somehow established or mandated by government or by regulation as an amount paid for the service. And then there still would be this third category of commercial surrogacy that could be entered into overseas. Here, in other words, Australians could travel overseas. I'm just wondering if you'd like to comment on your thoughts about the challenge of dealing with a evolving concept that gets away from the reality of what the practice of surrogacy is and some of these fundamental questions you're speaking to in your submissions, and trying to deal with the changing nation of the terms being used to define the practice.
Yeah. There is a provision in the French Civil Code that says that some things must be, in French, hors de commerce, outside of commercial activity, because the commercial activity destroys the innate function and nature of those things. And Michael Sandel, who is a professor at Harvard, has written a book where he looks at parents' relationships with their children and what the non-commercial nature of that is, and that how turning it into commerce, the word is desecration. The other way you could describe that is that I would call it the secular sacred nature of it, that the bond between parents and children is something that must be held on trust and not laid waste. Treating something as secular sacred means you do not lay it waste, you protect it, and you don't do things to it that can diminish what it is and its power of values. And so that's where I would put the bond between parents and the children that they have. And there's this concept of the unconditional love of the parent, simply because the child is their child. And that cannot exist, for example, in the area of surrogacy, or indeed even in ovum donation or sperm donation. Those people have got no idea that they want to look after that child, or that there's a bond between them and that child. So these are the upper level issues that human reproduction raises, and we need to keep in mind that societies have always formed their most important values around the two great events in every human life, birth and death. And we are currently in the progressive values era debating whether we're going to hold those values intact as we've always understood them, that parents automatically, unconditionally love their child, and that we don't introduce, for example, euthanasia in medicine, because that's not what doctors do. And again, there's a problem with that. Or are we going to change those values and say, well, we don't want to be bound by those anymore. We want to change them. We've got to be very, very careful if that's what we're going to do, that we don't cause incredible damage.
Mr. Donnelly, I shouldn't say anything at a parliamentary inquiry in an area where I'm completely ignorant, and I'm practically completely ignorant about this evolution in the notion of surrogacy from altruistic versus commercial through to this new thing, compensated. So I wish I had done a bit of work on it. If I can tell you off the top of my head, that sounds like commercial surrogacy to me. Being organised in a different way, and I don't know the details of it except what you said then, but I'd be highly suspicious. I'd want to know who was putting it forward and what their interests were in it. But that sounds like commercial surrogacy itself.
An interesting new term that was being proffered, but in effect, if you look at its component parts, what is effectively the reasonable costs or the reasonable reimbursements, and then on top of that put an amount of money and then argue it should be capped at a maximum amount, that in effect was still a commercial surrogacy arrangement. But if we just, can I move on? Is it just,
Yeah, no, please.
The best interest of the child was, I think, raised by both of you in your contributions in your opening statement. What's come through, and it'll be in the Hansard from witnesses from yesterday and today when it becomes available, is this emergence, and I don't think it's something which has just happened, in looking at this matter of human reproduction, that the best interests of the child, there's a centrality to that which has always historically been understood as being very, very important. To a newer idea, and particularly this is in the context of surrogacy, that the matter of the best interests of the child doesn't sit in a preeminent position, but rather sits in what is essentially a tension that's, or an equilibrium that's maintained, or should be sought to be maintained through a contract, where you've got the surrogate who is carrying the unborn, you have the baby, the product of the surrogacy arrangement, you have the providers of the gametes, you have the commissioning parents, and all of that has to be held in tension to get an outcome that is satisfactory for them all in a normative judgment. So you take away the best interests of the child and you place it in this line of other needs that need to be met and satisfied. In other words, the best interests of each of those categories. Do you have a view, and I'll pose this question to both of you, that is it realistic, or in fact is it just simply a pipe dream, that you can put all of those categories, the surrogate, the baby, the provider of the gametes, the commissioning parents, put them all together and say you can create an outcome where everyone's interest is being met, and that's the best way in which we should proceed in dealing with surrogacy?
I would just like to raise a comparison. The nearest thing to paying for surrogacy is actually buying organs for transplant. And we have prohibited buying organs for transplant as denigrating of humans, as unjust because only the poor sell and the rich buy. And all of the objections to paying for organs for transplant, those objections all apply to surrogacy. Only the women who've got no other access to funds to look after their family, and only people who can afford to pay a lot of money to have a child carried by a surrogate mother, because it isn't always women who can't have a child. There is increasingly talk of women who don't want to interrupt their careers by being pregnant. So we've got to think much wider than just the one couple or a couple of people that are involved in this, and really think, well, it's not a big deal, there's not so much. This affects some of our most important human values. And the commodification, making people into things that you can buy and sell, whether it's the baby or whether it's your kidney or whatever it is a huge step. We abolished slavery, and there's concern that this brings back some of the aspects of slavery and the reasons why we fortunately abolished it.
Thanks, Mr. Donnelly. So Dr. Conn has no further questions, so we'll just divide the time left between opposition and government. Oh, sorry, did you want? Sorry, Dr. Tobin. Yeah, please.
Well, again, I'm highly suspicious of that move. the one party to the arrangement who has no say is the child. That's relevant. Secondly, children need, if at all possible, to be loved and cared for, and thus to know their biological parents. Of course, there are others involved. There are people who can't have children who desire to, but just by saying that is on a par with the needs of the child doesn't make it so. And I guess that the committee will have to do some work on what the notion of the best interests of the child means, both ethically and legally. And in that regard, again, I'm just thinking of it now, there's very valuable material in Marion's case in the High Court, and some work that it relied on too, which really gives some substance to the notion of what's involved in looking after the best interests of the child.
Thank you.
Just on that, and I'll stay with you, Dr. Tobin. I was interested in your submission, I think it's paragraph 8, but you talk about, obviously it's up to the committee to deliberate in terms of any recommendations that we make, but you say that if there was a recommendation for the legalisation of commercial surrogacy, that it should ensure that the biological origins of a child are always accessible by that child. I just wonder if you could talk to that a little bit more. Obviously, you've spoken about the rights of the child and the sort of ethical arguments about that separate, but for people who do go down a surrogacy pathway, whether it's altruistic or commercial overseas, can you talk to why you think it's important that the child understands their origins?
What I'm referring to is what we found when we were doing the work 25 years ago on the NHMRC that was referred to earlier, and the needs expressed by donor-conceived adults to know the identity of their biological parents. There was an area of great suffering, loss, a sense of not really knowing who they were, a sense that a terrible injustice had been done to them. And at that time, there were different voices in that debate, and people spoke for the desirability of the donor being anonymous and the so-called rights of the donor. But it just seemed obvious that that an injustice had been done to those adults, and it was one that needn't continue. And if I can just add, when we published those guidelines, we heard from bioethicists around the world acknowledging the Australians were first to get that right. Now, it doesn't change things elsewhere and immediately, and it certainly doesn't change things in the States where, commerce reigns. But we were very struck by their sense of a terrible injustice having been done to them.
Thank you. I'll hand back to Mrs. Carter if she's got more questions.
Thank you very much. Dr. Tobin, if I could go to you, I'm interested again in your submission and your reference to the NHMRC guidelines. We were talking with earlier witnesses about what, how and if appropriate limits could be put on commercial surrogacy, but it's interesting to note that the NHMRC guidelines say that commercial surrogacy, where the surrogate receives financial compensation above and beyond expenses associated with the surrogacy procedure and pregnancy, is ethically unacceptable because it raises concerns about the commodification and exploitation of the surrogate, the commissioning parents, and any person born as a result of the surrogacy arrangement. Is that argument about the inherent risk of a commercial arrangement commodifying children, is that argument still relevant today in your view?
Yes, I think it is, and I'm very struck by the fact that the NHNMRC itself still thinks that it is. The work that I was involved in, as I say, it's 25 years ago now, and some things have changed. But it's striking that you would know that the NHNMRC or the Australian Health Ethics Committee comprises a wide variety of professions and people with different views, and yet they are still of that view that this should be prohibited. And you'd know that that RTAC, the Reproductive Technology Assessment Committee of the Fertility Society of Australia, requires its members to follow our guidelines. And there's always pushback from them, but in the end, whatever comes from the NHMRC, they do accept. So I'm just very struck that there's no movement on that. And it seems to me that there's an increasing understanding of what a terrible thing commercial surrogacy is. Mostly people focus on the injustice to the surrogate mother. I've been, in my own submission, focusing on the injustice to the child.
Oh, thank you. In terms of commodification, I'm aware of examples from, the classic example is the Western Australian baby gammy example. We heard some interesting evidence this morning about risks of commissioning parents not taking surrogate-born children and also risks of the child not being delivered at birth. If we accept the idea that we are purchasing the services of somebody to create a child, does that then import into that process, consumer warranty ideas that we are purchasing a child that will be healthy, will have all 5 senses, will not have any birth defects? Is this a risk? And then what happens to those children who don't meet the commercial standards?
I think you've got to ask, though, if you allow whatever it is you're going to allow, what else does that open up? And think about when you talk about, or when I talk about, the child has got a right to their biological family and to live in that and grow up in that. That doesn't just involve the parents. That involves your brothers, your sisters, your cousins, etc. And I don't know whether you saw just in the last few weeks, there's been a disclosure of a young woman in Brisbane who found out that she's number 78 of there's 77 young people who've been conceived with the same sperm as was used to create her. Well, what does that do to your concept of who's your brother, who's your sister, who are your grandparents? What is your line of life travelling to you? And people want to know that. And even lately I've been thinking about how people want to be buried in somewhere where they're with people to whom they're related. I went to a funeral here recently, and all of these areas where it's this family and that family, more perhaps in some European cultures than in our Australian one. But I think that's important, and we can't just we can't decide we're going to take that away from certain people because you want a child created that you can have. And just to add for the new technology stuff, the Chinese have recently been able to make a sperm, that they can use from anyway, they were able to breed 2 male mice so that you got a viable mouse child out of that, and that viable mouse child was actually fertile as well and could pass on the genes. So this is tiny little stuff at the bottom of what is going to become enormous and very difficult decisions.
Can I just go back to you quickly, Dr. Tobin? So do I understand that if we recommend whatever, but if the NHMRC guidelines are still requiring fertility clinics to observe their guidelines, that the NHMRC guidelines would trump any recommendations we made in this parliament, or complying fertility clinics would have to comply with the NHMRC guidelines?
Look, again, I'm out of my depth,
Sorry.
but I think...
I understood you to say that, and I just wanted to check that.
No, I think it would go the other way round.
Right, okay, okay.
But can I make a comment on your earlier question, the language of creating expectations that the child will come up to certain standards and meet certain warranties and all of that? All I wanted to do was to contrast that language with the language of a child as a gift. The philosopher Raymond Gaita says that we know and understand the truth of that language, even those of us who don't believe in a giver of that gift, that is, even those who are agnostic or atheist. So the language that you used then and put to me, how far away it is from the idea that the child comes along as a gift, and the parents will care for that him or her, however that child is. So it's a long way away.
Right. Thank you very much.
Mr. Donnelly, there's 10 more minutes
Thank
remaining.
you. Hang on.
Yep, all yours. Yep.
One thing that struck me with a number of the witnesses thus far, and we're into sort of the afternoon of the second day, is, I don't mean to be provocative, but a sense of, if not disregard, at least a degree of blindness, or go far and say willful blindness, to the application of international human rights standards with respect to the rights of women and the rights of children. And the argument effectively has been that, and it's been put in different ways, but they can see a way through where these international standards, they could be international covenants or international of the International Covenant Conventions, that they can see their way through those in a domestic way to not create an issue or breach by advancing their case with respect to surrogacy, be it altruistic or commercial. And what strikes me, and I'm looking specifically at what is submission number 18 to the inquiry, and you may be aware of it or may have even read it, which is the submission by the International Rapporteur of Violence Against Women and Girls, Its Causes and Consequences. That document, which is essentially a statement of concern by the International Rapporteur, Special Rapporteur on Surrogacy, goes at some pains on pages 17, 18, 19, 20, over onto 21, about the importance of international conventions, international covenants, etc., that Australia is a party to, I might add. Could you help provide some perspective to us that this is, a state in the Commonwealth of Australia? Australia is a signatory to a number of conventions and declarations. How much attention should we be paying to our being bound by these as influencing our thinking, and juxtapose that to the idea that, well, listen, we're a sovereign state, there is a desire to have commercial arrangements, and we should sort of seriously contemplate going down that path. I'm sorry, you don't have the benefit of the actual submission from the special rapporteur, but
look, I think we have a responsibility to benefit from the best thinking on a subject that there is, and if these international instruments can improve our thinking on a subject, well and good. But I think the primary locus of law is here locally. It matters more than anything what the New South Wales Parliament decides. And of course, uniformity around the jurisdictions is a good thing, but only if it's uniformity of good law, not just uniformity of any law. So I think it would be foolish and reckless of us to ignore what's in a relevant international instrument, that we ought to be guided by them only when we ourselves think that what's said in that instrument is sensible.
No.
I think as well that we've got to be very careful about the message that we might inadvertently send in. You know, there's an old saying in human rights, nowhere are human rights more at risk than when we act purporting to do only good. And the people who want commercial surrogacy, for example, they're trying to do good. And I've seen some of the people, I described one in my submission, that, you know, this woman said to me, how can you be so cruel? How could you? And she was crying, and she said, you know, the only thing we want is to have a child, and you would deny us that. It's pretty hard to sit there and get accused of that. But I mean, I think the wider messages of allowing commercial surrogacy, as would be true for the wider messages of allowing people to sell their organs, they are so damaging, and so damaging to what we think of as human moral conduct. Not to do with religion, just basic human, how we should treat each other, what is our purpose in life, what gives us meaning, and all of those things are upended by turning these extraordinary important situations into a commercial bargaining. And what is interesting too is that my experience, and this is mainly in the organ transplant situation, is that the people who were promoting commercialisation there were the people who would make the profit from it. Overall profit. They claim doing good, and they do. I mean, transplants are a very good thing, but there's a problem. And the people who are pushing the so-called fertility industry, the bottom line is the bottom line. We want to make profit. And I don't think we can afford to match those two things and think that we can keep some of our values as beyond desecration. We've got a lot of things that are tumbling at the moment, and it's even more important that our basic foundational values are kept intact. We don't sell our children, we don't sell our reproductive services, we don't sell our kidneys, and we don't do that not just because we don't think they're ethical or right. We don't do it as well because it worries us what messages that sends into the future. And I think one of our problems at the moment in ethics is that we've got intense individualism. We only think of the individual. We don't see the wider spectrum this opens up. and we've got what I've called presentism. The current progressive values adherents think that the past is passé, that it's got nothing to teach us, it can't show us anything. I think they are completely wrong. And they don't, on the whole, they do not look to what this will mean for the future in terms of values. The one area where they do look to that is in relation to climate change. And they're very good on that, and they can see what's going to happen, and they're as scared as the rest of us. But they simply do not see it on some of these other issues.
Thank you.
That concludes our time. Thank you both for appearing today and for your evidence.
Thank you.
There may be some additional supplementary questions that committee members have, in which case the Secretariat staff will be in touch. But once again, thank you for your submissions and for making time today.
Thank you for the opportunity.
Thank you very much.
Thank you.
Thank you for your submissions.
Dr. Klein, I think just checking that you can hear me.
Yes, I can hear you.
Excellent.
Oh, I know what that was.
Oh.
I know what that was. It's all good.
Okay.
That was your time running out, Mr. Donovan.
No, that's fine.
Right.
And then, sorry, so she's not here. Yeah.
So
I can see on screen now. I think, yes, hello. Excellent. Well, welcome to both of you. For this panel, both of you are joining us online. And we also have one of our committee members, Dr. Con, who is online, who will come on when she has her questions for you as well. So welcome, and thank you both for being here today. We just wanted to start with each of you stating your name, position, title, and then taking either the oath or the affirmation. I believe you will have the text with you, and if not, I can read and you can repeat. It's up to you. So I think I saw a nod from Dr. Klein. So do you have the oath or affirmation? Would you like to begin?
Yes, I do.
Sure. Well, over to you.
Okay, thank you very much. My name is Dr. Renate Klein. I'm a biologist and social scientist and was Associate Professor of Women's Studies at Deakin University. I'm the coordinator of FinRage Australia, and that's the Feminist International Network of Resistance to Reproductive and Genetic Engineering. Now, my affirmation is I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Dr. Paul, do you have the oath or the affirmation?
No, I don't.
Okay, which
but
would
I will take the affirmation.
Affirmation. Okay, well, if you just state your name and title firstly.
Yes, my name is Dr. Megan Poore. I am the National Director of the Affiliation of Australian Women's Advocacy Alliances. However, I'm also a member of the New South Wales Women's Advocacy Alliance, and I'm representing them today. I'm also a New South Wales resident.
Excellent, thank you. I'll just read the affirmation and you can repeat after me if that's easy for you. So, I solemnly, sincerely and truly declare and affirm.
I solemnly, sincerely and truly declare and affirm
That the evidence now about to be given by me.
That the evidence now about to be given by me.
Shall be the truth, the whole truth and nothing but the truth.
Shall be the truth, the whole truth and nothing but the truth.
Fantastic, thank you. There's an opportunity for both of you to make an opening statement to the committee as well, if you would like. So I might start with you, Dr. Klein, if you would like to to commence that statement.
Thank you very much. Thank you for the opportunity to speak at this hearing. FinRage Australia is part of an international feminist network commenting critically on reproductive technology since the 1980s. From the terms of reference, it is obvious that the starting point of looking into fertility services in New South Wales is that they, in particular IVF and surrogacy, are perceived as positive interventions and that an increase of these services should be supported. FIMRAGE members have the opposite view. We believe that IVF cycles cause tremendous psychological pain, are physically dangerous for the women involved, and are highly unsuccessful. IVF also presents dangers for any children born of IVF. We believe that IVF has become normalized and that an infertility diagnosis is immediately taken to mean that the next step is IVF. We strongly reject this view. Not having your own biological child, although often perceived as a tremendous loss, is not a death sentence. IVF is expensive and has grave health and emotional consequences for women due to dangerous hormones used and can lead to permanent impairment and even death. It is an international scandal that now no country in the world has studied long-term health effects on the multi-billion IVF industry on the women and the resulting children, if, in fact, there is a child. So-called success rates remain in the 20% range, and for every woman who gives birth to a child, there are 4 women for whom it did not work. Put differently, in 2026, there are roughly 40 million women worldwide who have gone through IVF without success. We have no idea whether these procedures have damaged their overall health and how they will go through menopause and cope with old age. The same is true for children born of IVF. As IVF only expanded in the 1980s, no person born of IVF has yet reached the age of 50. Their ongoing health is not studied systematically, another scandal. But alarming Swiss studies have shown that teenagers born through IVF already have elevated blood pressure, and people around age 40 experience increased heart attack and other cardiovascular events. We may be sitting on a time bomb, indeed. And I'm just reading another book, which I'll talk about later, if I may, that says that confirms that even more than I thought when I wrote this. So, FinRage members believe that New South Wales taxpayers should not provide further financial benefits for IVF users, and that instead New South Wales should run an educational campaign offering people with infertility problems other ways of having children in their lives, for instance, through fostering children or through their choice of profession, teacher, childcare worker, etc. No one has a right to a child, whether single, in a couple, gay or straight, and we strongly reject all types of surrogacy, which we see as a human rights violation of mothers whose children are removed at birth and given to strangers. These children never agreed to be take-away babies and be separated from the only mother they know. We think surrogacy is child abuse and many other things as well. Maybe I can elaborate on that. FinRage joins many other global organizations to call for the global abolition of surrogacy. We urge committee members to recommend the abolition of all surrogacy in New South Wales instead of supporting an increase in numbers, or worse, compensated or commercial surrogacy. That's the same, basically. A world without surrogacy will be a better world. Thank you. And we would like to table 2 books on surrogacy. the books have been delivered to Parliament House, and I think the committee members probably already have them.
We do. We've got them
The
right
first
here. So thank you.
Yeah, beautiful. Surrogate Mothers Speak Out, and the second is my book, Surrogacy, a Human Rights Violation, the second edition with a new preface that details the ALRC procedure so far. Thank you.
Thank you very much for that, Dr. Klein. Dr. Paul, would you like to make an opening statement?
Yes, thank you, Chair. Before I do, I'd like to apologise for not being there in person today. I live in a regional area. However, the plane was on the runway when it lost power to an engine, and the rescue flight from Sydney is in the air as we speak, so I'm at home. I'd also seek leave to table some documents which I was hoping to deliver in person today. They speak to the legislative, international and parliamentary instruments that we hope to talk about, as well as the terms of reference and some ongoing evidence of our engagement on this matter. Would that be okay?
Yeah, I'm just getting some advice from the Secretariat. I think if you can email them through, that will be fine. So after you've given evidence.
Okay, I have rearranged my flights for tomorrow because I do need to be in Sydney for a roundtable on sexual consent laws on Thursday. So I'm happy to deliver them in Parliament, given that I have printed them all out and our $2 shop is now out of folders.
That's fine. That's very, yeah. Can I just say, as a fellow regional resident, I certainly empathise with the flight cancellations and the impacts that has. So, but yes, if you're here in Sydney tomorrow, very welcome to drop in the hard copies.
Thank you very much, Mrs. Mitchell. If I may then move to my opening statement.
Please.
Thank you. Chair, members of the committee, we appear before you today not only as women's advocates, but as co-guardians with you of women's welfare. We also appear as monitors of the constitutional and human rights order in New South Wales, and as the women who entrusted you with the authority to uphold that order. Members, your office carries significant powers, and we honour that in speaking to you today, in the hope that you will use your powers for the protection of those of us who are most vulnerable to state and structural harm. As guardians, you have accepted on our behalf the burden to limit what can be done in our name, and we thank you for taking on this work. But as citizens, and here we speak especially as women and as mothers, we hold rights against Parliament, rights to not have our bodies or our children treated as resources in a market, however strong the demand, and rights to your protection from state and structural harms that individuals cannot prevent alone. A core question for this inquiry then is how Parliament understands its role in relation to women and surrogacy. The starting point we offer is guardianship. Applied to women and girls as a sex class, this means legislators hold a duty to protect us from laws that licence the exploitation and commodification of our reproductive capacity. This is why guardianship, properly understood, is not paternalism. Women do not lack capacity or competency, we lack protection. Paternalism assumes that adults lack capacity and uses that as a justification for overriding our wishes for our own good. Guardianship instead recognises that adults have agency, but also that some social arrangements are so structurally exploitative that the state must not endorse them, even when some citizens step into them. A Parliament that refuses to construct and manage a market that depends on women's inequality is not denying women's agency. It is honouring a duty to ensure that our agency is not used as raw material for exploitation. In this inquiry, however, parliamentarians are being invited into a different self-image as stewards of a policy domain now being termed fertility support, managing sets of consumer and industry interests. Within that stewardship frame, purchasers, clinics, brokers, surrogate mothers and children all appear as stakeholders whose claims must be balanced. We press the committee to step out of that comfortable stewardship frame and into the space that guardians inhabit, where there are hard limits on what may be organised as a service and commodity market. A steward of a reproductive market is by definition working for that market's continuity and stability. A guardian of women and children can, and sometimes must, recommend that the market not exist at all. Seen through this lens, your terms of reference embrace not just technical questions. They go to whether this committee will recommend removing protections in the name of access, or will instead affirm that the only coherent safeguard for an inherently exploitative practice is prohibition. Barriers to accessing surrogacy are not inconveniences to be removed. They are essential, minimal protections against the commodification of women as a sex class. And where harm is inherent in the structure of an arrangement, no amount of regulation can cure it. A framework built on stewardship will only ever treat women's bodies as sites of managed risk. A framework built on guardianship, however, will prohibit surrogacy, extend that prohibition extraterritorially, criminalise facilitation and brokerage, and integrate surrogacy into an anti-trafficking and women's rights protections framework. Our request to you is simple, and it is serious. To remember in this inquiry that the Parliament must not primarily steward an industry, but instead guard women and children in its role as trustee of the community's power. We are asking you to live in that role on which we rely and that you have promised to us to uphold. The authority you possess is considerable, and we lend it to you on terms. Thank you.
Thank you for that. So the committee has resolved to equally split the time for questions amongst opposition, crossbench and government members, and we'll do a couple of rounds of questions each in the time that we've got. So I might just kick off with a couple of opposition questions in the opposition time. And starting with you, Dr. Paul, I was interested in your submission. You talk about needing to make sure that there was a distinction between ART and surrogacy and not having a merge of both of those issues in a single law, and that would mask their profound differences. And I just wondered if you could speak to that a little bit more in terms of that part of your submission.
Yes, of course, thank you. Our position is that the TORs, as we say in the submission, wrongly bundle surrogacy with ART, as if they were both neutral medical responses to infertility. Now, I know that Dr. Conn is a medical expert and a doctor of medicine, so she will understand that women are not a medical service. ARTs, we say, treat a person's own fertility, while surrogacy contracts out a woman's body and requires the planned relinquishment of a child. And those are quite two different practices. So we say that the committee should explore ways to decouple these two practices. And the terms of reference, we say, obscure structural harm by assuming surrogacy as a service, akin to ARTs, whose barriers, safeguards and supports need to be optimised. We'd say that these so-called barriers to access, as I've said in my opening statement, are in fact fundamental human rights protections against exploitation and commodification. And we'd also say in that bundling, the TORs themselves demonstrate structural resistance to evaluating the baseline legality of ethics and ethics of surrogacy. So that's our position on ARTs and surrogacy, how they are different things. We do think they need to be decoupled in this inquiry. And it's a pretty broad question, I guess, but in terms of your organisation's views, obviously you've made some recommendations about surrogacy and recommending that all forms or all arrangements are prohibited, but is there a view from your organisation on things like IVF, or is it more the surrogacy component that you have concerns with? Yes, thank you for the question. No, our focus for this inquiry is solely on surrogacy.
Thank you. And then just one more for you. You also make a recommendation about investing in ethical solutions to infertility, strengthening adoption frameworks, and it probably goes also to you as well, Dr. Klein, if you want to make a comment, because I think in your opening statement you talked about people exploring things like fostering arrangements or adoption. So I'm wondering if each of you could talk a little bit more, I guess, about your views in that space around what you see as more ethical solutions to infertility or options for families who do want to have children in their lives. I might start with you if I can, Dr. Poor, and then we'll go to Dr. Klein. So.
Yes, of course. I can cover this fairly quickly, I think, because it's already been mentioned in the submission. But we want to ask the committee to strengthen non-exploitative routes to families. So that's, for example, guardianship, kinship care, social supports, social policy addressing poverty so that women don't have to turn to surrogacy, again, as a practice that turns their pregnancies into a service.
Okay. Dr. Klein?
Yes, well, I do agree with what Dr. Poor has just said. However, I also have to state that a actual practice of IVF is indeed repeated in surrogacy. So, as I have indicated in the FINRAID submission, we have indicated, is that the practice of ART is extremely dangerous for women's health. And that is true whether this practice is done for either IVF for a couple or a single person or two men, or surrogacy. So whilst I do agree with Dr. Poor that we have to separate these two issues, there are also connecting features of both, meaning that it is very dangerous for women to engage in this practice. Now, yes, as we have said in our submission, IVF should not be seen as the next step when you have received an infertility diagnosis. And I also acknowledge that infertility, although it is not a death sentence, can be extremely difficult for couples. In fact, I came to this country a long time ago in 1986 to do a study of women who go through IVF programs. And I can tell you, I cried with some of the women who go through these programs, because not only did they not have a child at the end, but they were truly so desperate, and often they didn't really get support from their partner, because unfortunately partners or men in general want their biological heritage, meaning their genes, to be put on to the next generation. That is why they sometimes urge their partners to engage in IVF rather than do other things. Now, what other things can be done? As we mentioned in our submission, fostering of children will be my probably number one things that can be done. I mean, if, for instance, many gay men who really, let's just be clear about that, they push basically this inquiry, not just in New South Wales, but all over the world, where the group called Men Having Babies go to Germany, for instance, a country that prohibits all surrogacy. Nevertheless, they have so-called baby fairs where they blatantly said that, come to the USA and have your baby there. So gay men, if they feel so desperate to have children in their lives, which is a good thing, they could start by fostering any of these babies. And we know that unfortunately there are so many broken families around that a lot of children do need actually really good homes. But if fostering is not what they want to do, they could try and have professions like teachers, childcare workers, other things. Or if that doesn't appeal either, many gay men and other couples have got family members and they have children, and they would be so welcome to say, all right, every Friday on a regular basis, I take care of your child. Not just this Friday, but every Friday for the next year. Now go with her or him and take them to whatever they want to do. So that would be real help, rather than going into this IVF treadmill, because I actually published a book in 1989 called Infertility, Women's Accounts of Reproductive Medicine, which has recently been republished by Routledge. And one of the Canadian women in this book said, you feel like a hamster on a wheel. Once you start the IVF treatment, they will always tell you, just do one more round, and we'll have a child. And we know that's not true. She will not have a child, but she does feel, as this woman said, like a hamster on a wheel. That's a very unsatisfactory state of mind. And Finrage really thinks that there's many, many other ways of actually coping with this sad moment in a couple's life or a person's life when they know they can't have their own biological child.
Thank you. We'll just move to Dr. Con online if she has some questions. I'll just...
Thanks, Chair, and thank you both for making the time to give evidence this afternoon. My first couple of questions are for Dr. Klein. You've put that IVF can have grave health consequences for women, including permanent impairment and death. I frankly disagree. I think IVF is performed very safely in Australia all the time. What my question to you is what empirical evidence you're able to provide the committee to support that claim?
Where do you want to start? There are so many instances of women dying in IVF, of women being severely sick in IVF, of women having, consequences of IVF in their next pregnancy. That makes it even hard. So if you say that you don't know of any deleterious consequences for women, then I'm afraid to say, please go on the internet and have
Sorry to interrupt, because I don't want to be mischaracterized. Of course, there's adverse effects that are possible of any medical intervention, but what I'm asking you is for empirical peer-reviewed evidence, if you're able to point the committee to peer-reviewed papers that support your claims.
Yes, well, there are. I could send you a copy of my CV and see how many papers I've published on that particular issue. There are endless numbers of women who have been hurt in both IVF or surrogacy. And I'm afraid, you really have to go on the internet and do your own research. I cannot send you all these papers. But if you, actually, there may just be one thing that may actually change your mind. It's a very new book by a man called Francisco Güell, Guell, and the U has a umlaut, like in German, two little things. His book is called The Last In Vitro. He is an epigenetic researcher from Spain. He has done research on the damage of IVF, particularly on children, and also on women. And I really, really urge you to read that book. We have been documented dangerous outcomes for women on IVF. I refer you to all the films on that Jennifer Lau from the USA has done. They are on her website, on the Center for Culture and Biology, and you watch one of these films and you know exactly what's happened. So to say, as you do, that there are no health effects recorded on women negates...
Sorry, Dr. Klein, again, I haven't said that there's never been any, just that adverse event rates are well understood in Australia and well accepted by practitioners and the community.
Maybe
I'll move on to my next question. That's all right. You've recommended...
Hang on. Let me just finish what I want to say. Maybe start by reading my book called Infertility, Women's reports on reproductive medicine that Routledge has reissued, and you can find all the stories by women who have been hurt on reproductive medicine, on IVF, including the story from a woman in Israel who died. Because women die, and in fact, actually, just about maybe 2 weeks ago, I got a report from the USA where a perfectly healthy woman who started IVF died. So it is a dangerous technology. And if you think about it, the whole what the women need to go through in IVF, they are first put into chemical menopause, which, I mean, if you think about it, a woman who's in her 30s being put in chemical menopause is not a good thing. Then, when the ovaries have stopped producing eggs, they are put on fertility hormones. It's like being just sort of this commodity that gets stopped and started, and so on the fertility.
Dr. Klein, can I ask you a follow-up question?
Sure.
You've made it clear your opposition to IVF. Does that opposition extend to all forms of assisted reproductive technology? So, for example, women who are put on medication to stimulate ovulation, do you also view that in the same terms?
What do you think when a woman is put on medication to stimulate ovulation? What's your point? What do you want to say with this?
I'm asking you if you also object to those assisted reproductive technologies, or if your objection is limited to IVF.
I don't know what exactly you mean with this. If women are put on ovulation-inducing medications, you think of clomiphene, which actually, together with my colleague Robin Rowland, I wrote about this in 1988. We were poo-pooed by IVF doctors, and we were wrong. Only about 10 years later to have a black box put on the box for clomiphene citrate. So I'm not really sure what your question is. But yeah, I do object to women being treated as commodities that are only worth something if they get pregnant and produce this child.
So it's my follow-up question, and this one would apply to Dr. Poor as well. We've heard directly from women in this inquiry, for example, one this morning who was a voluntary altruistic surrogate. My understanding of your evidence is that that should be viewed as this person being exploited or treated as a commodity. Is it your view that we should be intervening as politicians to prohibit a consenting adult from making that choice as an informed adult about what someone wants to do with their own body?
Well, let me give you an example, and in fact it's in the book Broken Bonds that you were given a copy, or if you're not there, you will be given a copy. It's this book. It's by an Australian woman. She had to use a pseudonym called Odette. She was asked to be a surrogate for her cousin. Her cousin had been rendered infertile through drugs used she had cancer, and so in the cancer treatment she was rendered infertile. Odette was totally okay. She really wanted to do that. She herself had a little boy who was looking forward to a little cousin that they could play with. She was all very happy to do this. She should have not been able to even be accepted as a surrogate because she had a very, very difficult cesarean section when she gave birth to her own little boy. But nevertheless, they accepted her. She and her cousin and her husband went through the necessary clinical counseling, etc., and she was accepted. Well, already quite early in the pregnancy, her cousin started to be very nasty. She used to ring Odette up and said, you're going to have a miscarriage. I know you can't have this child. And Odette started to get really upset. She was sick. She had morning sickness. It wasn't an easy pregnancy. And there, the woman that she was doing all for kept ringing her up and saying, you're not going to have a child, you're going to have a miscarriage. And also, the cousin never came to any medical appointments. And then gradually they stopped paying for any medical appointments. So what I'm saying is, and you can read it in Broken Bombs, there was a woman who, out of the goodness of her heart and really feeling sorry for her cousin, was very happy to start a surrogacy. The surrogacy went as bad as you can imagine. So the child, a boy, was born 10 years ago. And just earlier in April, Odette actually had a Facebook post saying, I wish I could see you, because when the whole thing went to the country, to the court, the judge decided that it was up to the commissioning parents to decide if the surrogate mother, that's Odette, could see her child or not.
Dr. Klein, I'm
Now,
sorry to
the
interrupt you. I
surrogate-
might just, the time for Dr. Klein's expired, but I think Dr. Paul wanted to respond
Can
as
I
well.
just add one? Well,
Yes,
can I-
thank you. I do believe the question was addressed to me. So if I may respond to that around the exploitation and perhaps also the lived experience, which may be part of the question as well, element. Yes, so thank you, Dr. Khan, for your question. I want to be clear that our organisation deals with matters of governance, accountability, process and policy. We work at the higher level of structural analysis. Our structural analysis indicates to us, and don't worry, I will get to the exploitation issue, is that the related matter of lived experience, whilst important for public officials to understand and acknowledge and be cognizant of, we think that lived experience should only be granted a small capacity in the state's decisions. So yes, the state absolutely does have a duty to prevent harm, in this case a negative duty to refrain from harm. So what we're saying, if I can explain it this way, is that social and structural analysis should organise the Parliament's response. We're not saying that we should discount individuals' testimony or their experiences or their feelings or their understandings, but we are saying that questions of structural violence cannot be decided by lived experience and anecdote and the recounting of lived experience. So in terms of the exploitation framework that we offer as a social analysis, we're saying that individual choices and feelings are subjective, but the legal and material structure is observable and objective. And it can be exploitative, even when some women say they like being part of it. So the question is not whether women feel exploited, but we feel as though the question for Parliament is whether or not women, it's not whether or not women are competent or capable, but perhaps further on from that, who benefits when we call that empowerment, when we don't call it exploitation. So we're very aware that we shouldn't try to avoid naming the dynamics, the social dynamics that are in play here. Because if we don't name them, in this case exploitation, it does become very difficult for Parliament to see what is truly at stake when it designs laws. And again, in this regard, I'd say that Parliament has a negative duty to refrain from harm. And in that sense, it has a negative duty to not construct and steward a market that depends on our pregnancies and the handover of our children. Parliament has a negative duty, again, a duty to refrain from harm, to not create a market that exploits women's individual agencies and uses our agency as raw material for the construction of a market.
Thanks.
Okay,
I'm
we'll
out
just-
of time. I'll
yeah,
get my
we'll-
colleagues.
Government time, so Mr. Donnelly.
Thank you, Chair. And thank you both very much for your submissions, which are very helpful, and the additional material that's provided by Dr. Klein, the two books, and Dr. Paul, some material that will be arriving this evening or tomorrow. I first want to start by referring to what is the report from last year by the Special Rapporteur on violence against women and girls. The Special Rapporteur, of course, is a formal role within the United Nations. I presume that both of you are familiar with, and probably no doubt will have read the report by the Special Rapporteur. Is that, so both nodding, so thank you for that.
Yes.
I note in the report putting very strongly the case of, like yourselves, opposing surrogacy in all its forms, and I'm just specifically looking at page 22 of the document. It's paragraph 70A, and 70 reads, considering the above, the Special Rapporteur recommends that Member States and other relevant stakeholders, A, at the international level take steps towards eradicating surrogacy in all its forms, and goes on. What strikes me is that I observe at an international level documents like this and other material that enters into the public domain about the exploitative nature of surrogacy. But we in Australia at this moment seem to be almost counter-cyclical in the sense that overseas there seems to be some serious reflection about the negative impact of surrogacy, particularly on women and their children, or the child that they carry and bear, and indeed potentially with respect to others as well. But here in Australia, there just seems to be this emergence of an impulse to push commercial surrogacy. I'm just wondering, and be keen to hear from you your thoughts about why do you think this is happening now in Australia?
Well, that's a difficult question to answer because I could be very rude, but I don't particularly want to be rude. One view is that Australia is simply lagging behind, and I know already that if, as it looks like, the ALRC final report that's going to be given to the Attorney General at the end of July will recommend commercial or compensated surrogacy, we will be seen, if it gets accepted by the government, as a pariah in the Western world. Because very clearly, the whole of Europe is practically surrogacy free. There is no surrogacy in Germany. They have tried, but it's not happening. Not in Switzerland, not in Sweden, not in Austria. And now, little Australia is trying to change the world and is trying to say, no, we should have compensated surrogacy. If indeed that's what the report will tell us, and the government would accept it, that would be a very sorry day to see, and we will have to really have a rebellion, basically. Why it is happening? Well, some easy responses. If you go to the ALRC and you look at the advisory committee, who have we got on the advisory committee? We have got lawyers who all stand to profit if more surrogacy is happening in Australia. And in fact, I was reading also some of the submissions to this fertility inquiry, and I came across the Growing Family inquiry, and I was really, I knew already about this actually, but what is proposed in the Growing Family inquiry is nothing else but what the ALRC is going to propose, or has proposed in its last issue, as what should happen in Australia. So we should have a cottage industry of surrogacy in Australia with surrogacy organizing groups where so-called surrogates as well as commissioning parents have to pay to be vetted, and then once they have vetted, criminally and health-wise and whatever, they then get to actually undertake the surrogacy. And it's just ludicrous that actually Growing Family has obviously provided the blueprint for the ALRC to come forward with their various points that they want to make. And I really hope that the general public in Australia will wake up and will strongly object to this, and that the government will not proceed with this. Because let's also face the fact that surrogacy in Australia is regulated by the states, and the ALRC is a government it's a government-funded agency that they can't impose what they want to do on the different states. So this has not actually run its course.
Just Dr. Paul, could I just, in the context of answering this, I note that I just want to add this for your consideration about my question, but also can you outline the domestic processes that you and AAWAA have tried to engage in articulating the concerns that you have put forward in your both submission and your opening statement today?
Yes, I certainly can. And some of this will lead on from issues that Dr. Klein has raised. We've tried to do a number of processes in this area and others, especially international instruments and obligations. Recently, Australia's 9th Periodic Review of Australia, where we were instrumental in forming a coalition of like-minded feminist organisations, and we covered the topic of surrogacy. We've engaged with the Commission on the Status of Women at the UN level, with the UNSR Special Rapporteur who appeared yesterday. We've also engaged with her on her report, which you've referred to, has been referred to here. We've also lodged UN Special Procedures requests regarding lack of democratic process for the New South Wales Equality Bill and the Western Australian Reproductive Technology and Surrogacy Bill. So all of that's been done at the international level. In terms of domestic and parliamentary reviews, we've engaged with the New South Wales review of the Surrogacy Act and Status of Children Act in 2024. The current process, of course, I also draw attention to the New South Wales equality legislation, where we sent letters to parliamentarians, similarly in Western Australia, to try to raise these issues. But perhaps something to hook onto there with what Dr. Klein has mentioned. We have tried very hard to engage with the Australian Law Reform Commission on its review of surrogacy laws, the current process. We also were instrumental as an organisation in getting up a coalition of feminist organisations, and part of this will be part of the documents that I'll deliver by safe hand tomorrow.
Thank you.
We were instrumental in getting up a coalition of 12 feminist organisations to put in a submission, very simple submission, which is around prohibition on the road to abolition of surrogacy. We, on the basis of that, unable to be ignored, and also raising questions as we did similarly in our submission here around CEDAW Article 7, the right for women to participate in policy formation, read in conjunction with the General Recommendation 23, I think it is, to not treat our participation as tokenistic. In the round of that, we were asked to participate in a roundtable with the ALRC. Now, at that roundtable, if I may just provide something that is emblematic of what seems to happen to women's groups in our area, is that in the roundtable we were told straight up that by Justice Bromberg that we were not to raise matters of governance. Now, that is our main remit here. We work for the protection and advancement of women and girls in Australia and in New South Wales in NSWWAA. And to take that off the table straight up meant that we weren't able to speak to our remit. We nevertheless did present our statement. From that, again, just as emblematic, so that the committee understands the difficulties, it's emblematic, and out of that round table, Justice Bromberg said that we were to raise any governance concerns with him directly and in writing. Now, we had concerns about governance, conflicts of interest, advisory committee imbalance, and the ALRC's own statutory obligations. Justice Bromberg also asked us how a recommendation for prohibition of surrogacy fits the terms of reference of the ALRC inquiry. Our answer to him is very similar to the one that we would give you, which is that for the ALRC, their own act allows them to make that recommendation. So for a senior law official, that would be a fairly obvious route. And also for this committee, the New South Wales Interpretation Act, which I believe has been mentioned earlier, but not in terms of our international obligations, would allow this committee to do that also. The response that we got from Justice Bromberg after we communicated with him to lay out exactly what he asked us to was for his executive director to communicate back to us without addressing any of our concerns. We also raised these same concerns with the Attorney General. A functionary from the department also got back to us without addressing any of the concerns. So we also raised concerns around advisory committee imbalance at the ALRC review. This correspondence will be in the package that I deliver tomorrow. We would also draw, so in that regard, we would draw this committee's attention to conflicts of interest or perceived conflicts of interest in witness testimony here for this very committee. ALRC advisory committee members have given evidence here, Ms. Jefford and Mr. Page, who, unlike women's groups such as ourselves, do not have a vested interest other than to work for the protection and advancement of women and girls. We are not seeking to benefit from the expansion of surrogacy. Our livelihoods do not stand on the expansion of surrogacy. So we would also ask the committee, as well as we've asked the ALRC, to be cognisant of any conflicts of interest or at least perceived conflicts of interest.
Thank you, Dr. Poor. I'll just hand to Mrs. Carter now.
Dr. Poor, if I could start with you. We have heard evidence that recognises the issues inherent in commercial surrogacy, but suggests that it can be designed properly in such a way that would eliminate risks of exploiting women and eliminate risks of commodifying children. Is it your understanding that that type of regulation is possible?
No, we don't believe that type of regulation is possible at all. Mrs. Carter, we, again, working from the high-level social analysis, we would say that regulation does not alter the ethical character of surrogacy. Instead, we would say that regulation makes surrogacy look orderly and respectable when that is not actually possible. It leads to normalisation and expansion in terms of where does this lead us in 10 years' time. If we normalise it and expand it, it creates pressures to relax restrictions once a market exists. It also creates pressures on the Parliament should there be problems, and we believe that there are inherent problems in the practice. But once those problems become even more evident at a societal level in 10, 15 years' time, it leaves the Parliament now with a duty to future members and legislators to not create a market that generates vested interests among clients, brokers, clinics, lawyers who benefit from that market. So in terms of exploitation and coercion, we're saying that no, it is not possible, that regulation has not proved effective in policing coercion, social pressure, economic vulnerability, all of those things that accompany surrogacy. And we can see parallels in this in the limits of New South Wales sexual consent reforms. It is very difficult to police and then enforce complex coercive relationships. It's not the same as regulating building codes or safety standards, even complex building codes and safety standards. This is dealing with something that has an ethical character that we feel cannot be fixed.
So Are you suggesting that regulation of surrogacy encounters the same problems as regulating a relationship which has coercive elements?
We're saying to look to that because there are coercive elements, we feel, in surrogacy. And yes, we're saying just look to that as an analogue or as a parallel for the limits of how we can police and enforce that.
It's been suggested to me, and I'd welcome your comments, that we learnt from the experience of women relinquishing their children through adoption when there was significant coercion on those women to relinquish, but that we are perhaps at risk of repeating that with the pressure that may be put on women to relinquish their children as part of a surrogacy arrangement. Are they different? Should we see them as completely different? Should we see surrogacy is informed by our experience with adoption?
Yes, I think so. Forced adoptions, the stolen children framework as well. That thankfully we've apologised for that. Yes, I think that it all involves treating children as commodities, and putting children first means refusing in the first instance to design systems predicated on planned child separation from the woman who carried them. The state is not obliged to create new categories of children whose origins depend on a contract for separation. So those experiences that we've had in the past, I think, should be front of mind for this committee, as should this committee's looking to the future, to future parliamentarians. Individual positive outcomes under adoption or surrogacy or things can look fine even in exploitative systems. It does not answer the ethical question of how these children were produced, and it does not alter the ethical character of surrogacy.
Thank you. My time's expired, sadly.
Dr. Con online?
Yes, could I please answer or add something to Dr. Poor's statement?
If it's very brief, Dr. Klein, we're just conscious of time, and Dr. Con.
Sure. In the book that you now all have, my book, a human rights, surrogacy, human rights violation, on page 37, I quote from then Prime Minister Julia Gillard's very wonderful apologies to unwed mothers whose children were taken. And she said things like, they often did not see their baby's face. They could not soothe their baby's first cries, never felt their baby's warmth or smelled their baby's skins. They could not give their own baby a name. And then she says, today this Parliament, so this was in 2013, on behalf of the Australian people, takes responsibility and apologises for the policies and practices. And we recognise the hurt of these actions, and we deplore the shameful practices. And now the last paragraph, we resolve as a nation to do all in our power to make sure these practices are never repeated. Now,
Thanks,
why are we doing surrogacy? Because those practices are repeated now.
I just want to hand to Dr. Con. I'm sorry to interrupt you. I'm just conscious of time. Dr. Con, did you have further questions?
Yeah, I do. Sorry, if I can just get in. I had a quick question for both of you just about your organisations. I am going to confess that despite practising in women's health and being a feminist activist for many years, I hadn't actually heard of either of your organisations before I'd participated in the inquiry. So that's the context for my questions. Could you let us know what the structure of that organisation is, how many members you have, what your process was to arrive at the submissions that you've provided?
We might start with Dr. Paul.
Yes, thank you. New South Wales Women's Advocacy Alliance is a member of the affiliation of Australian Women's Advocacy Alliances. AWA, the umbrella or peak body for our own women's advocacy alliances, AWA came out of the formation of a Canberra group, the Women's Action Alliance, Canberra Incorporated, which then grew from there. Once we had enough groups in Australia to create a national affiliation we did. We now have groups in all states and territories of Australia as AWAR. So our organisation's mandate is to advocate, as I've said, for the protection and rights of women and girls. It's not just for member interests, so therefore we represent all women in New South Wales for New South Wales Women's Advocacy Alliance and all women across Australia. We run, I don't know if you've had an opportunity to check out womensadvocacy.net, but that is the overarching website for all of our organisations. You'll see that we are very engaged in policy work. Our website has had close to 30,000 views since the beginning of last year, peak days of over 1,000 views. We have a podcast which has been ranked as high as 10th in a global feed spot list of independent women's
Sorry,
podcasts.
and I'm trying to direct you. I'm so sorry. It's really in the interest of time.
Sorry,
How many members does the NSWWAA have?
So again, yes, thank you. So we have 15 active members or thereabouts in New South Wales across the state, close to 100 across Australia. We are probably the largest, if not the largest, women's advocacy and rights organisation representing all women across the nation in this regard. For the matters that we cover, again, you can check that out. So our success for us isn't measured in raw membership numbers, but in how well the mandate is being filled, and we think you can see that through our website.
Thank you.
And same question to Dr. Klein for FinRage Australia.
Yes, well, FinRage, as I mentioned already, got started in 1985, long time ago. We have chapters in every country, and if you go on the FinRage website, you will see how many meetings we had, how many books we published, how many conferences we had. We had conferences in Bangladesh, in Germany, and everywhere. And at the moment, the group in Australia is not very big. I'm not actually sure how many people there are in it, but we continue with the founding principles of FinRage. That means that we are very critical in assessing reproductive technologies and surrogacy.
Okay. And so you've said the submission that you've provided on behalf of FinRage Australia, what was your process for arriving at that submission? How many other people fed into that?
There's a lot of our members read the submission, and I, in the end, submitted it, but it was a joint product.
Okay. Are you able to take on notice how many members that was?
No, I don't, because we have many members who actually read and give comments, and then don't want to be in the public eye. So I can assure you,
I'm not asking for you to name them. To be clear, I'm just interested in the size of the organisation.
Well, it's at least 40, if that actually makes you happy.
Thank you. We have actually.
Can I just add one thing, please, Chair?
Briefly, yes.
Just one short thing. Yes, I just want to say it's not surprising that people haven't heard of us, because women with our perspective and baseline mandate are quite severely silenced.
Thank you. So we have hit. Sorry, Dr. Klein. I'm sorry to speak over you. We have hit 4 o'clock, but I'm going to give Mr. Donnelly 3 minutes, just so that there's been the fair allocation of time, and we'll go slightly over. So, Mr. Donnelly, 3 minutes to you.
Thank you. And listen, just returning to that last subject area, just briefly, if I could. Just in terms about numbers, Dr. Con was seen to be very interested in numbers, counting individual persons who may be a financial member of an organisation, or a non-financial member of an organisation, or an associate member, whatever it is. But if I just go to Dr. Poor, your submission, and go to the final page of that submission, page 4, where you've got the signatories to your submission.
Yes.
Can you just simply confirm that all those organisations are associated with the work that you're doing, and that they are represented?
Okay, so they were associated. Yes, so you're talking there of the signatories to the coalition, to the call for input to the ALRC's review of surrogacy laws,
of which you've drawn quite substantially on that submission with your contribution today. Yeah.
Yes, that's right. So those are all separate organisations, and I would take that as those organisations and that coalition membership for that particular submission as more emblematic of women's the number of women engaged in these issues, but who just aren't being heard.
Yeah, and can I just
rather than just raw membership numbers in AWA, in SWWA.
No, I think that's what Dr. Con wants, just a number so she can quote that number. And with respect to Dr. Klein, the same thing with respect to your submission. It goes further than just simply a number, does it not? These are organisations which in fact are international in nature, some of them, and are involved in putting together submissions to like the ALRC and indeed this inquiry, isn't it? That's the case?
Absolutely. And I mean, FinRate is working with all the other organizations that want to abolish surrogacy, and that's the Declaration of Casablanca that stops surrogacy now, which comes from the USA. That is also SIAMS from France, Stop Leihmutterschaft from Austria. You name it, there's more. There's the UK,
Sure.
Stop Surrogacy Now in the UK. So we are very much networked. And Dr. Cohn's question about, questioning our legitimacy is really misplaced, because we have been here for more than 40 years.
No, that's fine. That's helpful from both of you. Thank you very much.
Thank you. That does draw an end to our time with you both today, but thank you for appearing and for your submissions and for the books and further paperwork to come from you, Dr. Paul. Much appreciated.
Thank you.
The committee, I think there has been a few things on notice, and the committee might also have some supplementary questions, in which case the Secretariat staff will be in touch. But once again, thank you for joining us today. The committee will now break for a short afternoon tea break, and we'll resume at 4:15.
Everybody needs a cup of tea.
on? Excellent. Fantastic. Well, welcome to the last session for the hearing today, and I want to thank you all for being here. There's obviously quite a panel, but we will start with each of you stating your name, your position title, and swearing either an oath or an affirmation. And we'll start with you, Dean Grant.
Thank you. Sandy Grant, Dean of Sydney at St Andrew's Cathedral, Chair of the Anglican Social Issues Committee. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you.
Danielle Treweek. I'm the Sydney Anglican Diocesan Research Officer and an ex officio member of the Social Issues Committee. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. Mr. Rowe?
Joshua Rowe, New South Wales Director for the Australian Christian Lobby. And I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you.
I'm Dr. Elizabeth Taylor. I'm a research consultant assisting ACL in this inquiry. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you.
Monica Dumit, Chancellor of the Catholic Archdiocese of Sydney. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you.
Sadie Simmons, I'm Director of the Plunkett Centre for Ethics at the Australian Catholic University. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Fantastic. Thank you. There's an opportunity for you to make an opening statement as well. I'm not sure if you want to do that sort of by organisation or how you'd like to, but I might start, Dean Grant, if
Sure.
you have it. Great.
Well, look, thanks for the chance to address this committee on behalf of the churches and people of the Anglican Diocese of Sydney. Our submission is endorsed by the Archbishop of Sydney, who I note is also a hearty co-signatory of the faith leaders' submission. Christian people always hold the formation of family and the welcome of children in the highest regard. We believe that supporting strong marriages between a man and a woman intended for life provides the best context for supporting fertility in a society. Anyone familiar with our scriptures also knows they give strong voice to the pain of infertility. Christians hold that all people, including unborn children of any and all stages of gestation, are made in the image of God and have an inherent dignity. Their sanctity of life and rights must be upheld, with special attention to those who are small and vulnerable. With society at large, we believe children have a natural interest, wherever possible, in knowing and being raised by their own biological mother and father in an intact relationship. The pain of those denied such knowledge or care is well rehearsed by some submissions to this inquiry. We do not think mothers and fathers are interchangeable. Therefore, the denial by design of the presence of a child's father or mother in its family is highly problematic. Self-evidently, fatherhood or motherhood is a privilege which comes to some but not all, and a responsibility that goes well beyond fertilisation. We strongly reject the claim of some, including some submissions to this inquiry, that there is any such thing as the right to have a child. We see no grounds by which such a right has or can be established by reason and evidence except loud assertion. Our view is consistent with international human rights instruments, which do not enshrine any right to parenthood, and certainly not outside the context of natural procreation between a man and a woman. Our submission to the Australian Law Reform Commission, which we seek to table here, I guess you'll advise me of the proper procedure, made that argument in detail. The use of ART has increasingly detached the begetting of children from the relational and biological context of marriage. We don't want that disconnection accelerated. Likewise, we have serious concern about any ART or surrogacy practice that involves the discarding or indefinite disuse of unwanted embryos. In addition, we urge the New South Wales Parliament to maintain the current prohibition against commercial surrogacy, whether by name or practice. Commercial surrogacy commodifies children, exploits vulnerable women, disregards the social significance of gestation and maternal care, and undermines biological connection. We continue to think that altruistic surrogacy, if practiced at all, should be a rare and carefully controlled exception. In all these things, the rights and best interests of children must be paramount, not the desires of adults. Thank you for the chance to speak to your committee.
Thank you.
There's 10 copies.
Mr. Rowe?
Yes. I'll be making the statement on behalf of myself and Dr. Taylor. And the Australian Christian Lobby. We seek ACL, a just, compassionate and moral society with Christian ethics shaping the way that we operate in public life. We do thank the committee for the opportunity to participate in this inquiry, as well as the opportunity to be at this hearing today. Specifically, our submission is confined to terms of reference F, I and J, and that's specifically pertaining to the matter of surrogacy. ACL is in principle opposed to all forms of surrogacy, grounded in our concern for the inherent dignity of human life, the sacred bond between the child and her biological mother or father, and of course the risk of commodification and exploitation of women. However, our primary concern here today is one that is procedural, and specifically noting that the terms of reference didn't distinguish between commercial and altruistic surrogacy. And we just wanted to lodge that these are fundamentally different issues. They engage different legal, moral and human rights implications and need to be considered explicitly and in different contexts. So if the changes to these prohibitions are being contemplated, then we would say that needs to be clearly and explicitly consulted separate to this inquiry. And we note that this is particularly important given Australia's long-standing prohibition on commercial surrogacy. So we welcome any questions on our submission, and thank you again for the opportunity to appear.
Thank you. Mr.
Thank you. I'd also like to thank you for the invitation to appear today. And I'd like to begin by acknowledging the pain experienced by many people who long for a child, but for any number of reasons are unable to have children of their own. The beautiful and natural desire to be mother or a father is one of the most identifiable examples of self-sacrificial love that we have, and this should be commended and supported. And it's good that the Parliament is open to considering how the desire for family life can better be supported. It's our observation, however, that the government's support of this desire is solely focused on assisted reproductive technologies and not other forms of fertility awareness and care. This creates an unnecessary inequity where couples who do not wish to use IVF are not eligible for existing financial assistance available for fertility support. There are some who do not want to go down the IVF path because of religious reasons, but for others it's about a preference for natural methods or the desire simply to avoid side effects. Our primary recommendation is a definitional change that would expand fertility supports to include natural methods that are proving to be cheaper than IVF with similar success rates while simultaneously addressing the underlying health issues that contribute to infertility. When it comes to surrogacy, while we understand the pain of those who want a child of their own, this does not mean that we facilitate a culture of having a child at all costs, particularly when those options present a risk to the women and children involved. When it comes to proposals for expanding surrogacy arrangements from altruistic to commercial surrogacy, this especially includes the risk of exploitation. Our submission goes into some details about these risks, but I just want to highlight something said by the former Chief Justice of the Family Court of Australia, John Pascoe, who described the international commercial surrogacy market as being used by people ill-suited to be parents, driven by cash, with no oversight by any regulating body, and likely to expose vulnerable women and children to terrible abuse. Surrogacy, he said, is the new frontline in the trafficking and commodification of women and newborn children. We look forward to taking your questions.
Thank you very much. So just for your information, the committee has resolved to equally split the time for questions amongst opposition, crossbench and government members. So we'll do a couple of rounds each. And Dr. Con is online, so when she asks her questions, she'll just appear on the screen in front of you there. So we'll start with Mrs. Carter.
Thank you all for being here today, and thank you for the time involved in your submissions. Perhaps, Ms. Dermott, if I could start with you. So, other than IVF, what are the sorts of fertility supports that you feel that women should be aware of and that this committee should be considering?
Sure, absolutely. There are some examples that are in our submission on page 3, but one example is naprotechnology, which is an emerging field, and the initial research shows that it is approaching the effectiveness of IVF, particularly for second and third pregnancies. But these aren't included in the definition of assisted reproductive technology that attracts the fertility treatment rebate, and that medical practitioners offering these types of solutions aren't yet accredited by the Reproductive Technology Accreditation Committee. It's worth noting that these types of technologies can be rolled out in training to GPs, which means that if the training was provided, you would be able to roll this out into rural areas and to other places where women are having difficulty in attracting fertility support. As I said, the costs are much cheaper than IVF. So I think that's one in particular that I would suggest the committee be aware of. And I understand that there are submissions to the committee from some NAPRO technology providers as well on this issue.
We've heard some submissions in relation to education for women and clinicians in relation to fertility and infertility. Is there any education work that you're aware of that's done just to advise about the availability of these other technologies?
I think I know that there's training for practitioners available. I know some of the practitioners, but I think the awareness is still quite limited, and sort of it moves around almost by word of mouth in some of these circles. So I think it would be great if we could actually assist, the pump could assist in some way in rolling that type of training out.
Okay, thank you. I suppose this question to everybody. I understand from the submissions that there is uniformity in terms of opposition to legalising commercial surrogacy in New South Wales. It's been put to us that it is at least theoretically possible to legalise commercial surrogacy in a way which would protect against the commodification of children and would protect against the exploitation of women. One example that's been offered without much supporting detail was New York State. I wonder if anybody has a comment about whether it is possible to regulate commercial surrogacy in such a way that you remove the commodification and the exploitation, or about experiences in other jurisdictions which may be positive or not.
I'm happy to comment briefly on the New York State, and then
sure.
Save, you might comment more broadly on commercial surrogacy. It's interesting, I've heard the comment about the New York State law being something of a gold standard, but it only became effective in 2021, and so we only have 5 years of its operation. There are certainly there's no data on the effects on the surrogate mothers, on the children born of those arrangements, and there's no requirement in the New York legislation for that type of detail to be presented at all. I mean, look, I'm a lawyer, I love contracts, and I think you can draft an amazing commercial surrogacy contract with all of these different clauses, but that doesn't tell you whether or not some of these other things are existing. I know that in our submission we talk about the Federal Parliament Australian House of Representatives Surrogacy Matters report, talking about PTSD experienced by surrogate mothers here in Australia. So I'm not sure how a very well regulated contract can avoid those types of things. The only thing the New York state legislation seems to tell us is that in 5 years there hasn't been any high profile disputes, and while that is one measure of success, it's not the only measure of success, and I think you need a lot more data and a lot more information, which I don't believe is being collected in New York State.
All right. Thank you.
I'll try to be brief, but just to echo Monica's concerns, I think sometimes you can miss the bigger picture when you're thinking about surrogacy, and particularly commercial surrogacy, when talking about these questions of whether we can establish a commercial surrogacy regime where women and children are not at risk of exploitation. Because I think the objection that's often made to commercial surrogacy is not so much to point to specific cases of exploitation, but rather to focus on the structural exploitation that occurs in surrogacy, the power imbalances between people commissioning the surrogate and the surrogate themselves, the fact that they can impose contractual obligations on the surrogates to, for example, limit their caloric intake during pregnancy, or to not engage in certain activities, to not go certain places, all sorts of different things. Some of those may be addressable through very carefully constructed legislation and regulation, but some of them are not. I think there's an inherent power imbalance in commercial surrogacy arrangements that is just part of what it means for it to be a market commodity. And then the only other thing I would say is that even when it comes to arrangements where you have two apparently fully consenting parties, it remains the case that women entering into surrogacy arrangements as surrogates could very well have developed a preference for doing that only because they find themselves in situations of financial or material or other disadvantage. And that's what's known in philosophy, I'm an ethicist, as an adaptive preference, a preference that's been interiorized because of really unideal social circumstances and has led you to consent to something which you otherwise wouldn't under much more just social conditions. So I think there's these inherent issues with commercial surrogacy that suggest we shouldn't go down that path.
Okay. Anybody else?
Could I pick up from Xavier there that I took your question being, is there a possibility of setting up regulatory principles such that we would avoid the commodification of children or women, I would imagine, through commercial surrogacy? The regulation, if good regulation is in place, then the aim of that would be to avoid certain detrimental realities or consequences that might come out of commercial surrogacy. But they cannot regulate against the commodification that is just a fundamental reality of this. That as soon as we're talking about compensating, not directly reimbursing a surrogate for medical costs, but compensating them for providing some sort of service, that is an instant introduction of commercial norms and market value into pregnancy, gestation, childbirth, parenthood. And so regulation, the question of regulation is a very, very important one, should this go ahead. But regulation cannot actually do away with the fact that the system automatically commodifies babies and women in this equation. That's certainly my belief, yeah.
Thank you.
Just add a small note on that, that when you're dealing with human life, it's obviously something that's very sensitive, and regulation, no matter how well it is drafted, is always open to abuses. That is the nature of the reality in which we legislate, and we can see that in that it is currently there is a prohibition on commercial surrogacy, yet we know that between 2010 and 2023, 2,769 children have been born to international surrogates and brought to Australia, and that's not something that has been prosecuted. There's been zero prosecution, so that is a clear demonstration that even some of the best regulation, sometimes when it pertains to exploitation of women and the trafficking of children, is still abused and not actually used effectively. And so as soon as you step into this space of creating a regulated model, because it is such a contentious space with the commodification of children and with the monetisation of women's reproductive system, it is inherently open to abuses in that regard.
Okay, thank you. That's my time.
We'll move to Dr. Con online.
Thank you. Thanks, Chair. Thanks to the witnesses for making the time to give evidence, and my apologies that I'm online today. I just wanted to follow up on a question that Mrs. Carter asked about support for other forms of assisted reproductive technology. I think her question was specific to NAPRA technology, but we've had other submissions seeking public funding for treatment like ovulation induction or intrauterine insemination. Are those things that you would also support extending funding for? And if I could identify correctly who was talking about in their opening statement, I think it was Ms. Dumit, but I apologise that you're all very tiny on my screen if I've got it wrong.
It was, thanks Dr. Con for the question. Look, I don't imagine it's a secret that in terms of Catholic moral teaching, both of the methods well, certainly the artificial insemination, it goes against Catholic teaching, and so from a religious faith perspective, that's not something that we would consider to be morally illicit. That said, nor is in vitro fertilisation. I think our main point is if this was going to be expanded, that people should have a choice in terms of the fertility treatment that they wish to seek.
Okay. I also had a question about neprotechnology, but are you the right person to ask, or should I save this for someone else?
I think probably save it for somebody who's an expert in this. I'm not. I know you're a medical doctor. I'm not, and so I wouldn't pretend to be an expert in this. But I do understand that there are other submissions. I'd read a couple of them in preparation.
Thanks. Look, my final question is to all of you. You're advocating that current bans on commercial surrogacy should be enforced. And my question to you were that if we were to adopt that recommendation, what would that actually look like in practice? What penalties would you see being applied, and how would we actually apply that in New South Wales?
I can probably speak to that a little bit. Anyway, it's a difficult question because it involves both state-level legislation and national enforcement mechanisms. So we know that these children are coming from overseas, and that by the time they're here in Australia, it's a fait accompli. The family court is presented, or the Supreme Court is presented with a child who's already been brought here, and they're constrained to prioritise the best interest of the child, which almost always is to remain in Australia at that point. Quite often, one of the commissioning parents is also the biological parent. So these are incredibly complex issues. And I know that they were considered at some length in the 2016 Surrogacy Matters inquiry by the, by the Federal Parliament. And one of their recommendations was that we need to give some further consideration to how we uphold our international human rights obligations to prevent commercial trafficking of children. At the moment, there is a loophole in the system, the gap between what we want to have happen and the reality of what is happening. It's regrettable that the ALRC, which was tasked with giving consideration to how Australia should implement its international human rights obligations, has decided instead to consider some human rights principles. I'm not sure where they got those from, but it is really a lost opportunity, because this would have been a great opportunity for the Federal Parliament, which is really, I think, where New South Wales needs to you need to work with the Federal Parliament on this, because it involves a two-pronged attack. But I think at the moment, the declaratory effect of the law of having a criminal penalty for international surrogacy is the correct thing, because it's morally objectionable to be bringing children to Australia who are trafficked children. So I think the New South Wales prohibition needs to remain for the declaratory purposes, if for nothing else.
I think, Dean Grant.
Thanks, and thanks, Dr. Cohn. I confess that I've not read all the details of my fellow panellists' submissions, but I also would just note that I didn't hear Joshua arguing that the breach of the law should always be more vigorously prosecuted, but rather that the illegality should not be removed. It may only be in very rare cases of particularly egregious breaches where it's judged by those with the heavy duties of enforcing the law might think a prosecution is worthwhile. So I'm not sure that we're saying, go harder, but that don't remove the illegality because of the educative, the shaping nature of it. And there may be very rare, the degree of rareness I don't know, but there may only be very rare occasions where actual prosecution is the right step.
If I might just add one thing, I think one of the issues is that the lack of enforcement not only seems to permit international surrogacy, but also incentivises the exploitation of the more vulnerable women. Because if the test here is the best interest of a child, and the child is already in Australia, the disparity, the greater disparity between, the perhaps child from the developing world, someone whose surrogate mother is in poverty, all of those things, it actually seems to incentivise exploitative practices, because the greater the disparity between the commissioning parents and the surrogate mother, the more likely that the best interest test will lean towards keeping the child in Australia. So I think we can probably do better in a sense of not actually incentivising bad practice.
Yeah, and I think your answers come to the crux of my question, I suppose, that you're all talking about criminalisation as a deterrent. And what we've heard loud and clear from this inquiry is that it hasn't served that way. There are many children living in New South Wales who were born through overseas commercial surrogacy arrangements. So I suppose the crux of my question really in practice is how is this enforced? Do current parents get fined or thrown in jail? Do children at that point of being before the family court for a parentage order get separated from their parents to be sent back overseas? I'm trying to get into the complexity of what this would actually look like in practice for that penalty to be implemented in New South Wales.
Can I make a comment here? Can I just challenge the idea that it's not acting as a deterrent, because we don't actually have a counterfactual world to work with which doesn't have this legislative prohibition on international commercial surrogacy. So we don't actually know how many more parents or how fewer would have gone overseas should the law have been different. So I think we do need to bear in mind that while there are still a lot of couples commissioning surrogates overseas, it is quite possible that the law is still deterring others from doing that. So I think that's just something worth considering in this context.
Okay.
If there's no more answers to the question, I'll hand back to you, Chair.
Thank you, Dr. Conn. I will move to questions from government members.
Thanks,
Mr. Donnelly?
Chair. Thank you all for coming on this afternoon, and thanks for your respective submissions. They're very helpful. Might just sort of bowl the question up and then offer the opportunities for whoever might like to.
That's only your time, Star.
No.
You got 20 seconds of Amanda's
time. I do
time.
that all the time, but I do normally press on. No, the matter of human reproduction hitherto has been underpinned, and we find this in various documents, conventions, both at an international level and legislative inside jurisdictions or even states within jurisdictions, about the paramountcy of the consideration of the child. What's come through from various witnesses over the course of yesterday, and I think you probably know today is the second day, is an overt change of focus from that to something which is I find quite different and quite challenging, and that is that this is in the context of surrogacy. That instead of keeping in front of our eyes as paramount to the consideration of the interests of the child, we now bring into consideration a range of parties. And that is quite an elastic range, I might add, depending on how you want to define this. But perhaps just I'll use a sort of a group definition to include the surrogate herself, the child born of surrogacy, provider of gametes, and commissioning parents. I'll use that as a subset. You can extend that, but just perhaps use that as a definition for this discussion. Are there implications for society to move away from that very laser-sharp focus on the best interests and paramountcy of consideration for the interests of the child in the context of human reproduction and through the vehicle of surrogacy, and putting those interests in line, but also, I would argue, and like interesting views on this, in tension with meeting the interests, and how one defines that's, I guess, a side question, but the interests of these other parties. Just interested in how that is quite a seismic shift from the way in which we've looked at, well, I would submit the consideration of the child being that primary interest. So I'll open that up for.
Sure. Thanks, Mr. Donnelly. The only of all the different interest groups or people, providers that you mentioned, the only category of person who has no choice in the matter is the unborn child or the newly born baby. By self-evident, the weakest, the most vulnerable person involved, and the only one without choice in the matter. And yet evidence before you, I've read in some of the submissions, shows how deeply, for example, the loss of knowledge of biological origins, the loss of connection to a mother or a father can be felt. And I really, in a sense, we've submitted it, but I want to kind of read into the record that there is the international rights instruments do not provide any right to parenthood or right to a child because, I'm quoting from the United Nations Human Rights Council, a child is not a good or service that the state can guarantee or provide, but rather a rights-bearing human being. Hence, providing a right to a child would be a fundamental denial of the equal human rights of the child. And that's only magnified by, as I said, its defencelessness, its inability to speak for itself, its lack of choice in the matter, which every other party, however constrained, however desirous of a benefit or a gain, they have choices in the matter that the child has none, and it should be defended.
Thank you. Perhaps move along the table if you wish to add.
I can add to that, which is that in terms of international human rights law, most of the instruments that Australia is signatory to, the covenants, were written before assisted reproductive technology was really well developed, and the committees that have been considering this at UN level have taken many years to do so because the issues are complex and increasingly so as the technologies become, the ethical issues are increasingly complex because of the technological advances and the things that can be done now that couldn't be done 30, 50 years ago when these covenants were drawn up. But what I would say is that there are very definite human rights protections for women and children in the existing covenants, and the three that are particularly important are the International Covenant of Civil and Political Rights, Articles 7 and 8 in particular. Article 8 prohibits human trafficking and other forms of exploitation. In terms of the Convention on the Rights of the Child, we can point to Articles 19, 34 and 36. Also Article 7, which is the child's right to be cared for by their parents and the preservation of identity as far as is possible. Article 31 of the Convention on the Rights of the Child says that state parties are to prevent the abduction or sale or traffic in children for any purpose or in any form. CEDAW as well provides that states parties shall take all appropriate measures, including legislation, to suppress all forms of traffic in women. So these are very strong human rights protections established by well-recognised conventions. I have seen, particularly in the ALRC treatment of this, for example, that the human rights of the commissioning parents are also bundled up together as though these were equally to be considered, and I can't see that there is human rights support, authoritative at international level, for those rights that are claimed. It seems to me that there are some very elastic readings of the conventions in order to establish those rights, and that they are speculative in nature, mainly because those issues were not considered when the conventions were drawn up.
Thank you, that's very helpful.
Just one comment from me. We're talking about the best interests of the children. It's not only the child born of surrogacy who's a child in this circumstance, and there's been some evidence about other children of the birth mother who either develop a fear that they might be relinquished themselves or suffer grief at the idea of this baby, maybe they've been told the baby passed away or something like that. So our submission goes into some detail about this, but actually the impact on other children in this arrangement who aren't necessarily the focus.
May I just... Oh,
yeah,
sorry.
You go.
I'll take in a different direction, so you keep going. And
Okay, very briefly. I mean, I was just going to say, I just echoing what my fellow panellists have said, the secular philosopher Dame Mary Warnock famously said, no one has a right to a child. It does not exist. She wasn't approaching this from a perspective of religion. She was approaching this just from the perspective of moral philosophy, and it's something which I think we need to recognise that this supposed right, which seems to be motivating a lot of this discourse, has not actually been grounded in any human rights document or any philosophy or kind of religious system. It's something that has just been asserted, I think, because of social circumstances, but needs to be essayed. And then the other thing I would say in answer to your question is that if you do start to introduce this supposed tension of rights, I think the concern is that it erodes the fundamentality of the rights of children. And that really, I think, is the nub of the matter, that what we will start to see, and we have seen already in commercial surrogacy arrangements, for example, is that children may want to stay with their parents, or they may not receive information about who their biological parents are, the surrogate parent, I should say, and yet they kind of are at the mercy, I suppose, of the commissioning couple and what they want to do, and that's a challenge, I think.
If you wanted to answer.
I'll keep this very brief.
No, it's fine.
But just to echo everything that my panellists have said here about the implications for the rights of the children involved, I think your question did ask what are some of the other social consequences or consequences for society. And I think there is a significant consequence for women here as well, not just in the potential of exploitation, but just in the very basic principle that surrogacy and, to a degree, some other forms of artificial reproductive technology are redefining what motherhood is and is not. And so with surrogacy, for example, and you indicated this in your question, motherhood can now be divided into 2 or even 3 different parts. There's the genetic provider, the gestational mother, the parent. And any one of those, particularly the first 2, can be diminished to the role of a paid or unpaid service provider in this context. That's an ironically tragic diminishment, I think, for the unique role and privilege of womanhood in our society as well, for what it is to be a mother, to be the one who conceives and bears and nurtures children. And I think the same argument could potentially be made with fatherhood too, in slightly different ways. But I think absolutely the rights of the child are paramount in this discussion, but there are broader social implications as well, I'd argue.
Interesting, I'll just finish on this point. We had a witness yesterday who insisted emphatically that there was no evidence of any bonding relationship between a mother and their unborn child. And we pressed that with that witness, and he was absolutely certain that there is, sorry, it might have been she actually, there is absolutely no evidence that there is a bond formed over the course of pregnancy, and was very clear about that. So it's just very interesting that that's being put forward as part of the reasoning against what is essentially, I think, something which is understood as essentially human nature. So, yeah.
Just back to the small position, I have a couple of questions. I wanted to direct this one probably to either Dean Grant or Dr. Treweek. I was just interested in your submission. You talked about how there might be some sort of limited circumstances for altruistic surrogacy, but you put some frameworks in around that. And one of the dot points, Part D, you say ensuring that surrogacy arrangements are treated with the same scrutiny as adoption, working with children checks, and also having those open relational frameworks. I just wondered if you could talk to that a bit more. We've had some evidence in line with that yesterday as well, and I'm just keen to understand your perspective on that particular component of your submission.
I think I don't have a lot to add, except that we in following up our engagement with the Australian Law Reform Commission, we did say that the qualified and cautious support for a limited range of altruistic surrogacy arrangements might actually be undermined by the legalisation of commercial surrogacy. It might kind of compromise the whole, even the limited possibilities. But in terms of your particular question, for example, I noticed the requirements we were suggesting, I think, were higher than, and I've only been able briefly to look at it, the New York regime that you mentioned. We would be only comfortable with a very high bar. I think that's as far as I can go.
And I guess, and I'm happy for anyone else on the panel to comment about this as well, but in, obviously altruistic surrogacy is legal in Australia and in New South Wales, but I guess would your views be that in the instances that does occur, there should be sort of clear and transparent information, particularly to the child, to know their circumstances? And there's a lot of nodding for the benefit of hindsight, but if you would all like to maybe make a comment about that, if you would so choose.
Short comment, because we make some statements on page 7 through 10 of our submission with regard...
I was going to come to you next, so it might be good timing, Mr. Rowe.
With regard to altruistic surrogacy, sort of working within the model, given it is legal, we were actually having a conversation about this beforehand with regards to the motivation truly being altruism, that's in the word of a giving act as opposed to an incentive-based act. And so I think with all of the different safeguards that we've outlined, it's with that in mind that we don't want to see a legislative creep towards commodification. We want to keep it truly based in that altruism or that giving. And that is also undergirded by the consistent revisiting of the best interests of the child and, of course, models which ensure that women aren't being exploited or coerced into being a surrogate into that arrangement. And so we have 9 eligibility criteria that we propose there across pages 7 and 8 around medical necessity, age and health, previous pregnancy. There's a number there that could go through. For the matter of time, I won't go through them all. Talk a little bit about clear legal protections for the surrogate, as well as post-birth parentage by court to ensure that the mother is actually willing to part with that child, as well as tightly controlled financial arrangements that if there's reimbursement with independent oversight to ensure that there's no abuse of that model financially to creep towards commercial. And we even mention just advertising and keeping that strictly low as well, so that it's not advertising women as a reproductive commodity in that regard as well. So it's all really focused on making it non-incentive based and being grounded in altruism, the virtue of altruism, as opposed to a commodification or an industry.
And just on the topic of parentage orders, which was what I was going to ask you about. So we've had evidence earlier today from people who have gone through surrogacy, both altruistic and also some who've taken the international path. And they gave sort of, I guess, counter evidence to yours, saying that they would have preferred a pre-birth order. And I just wondered if you wanted to, and again, happy for all of you or any of you to comment more broadly, but just keen to get your perspective, and it is touched on a bit in your submission, but why you think that it's important that those sort of parentage orders happen post-birth rather than pre-birth.
I think for us, principally, it comes down to something I said in the opening statement, which is the sacredness of the bond between the mother and the child, and the recognition that in that regard, the mum needs to have the opportunity to birth that child, and then to be able to sort of reconcile and come to the recognition of what it means to actually give up that child. And she shouldn't be under a contractual arrangement prior to that moment to give that child up. That would be how I see it, but I'm happy to hear from other people on the panel as to other reasons.
Any other comments?
I can understand why commissioning parents would prefer the certainty of having an outcome that is definite, but I think that for they are not the most vulnerable party in this situation, and that's why the protections ought to rest with the mother and the child. And to be sure that if she gives up the child, that it's freely of her own will, and that she, with all respect to the gentleman yesterday who was saying that he doesn't believe there's a bond between a mother and a child, I respectfully wonder how he can say that if he hasn't ever born a child himself. And women who have not born a child also cannot understand perhaps what happens in these processes. They're extraordinary. So I can understand why we might want to reduce it down for simplicity and for convenience and for certainty, because we value these things highly in our society. But much more important is to ensure that the sacred bond between women and children is preserved wherever possible, that protections go to the vulnerable, and in this case, that is the mother and the child in the arrangement.
Thank you. Any other? No? So it is Dr. Con's time, but she's had to duck away. So we might just have a little bit more from opposition. So I'll just see if Mrs. Carter has got any more.
I wanted to pick up the idea about does criminalisation or does prohibition of commercial surrogacy work? And I know enough to be dangerous about this, but I observed, for example, that Thailand, after they found their women were being exploited, said, no, we can't do this anymore, and retrospectively prohibited commercial surrogacy. I believe India has done the same. It's only available for citizens, residents. Do any of you have any more information than I do and can help us understand if there are jurisdictions which, having an experience of commercial surrogacy that they believe to be well regulated, then went no, this is not working for our women, we have to change our laws?
It's a very good question. I'm not sure whether anyone thought that they had good regulations before they changed their minds and decided that it was all going horribly wrong. But you're right to point to the pattern, which is that almost all of these countries that are open to commercial surrogacy very quickly realise that it's not working for them and that their women are being exploited.
Thank you.
And could I just make, it's a general observation rather than a specific response to your question, but I think this is part of the challenge of when we have technology, for in this instance, artificial reproductive technology. Because we can do things, we do it. And then we either can get down the track and look back and go, oh, I wish we hadn't done that. More often than not, we don't even have the opportunity to observe that perhaps we should have been asking these questions many years before. And technology, I think we like to think that we are the users of technology. I think technology in all sorts, but particularly in this context, very much shapes our own societal principles without us necessarily realising it, which again I think speaks to the importance of an inquiry like this, that we're asking the right questions now rather than down the track when we may end up like Thailand.
I wonder if I could go quickly to you, Dr. Simmons, and if you can help me. It builds on what Dr. Taylor was saying before. We have talked a lot about the idea of a surrogate mother giving informed consent. Something that troubles me is the way that over, let's say, a 10-month journey from fertility treatment to birth, a woman's consent processes may change. Is there any way that we can regulate for the fact that what one assumes is going to be one's position before one has experienced fertility treatment, pregnancy may change? Can we accommodate that in any sort of framework?
I am not a lawyer, but I would say that it would just intuitively, as someone who does look a lot at both the theory and practice of consent in medical contexts, that it would be quite difficult. And definitely this is something I think which is often missed in the discussion, that rather than consent from an ethical perspective at the start of pregnancy being satisfactory to underwrite a whole process of bearing another woman's child or another couple's child from gestation at the start to gestation at the end and delivery. I think rather than that being the case, what we need is ideally like consent along the way at multiple junctures, or at least an opportunity for women when their mindset may change to be able to renegotiate the terms of the contract. But I'm not sure whether you can make that work in the end, just given the fact that the couple or the individual who's commissioned the surrogate probably wants certainty that when they enter into the agreement and their child is implanted in the surrogate mother, that they're going to, in 9 months' time, have their baby handed to them after birth. And I'm not sure you can make that work. You can square the circle on that one. So that's a challenge.
I think that's my timing.
That is, so the remainder of time to the government members. So.
Okay, my colleague Emily Saval is there, I think, unless
yes,
she's
Mrs.
otherwise
Saval
ready.
is also online.
Emily?
No questions from me at this time. Thanks, Chair.
Okay, thank you. On the question of looking at what is, or could be argued to be, the complete domain of what could be seen as exploitation in the context of commercial surrogacy, trying to understand what that exploitation is. Those who are pursuing reform effectively say that, listen, it comes down to if you can create the right document and the content of the document which will regulate the practice, the issue of exploitation really effectively evaporates, because to the extent that exploitation is going on, and examples can be pointed to way overseas examples in, for example, say in Nigeria or in another country, say in Eastern Europe. That's because in that context of commercial surrogacy, there's just not the right contract that's being prepared and being enforced. So if you can get the right contract in place and enforce it, effectively the question of exploitation just goes away. I'm interested in any comments about whether or not you would accept that as an argument, or put the case that notwithstanding you might have a document that legally looks like quite a comprehensive document, and that, and I think this is a leap of faith, but let me say it anyway, that there is regulatory enforcement actually capable of being done. Are there broader issues of exploitation that goes to this issue of commercial surrogacy beyond being something that the contract has failed to cover? In other words, the issue of commercial surrogacy as a practice is fundamentally problematic.
I could start off, and I'm sure there'll be other remarks, but I mean, one thing I would note is that even in regulated commercial surrogacy jurisdictions, there have been abuses. So, for example, I'm quoting the UN Special Rapporteur on Violence Against Women in her report on surrogacy and other matters, which was released last year, and she said, for example, 2 prominent surrogacy attorneys were criminally convicted in a baby selling ring in California, a centre for international surrogacy arrangements. And these particular individuals were selling babies to overseas clients using the legal, I suppose, legal arrangements for surrogacy in California, but misusing them. And so I think that's just, I mean, that's something which ideally we can make our law work such that people don't use it. But I think potentially there might be this risk that if you did, even if you had the ideal legislation in an Australian jurisdiction, that it could be misused in ways that we don't anticipate. But I think your question really gets more to fundamental questions of exploitation that go beyond just circumstantial factors. And I would go back to the remark that was made by the panel earlier, that there is just something about introducing financials into the equation, commoditizing, commercializing women and their wombs, that is inherently exploitative. And I think that just from a philosophical point of view, it's true to say that finances, introducing money, has a coercive effect on freedom. I mean, it's just how it is. Like that if you tell someone, okay, if you do this thing for me, it may be uncomfortable, but I'll give you $1 million. Does that change your mind? And that's effectively, I think, what happens. So while you may have consent, you don't necessarily have autonomy, I suppose. You may have a thin consent, but you may not necessarily have a fully free choice from the woman if it's the case that you've got a high financial incentive for commercial surrogacy arrangements, which may get you consent, but doesn't necessarily, I think, mean that people are particularly happy about the arrangement.
I think that's helpful.
I would add too that notwithstanding a seemingly perfect contract, there are all types of circumstances where particularly the vulnerable party in the situation doesn't have the resources to enforce it or anything like that. So if it was to come to a dispute, we know many cases of in any type of sort of civil or commercial arrangement where a party just says, look, I know I've been wronged in these circumstances, but I just don't have the resources, the energy, the time, the emotional stability to fight it. And I think if you're having an arrangement that is inherently, you're recognising that there is a disparity in terms of bargaining power and things like that, and you're trying to fix that in a contract, the disparity also exists when it comes to enforcement. And so I wouldn't assume that even if you have a contract that is clear on its face, that somebody is then going to be able to have the wherewithal to go and get legal advice and pursue the enforcement of that contract through the courts. Plenty of times that doesn't happen for vulnerable parties, and I can't imagine why it would be different in these circumstances.
Thank you.
Just picking up on what I mentioned earlier to an earlier question, the introduction of commercial surrogacy by nature commodifies what is happening there, both for the mother or the mothers and the child or the children. And so those who are arguing, you know, if we've just got the right contract in place, then we can rule out exploitation. I would suggest a conveniently overlooking the question of whether actually just by nature of having a contract in the first place that is determining how this child is going to be born into this world and nurtured in this world overlooks the question of, is that by just principle an exploitation of that child that we're just ignoring as a matter of principle? We're going to focus on these other questions of potential exploitation and mitigate against those, but we're going to pretend that this one actually isn't a question in principle that we need to deal with. And, you know, I think we could see from all other areas of regulatory conduct that best interests are one thing. It's very, very hard to create a regulatory system that mitigates against the power of capital market, competitive self-interested capital market, people who are part of that market in terms of agencies and procurers, and also bad faith actors as well, who will always be able to find loopholes that are going to allow them to have their exploitative ways.
I'll just add a short comment, which is there's a presupposition of your hypothetical that we can have a perfect contract that will, you know, eliminate the problems. Presupposes that a contract can eliminate power imbalances between the woman who's being commissioned, the child in the situation who has no choice in the matter, and the commissioning parents. And I dispute that premise. I think that's not the case. We already know that there's a power imbalance in altruistic arrangements. It's not ideal, but there's nothing that you can really do to get rid of it, because we know that very often altruistic surrogates are junior members of families. There's emotional pressure put on them. Do they have free choice? Well, it's coerced by you know, means that are invisible, but obviously can't be legislated and certainly not controlled in terms of by contract law. So when you add in commercial incentives, then the potential for that power imbalance is just much greater. And so the idea that you can get rid of that by the right law or crafting things carefully, I think that's impossible. All you can do is minimise the harm, but in the same process you have multiplied the harm across more people, because obviously if you create a market for these services and you legislate it, there'll be more women who sign up to be surrogates. That's the whole point of these legislative changes. So in that process you've sort of magnified the problems across multiple women and children.
And perhaps just one final question if I could. We've had evidence across the course of yesterday and today which introduced a terminology that I'd not been well familiar with, and much clearer now, I have to say, after the evidence about compensated surrogacy, which has been emphatically emphasised as not commercial surrogacy. It's something that can be best explained in these terms, that altruistic surrogacy, as practiced in New South Wales, provides for the ability for the practice of surrogacy and the capacity to provide reimbursement for reasonable costs associated for the pregnancy and obviously the birth, but no payment on top of that. We're well familiar with the notion of commercial surrogacy, which has been around a long time, and I don't know where that was originally created, that terminology. Could have been in the United States, I don't know, but clearly it's the payment for a person to be, a woman to be a surrogate for the purposes of producing a baby. The way in which the compensated surrogacy was described in submissions earlier today is that it's, and this is my sort of explanation, it's like altruistic surrogacy in that there is reasonable expenses covered, but also there can be a payment on top of that. And in terms of don't have the actual submission here, but to cover things like emotional stress. I even used the word labour, L-A-B-O-U-R, which I thought was interesting, and other effects, that it's appropriate to pay, or would be appropriate in a new regime to pay something additional. And they went further to say that under their model, that there should be a government agency of sorts, or a regulator, which would set that fee above the reasonable expenses. Now, it seems to me that that payment above the reasonable expenses, in effect, is a commercial exchange, a payment. So, based on what I've described, would you agree that what's been described effectively is still commercial surrogacy, except the form of the payment and how that payment is calculated is different from, say, a market rate being set by negotiations? Or am I misunderstanding what's being proposed?
I think it's a smart lobbying strategy to call, something that's the same a different name, and then use that as a medium through which to pursue the same thing. But I mean, very clearly our concerns would be the same, and it's actually why we're so clear within our discussion around altruistic surrogacy about spelling out certain eligibility criteria, is because you get this creep towards commercial surrogacy, and I think compensated surrogacy is just a different name as a vehicle to move in that direction towards liberalisation, and it would be open to the same abuses, and in time it would evolve to be even, I think, more open to those abuses as you begin to monetise the reproductive process and children indeed.
Thank you.
I would think that what you're describing is a move from something that is objective, which is the repayment of expenses, to a subjective measure. And once you introduce a subjective measure for things like emotion, labour, things like that, then that line or the payment becomes arbitrary. And the arbitrariness of that payment then is what risks it, call it coming to commercial. So I think that you're moving from objective to subjective, which is where you get the move from altruistic to commercial.
I have heard this argument that commercial surrogacy or compensated surrogacy isn't necessarily not altruistic. The surrogate can have benevolent intentions towards the commissioning parents. I don't dispute that. Or that altruistic surrogacy can be not altruistic in terms of being coerced or the surrogate mother being pressured, and I also accept that argument. So there are grey areas there. However, there is a very clear distinction to be made between an arrangement that is financially incentivised and one that isn't. And this distinction was very clearly made in the 2016 Surrogacy Matters report, the federal government report, which defined commercial surrogacy and altruistic surrogacy. And I know that these new terms have been introduced in order to sort of blur those distinctions and say that maybe these aren't useful labels, maybe we ought to discard them, but regardless of the feelings in everybody's hearts at the moment that babies are handed over, there is a very clear objective distinction between one and the other, which is there's a financial incentive in one which increases the risk of exploitation and the pressure involved, and also the incentives for bad actors to monetise this situation, and the other one which is much less open to abuse. So I would say that that's a very clear distinction, and compensated surrogacy is a nice way of trying to blur that distinction, but I still refute the premise that financially compensated arrangements are not commercial in one sense or another. They certainly are.
Thank you.
Thank you very much.
Yeah, thank you. That does conclude our time with you this afternoon. But thank you very much to all of you for appearing, for your written submissions and for your evidence today. I don't think anything was taken on notice, but there might be supplementary questions that come from the committee members, in which case the Secretariat will be in touch with you. But thank you.
Thank you
And
very
that
much.
concludes the hearing for today as well.